I guess you know what comes across my mind. Murder. Just murder, murder.
A lot of ladies think he's attractive.
Very nice, very well spoken.
This is what I do with women, you know? I use my charm, use my good looks. I'm like a lion. You're the prey, I can sense it.
I stand here today to announce the indictment of Wade Wilson for the murders of Christine Melton and Diane Ruiz.
Both of them had been strangled. The last person that they encountered was Mr. Wade Wilson.
He said he got back in the car and ran her over until she looked like spaghetti.
I choked her out so she couldn't breathe anymore. I was on a rampage at this point.
He's still pulling the strings from a jail cell. He's got an army of wives. That's all he's ever wanted.
To advocate for someone because you think he's handsome.
A rage overcomes me. Just kill, kill, kill. When I get that way, I become the devil.
I'm gonna be honest with you, son. Everybody in the state thinks you're a monster.
True crime just got darker. Catch the full episode on the link above. Subscribe to At Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m. Subscribe to At Southern Sin and hit the bell for when we go live.
The reason why the state filed this motion is because, again, based on Mr. Cruz's proffer back on the 21st, we believe that he is referencing calls made to a number ending in 9554. So the motion is to exclude any evidence relating to 9554 because that wasn't her number. It's irrelevant, and it's also, out under 403. That would be the state's position.
Mr. Cruz?
They can proceed with their motion, Your Honor.
All right, go ahead, Mr. Bolden.
Thank you, Your Honor. Ms. Hall, can you raise your right hand, please, ma'am? Do you swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? Okay. And we're going to need you to kind of maybe pull that microphone a little bit closer to you and kind of, you don't have to speak directly into it, but
Okay.
enough so that everybody can hear you, okay?
Is that better?
Yes, absolutely. Could you please state your name for the record?
Ashley Hall.
And Ms. Hall, I'm not going to go into it too much in detail now, but how do you know, or how did you know Tara Baker?
We met in college. We were sorority sisters, roommates, and then we both came to Athens and were roommates.
Okay. I want to talk to you about some of the different places that you lived in Athens. Do you recall living in an apartment at Timothy Woods?
I do.
Who did you live with at Timothy Woods?
It was Kyle Collins and Karen Burford.
And do you know how to spell Karen's name?
I believe it is Karen.
Okay. And I just go ahead and get this out of the way. Is Miss Burford still alive?
No, unfortunately, she had a kayaking accident back in 2022.
So again, at Timothy Woods, it was you, Karen, and Kyle. Is that right?
Correct.
Okay. And did there come a time when you moved out of Timothy Woods?
Yes, it was, I guess, August 99. I ended up moving. I didn't realize Tara ended up getting her job at the law firm around that time, but I'd already signed over a lease. So she ended up moving in my spot at Timothy Woods with Kyle and Karen.
And again, that was in August of 99?
Yes.
Okay. And where did you move when you moved out of Timothy Woods?
Polo Club.
And who were your roommates at the Polo Club?
Valerie Lang and two girls that she went to high school with.
I'm going to kind of skip ahead about a year.
Mm-hmm.
In August of 2000, did you move again?
I did.
And where did you move that time? Mary?
We moved to Fawn Drive.
When you say we, who moved into Fawn?
Tara, Valerie Lang, and myself.
Tara, Valerie Lang, and yourself. Okay.
Yes, sir.
Do you recall around the time moving into 160 Fawn Drive, anything with Tara as it related to her getting a new phone number?
Yes. Karen was staying at Timothy Woods, and she wanted to keep the current phone number that they had shared because all of her contacts already had it. So when Tara moved, she went ahead and got her own line, which actually was even separate from Valerie and my line, just because with law school, she was on the internet a lot more.
Was that in the days of dial-up internet?
Yes, it definitely was. Yes.
Okay. Ms. Hall, do you remember in the days following Miss Baker's death talking to the police?
Many times, yes.
And at one time, do you recall the fact or I guess the existence of Tara's phone number at Fawn Drive coming into question?
Yes, I do.
Now, as you sit here now, 25 years later, are you able to recall off the top of your head exactly what that number
I do not. I cannot.
But at the time, would that have been a number that you would have known?
Yes, because I would have called her at different times to her actual phone number.
Was this in the days prior to cell phones?
Yes, yes. So if I was checking to see if she was at home or updates, I would have called her number. And so I had the number memorized back at that time.
And would you have had any reason to give the police an incorrect number as to what?
Not at all. I would have probably even double checked my memory to make sure.
Yeah, first, please, Sean.
May.
So I'm going to show you what I marked as State's Exhibit 1. Have you had a chance to look over that prior to testifying?
Yes, you sent me my statement.
And is that does part of State's Exhibit 1 summarize a conversation that you had with the police, I believe, on January the 22nd?
Yes.
2001? So
Yes.
would that have been 3 days after Tara's murder?
Yes.
And in that statement, did you provide Tara's landline phone number to the police?
I did.
And what was that number?
Tara's phone number was 706-316-9760.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
Ms. Hall, those are actually all the questions I have for you this morning. Thank you.
Mr. Cruz?
Good morning, Mrs. Hall. Thank you for
morning.
being here. I don't have questions.
You may step down.
Thank
You may call your next witness.
Oh, Jeremy Howell. Sir, if you could raise your right hand. Do you swear or affirm your testimony in the matter pending before the court should be the truth, the whole truth, and nothing but the truth, so help you God? Have a seat, sir. Could you state your name for the record?
Yes, my name is Jeremy Howell, Jeremy Howell.
How are you employed, sir?
I'm currently employed as a special agent with the Georgia Bureau of Investigation.
And what is your current role at the Georgia Bureau of Investigation?
I'm currently assigned to the Office of Special Investigations Cold Case Unit.
Agent Howell, in connection to the motion that we are arguing right now, did you have a chance to go back and look through some documents belonging to the deceased Tara Baker related to her residence and phone numbers in and around 1999, 2000, and 2001?
I did.
How did you come to be in possession of those documents?
On Monday, April 29th of 2004, about 9:30 in the morning, I met with Meredith Schroeder here in downtown Athens in order to collect a gray file box from her that contained numerous documents regarding Tara Baker.
I think you said 2004. Do you mean 2024?
I'm sorry, 2024, yes.
And what was your understanding as to where those documents had been located at the time of the crime?
That file box, to my understanding, was located at 160 Fawn Drive at the time of the incident.
So at Tara's house?
Yes.
What was the condition of the box itself?
It is slightly, it's got debris on it that may look like smoke damage and fire damage.
You may.
First of all, Agent Howell, put everything back in the envelope. All right. Agent Howell, I'm going to show you what I've marked as State's Exhibits 2 and 3. Do you recognize those?
I do.
And what are they?
It is an open envelope from Bell South, State's Exhibit number 2, and State's Exhibit number 3 is a communication, a letter from Bell South that was within that envelope.
Okay. So just to clarify, State's Exhibit 3 was inside of State's Exhibit 2.
Yes.
Maybe over. Agent Howell, were State's Exhibits 2 and 3 part of the documentation that you recovered from that soot-covered box from Miss Baker's sister?
Yes. Inside that file box were file tabs, and under a file tab that said Bell South is where this letter was located.
I move to tender States 2 and 3 at this time.
Any objection?
No objections, Your Honor, for the purposes of this hearing, as well as State's Exhibit 1 as well.
Thank you. You said they are admitted, 2 and 3.
I'm not going to focus too much on States 2. That's just the envelope, is that right?
Yes.
States Exhibit 3, again, just to make sure everybody's clear, what exactly is that?
It is a letter from Bell South. It is addressed to Tara Baker at 160 Fawn Drive in Athens, Georgia. And in the letterhead, it indicates that it's from Bell South Telecommunications, and it is dated August 1st of 2000. And underneath that is a phone number of 706-316-9760. The letter then continues with, "Dear Tara Baker, thank you for ordering Bell South Solutions and that they appreciate her business." And it continues from there about the account.
Agent Howell, those are all the questions I have for now. Thank you.
I don't have any questions for this witness.
You may step down, sir. You may call your next witness.
Call Agent Elizabeth Bigham. If you could raise your right hand. Do you swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can have a seat. Ma'am, if you could state your name and spell it for the record, please.
Elizabeth Bigham, Elizabeth Bigham.
And ma'am, how are you employed?
I'm employed as a special agent with the Georgia Bureau of Investigation.
And is that the GBI?
Yes.
I asked that because that's what I want to say.
Okay.
And what is your role at the GBI?
I am assigned to our Office of Special Investigations Cold Case Unit.
And as part of those, as part of your responsibilities on the cold case unit, have you and Agent Howell been responsible for the reinvestigation of the Tara Baker case?
Yes, we have.
And as part of your reinvestigation, did that include kind of a comprehensive review of the investigation from its origin back on January the 19th of 2001?
Yes, it did.
Does that include a review of files contained in the Athens Clark County Police Department's files?
Yes.
You may.
Agent Bingham, I'm going to show you what I marked as State's Exhibit 4. Do you recognize that document, ma'am?
I do.
And what is State's Exhibit 4?
It is a letter from Bell South Subpoena Compliance Center. It's dated February 2nd of 2001, and it is addressed to Investigator John Newton of the Athens Clarke County Sheriff's Office.
Is that document part of the Athens Clarke County Police Department's file that I just kind of described?
Yes, it is.
I move to tender State's Exhibit 4, Your Honor.
Any objections?
No objections for the purpose of this hearing, Your Honor.
All right, it is admitted.
Agent Bingham, I think that the thing that might make the most sense is just have you read that letter into the record.
Sure. I'll start with what it's in regard to. It says Tara Baker, telephone, or it actually says Tara Barker, telephone number 706-316-9760. Dear Investigator Newton, as we discussed telephonically, I ran 11 jobs today in an attempt to create call detail records for telephone number 706-316-9760 for January 16th, 2001 through January 19th, 2001. I have reviewed all 11 jobs and I did not find any incoming or outgoing calls for 706-316-9760. I have entered a request in our subcom system to search for call detail records for December 1st, 2000 through January 19th, 2000 for this, 2001 for this number. These records should be available on Monday morning. I found another number for Tara Barker, telephone number 706-559-9554. This number is found for Tara Barker, 2035 Timothy Road, Timothy Woods Apartments, Athens, Georgia. This number appears to be associated with the same Tara Barker that had telephone number 706-316-9760. Do you want to send a court order for call detail records on this number also? Please call me at 770-492-4561 to discuss further. Sincerely, Kathleen Mahoney.
And just, I think now's a good time to talk a little bit about Baker versus Barker. Can you
Yes.
that just very, very briefly?
Sure. Our understanding from the investigation and from her family was that her biological father's name was Barker, or last name was Barker. Her stepfather's last name was Baker, and she wanted to change her name to Baker and get rid of her biological father's last name. And I believe that was a year or so before her death, but I don't recall the exact date that she did that.
May.
Agent Bingham, I'm going to hand you what I marked as State's Exhibit 5 and State's Exhibit 6.
Okay.
Do you recognize those, ma'am?
I do.
Let's start with State's Exhibit 5. What is that?
So it is phone records for the 706-316-9760 phone number, which was the landline for Tara Baker. And the records appear to start on December 6th of 2000 and end on January 19th of 2001. And there's also a Bell South letter attached to it, an affidavit, and a copy of what appears to be a court order or subpoena for those records.
Any objection?
Not for the purposes of this hearing.
It is admitted.
Before we get into States 5, let's talk about State 6.
Okay.
Do you recognize that?
I do.
What is States Exhibit 6?
These are phone records for phone number 706-559-9554. And they begin on December 6th of 2000 and end on January 19th of 2001.
Any objection?
No objections for the purposes of this hearing.
All right, it is admitted.
Agent Bigham, in preparation for the hearing this morning, did you have a chance to personally go and review all the calls associated with both States Exhibit 5 and States Exhibit 6?
I did.
Let's start again with States Exhibit 5. And again, just to be clear, those are the phone records associated with the number ending in 9760. Is that correct?
That's correct.
In your preparation of your case, of this case, and in preparation in advance of particularly this hearing, have you been able to familiarize yourself with certain phone numbers that were, for lack of a better phrase, in Tara Baker's orbit?
Yes.
Would those phone numbers include the cell phone of Chris Melton?
I would object, Your Honor. I think we've had 4 leading questions in a row. I didn't want to interrupt them, but I'll just object on the grounds of leading.
All right, well, I mean, for the purpose of this hearing, there's no jury here, and I certainly know that both parties have the ability to ask questions a little bit differently than in front of a jury. But Mr. Bolden, if you would try to rephrase your questions appropriately with regard to direct examinations.
Certainly, Your Honor. Were you able, or did you familiarize yourself with certain phone numbers?
I did.
Whose phone numbers did you familiarize yourself with?
Primarily people that I believe she would have spoken to most often, to include her stepfather, Lindsay Baker. And he had 2 different cell phone numbers listed in the case file. Her mother, Virginia Baker, or their home line. Her boyfriend at the time, Chris Melton, and that would have included his cell phone, his parents' residence, and his apartment in Athens. Because my understanding was that he was between both his parents' residence and apartment in Athens around the time of her death.
And again, talking specifically about States Exhibit 5, do the numbers that you just referred to appear in those records?
Yes, they do.
Can you talk about that in a little bit more detail?
Sure. So I went through the records and looked for each phone number and found the following information. So Lindsay Baker's cell phone ending in 8423 appeared twice over just over a month and a couple weeks of records. Chris Melton's apartment.
Yes.
Relevance. I understand the purpose of this hearing is just to determine whether or not the 9554 number is Ms. Baker's home phone number or not.
Mr. Bolden, any response to the objection?
I think that the calls that are coming to and from the 970 number are absolutely relevant to show that the 9554 number was not her actual phone.
I'm going to overrule the objection. You may continue.
So Chris Melton's apartment phone number, which would have been his apartment landline in Athens, either received calls or called that number 37 times. Miss Baker's home phone, where her parents resided, was 1 time. Lindsay Baker's other cell phone, ending in 0598, was 2 times. Chris Melton's cell phone received calls or made calls 5 times to that number, and Chris Melton's parents' home phone number appeared 29 times in those records.
Let's shift to States Exhibit 6. And again, just to be clear, what is States Exhibit 6?
It is the phone records for phone number 706-559-9554 that was associated with 2035 Timothy Road in Athens, Georgia.
Did you have an opportunity to scan States Exhibit 6 for the same phone numbers that you just referred to a moment ago?
I did.
And what, if anything, did you find in the records relating to State's Exhibit 6?
That none of those phone numbers appeared in those records from the same time period.
Agent Bingham, I believe that's all I have for now. Mr. Cruz may have some questions, ma'am.
Mr. Cruz.
Yes, ma'am. Agent Bigham, as the lead investigator in this case, did you review Ms. Baker's entire case file?
I did.
Every document?
As much as humanly possible for the probably 25,000 pages that it was.
That's my only question for you. Thank you.
Anything else, Mr. Bolden?
No, Your Honor, I asked that she be excused.
You may step down. You don't want her excused. You want her to step down.
Step down. Right. Excuse this here. Yes.
You may step down. You may call your next witness.
That's all the evidence.
All right. Mr. Cruz, any evidence you want to present?
No, ma'am, but I would like to emphasize for the record, Ms. Bingham's testimony that she's reviewed every single page of the discovery. And I just want to emphasize that for the record, but otherwise, no.
Any concluding remarks, Mr. Bolden?
I'd waive opening
All right.
remarks or last word.
Mr. Cruz, any response to the state's motion?
So based on the evidence that the state presented, Your Honor, I don't believe I am in a position to dispute the evidence that came before the honorable court. So no concluding argument.
Well, that makes it a lot shorter, Your Honor. I'd ask that the court grant the state's motion and exclude any evidence related to phone records associated with the number ending in 9554.
I'm going to grant your motion.
Thank you, Your Honor.
All right, let's talk very briefly then about a few other matters before we handle the email that I sent both counsel, all three counsel, over the weekend. Have the parties been able to confer about the motion that Mr. Cruz filed with regard to the statement?
We have not, Judge.
Well, let me ask this question. Are you familiar with what Mr. Cruz has filed a motion to keep out of that particular statement?
I am, Judge. At the initial portion of the interview, Agent Bigham and Agent Howell talked with Mr. Faust about previous criminal contact that he's had and things along those lines. I think I can state for the court, Mr. Bolden will be giving the state's opening statement. Mr. Bolden, I believe, would refer to portions of the statement, but just portions that have to do with Mr. Faust's denial of ever. I just want to make sure I wasn't in perspective here. Mr. Faust's denial of ever having had any type of contact with Ms. Baker or gone over into any residences in the Deer Park neighborhood or things along those lines. We would not be attempting to introduce any evidence related or make reference to any portion of the statement that would touch on Mr. Faust's previous criminal history or conduct.
All right, Mr. Cruz, any response to what Mr. Young actually said about that particular issue?
Sure. So for those particular facts, I believe they would be admissible in regards to Mr. Faust's statements in response to Ms. Bigham's question about Ms. Baker and himself. But I would ask the Honorable Court to rule. I provide the Honorable Court with a copy of the transcript as well, the timestamps as well. But we would ask that those particular timestamps are excluded.
Okay, so let's talk about your motion. So the reason I wanted counsel to get together, and I know you all have been busy, so I'm assuming you may have a conversation in the near future, was because your motion, even though it had the timestamps, was not terribly specific. And so it isn't appropriate to make the court go look in the transcript for the moment that you wanted excluded. You needed to have provided that for the court. And so that was the first reason why it's not just the transcript. It is not appropriate for the court to have to read through the transcript and do that.
So you don't have an entire transcript. You only have the time site. So if it says minute mark, hypothetically 00 through 005, the transcript would say what that language is in 00 through 005. It isn't anything extra that the court would have to read. You would just go to the timestamp, say, okay, this is the statement, and vice versa.
Okay, well, I disagree with your assessment of your motion. Your motion was a series of timestamps, and it may have had a transcript attached to it, but it is not appropriate for the court to have to go look at the transcript and your timestamp and make a decision about what one looks like with regard to the other. That's for you to do. And so that was the first reason that I wanted counsel to get together and talk about the timestamps that you felt needed to be excluded. I figured the state was aware of some of those moments. Certainly, I imagined them to be the occasions that Mr. Faust may have talked about his criminal history in response to questions. I assumed that was part of what your motion was. But the court's not going to go through the timestamps. You need to provide that to the court unless you all can agree otherwise. So in the meantime, I'm going to certainly take you at your word, Mr. Yalamanchili, that you are not going to refer to any of those moments in your opening statement. And I will grant Mr. Faust's motion with regard to that. Hang on one second. Keep dropping my pen. I will grant Mr. Cruz's motion with regard to any mention of Mr. Cruz's criminal history with regard to opening statements, okay? But I want you all to at least talk about what Mr. Cruz's motion was so you can at least be on the same page. If I need to make a ruling, we'll have a motion, right? A motion hearing outside the presence of the jury. So at the moment, you are forbidden, even though you've already stated this, from mentioning anything about Mr. Cruz's criminal history, even though it may have been in the statement. So that's the first thing. All right.
Your Honor, before we move to the next item,
yes.
In regards to and I know the state has been extremely busy. We've been extremely busy as well. Based on our following of the motion, I understand that we may need time for hearing on those timestamps if same becomes necessary.
That's right.
There are a couple of things that the state and I need to discuss that we just haven't had opportunity to discuss just based on the workload that we both have. So I would ask this, can we put a date or time certain for a motions hearing, which would at least give us a deadline to have that discussion? And if not, we could just present the evidence to the honorable court.
I don't know that we can do that. We've got a jury waiting outside. We're ready to start opening statements. I don't know how fast the evidence is going to proceed. So you're just going to have to use your lunch break and get together and talk about it.
No, Your Honor, I'm asking for a date certain.
I mean, we'll have a motion whenever I can fit it in. I'd like for y'all to confer first if you can. If you can't, and you can't come to an agreement, certainly I'll have a hearing. But I mean, be prepared at every moment to have a hearing in this case.
Yes,
I'm not going to sort of schedule things ahead of time and things of that nature. We're going to take up things as they come. So y'all need to be prepared for everything. All right. Yes.
If I may, Your Honor.
Yes.
We talked about WebEx. I've had several law enforcement officers reach out to me. I think even this morning I spoke to a law enforcement officer that inquired about appearing virtually. I told her I would bring it up with honorable court today. Is there a way that we could get a WebEx link to send out to those officers that are far away? I believe we have a Mr. Michael Moon whose father just passed away. And instead of him traveling back here once it's our case in chief, I would just like to provide him a link so you can take it.
Yes, that is actually fairly easy to do. It needs to be done more in concert with when you're going to present that evidence so we can send out the link, but we'll work with you on that.
Yes, ma'am.
Yeah. All right, thank you. All right, so I'm looking through the list of things that we have gone through for the past week and a half. With regard to motions in limine, I've just granted the state's motion this morning. With regard to the telephone numbers that the state asked the court to exclude, which I have granted. I have granted the state's motion in limine for no mention of consent by the defense, no mention of anyone else committing the crime other than what has been previously ruled admissible, no mention of the legal punishment or sentencing or what the statute requires during opening or closing with regard to any of the charges. I am going to invoke the rule of sequestration. We're going to have to handle the Daubert motions and maybe a Jackson-Deno issue. Let me ask the state first. Anything else we need to bring up before we get started?
Briefly, Your Honor, we're filing in court this morning a motion to prevent publication of crime scene or autopsy images of the victim. Providing a copy to Mr. Cruz. It is not a terribly long motion. I mean, the title contains everything that the state is asking the court to do. We would ask the court, understandably, that there's media present, but as part of the Rule 22 order to include a portion that would prevent any outlet or any individual who's in the courtroom from publishing any crime scene images or autopsy images that contain this terror victim in this matter.
All right, thank you. Mr. Cruz, any comment on the motion?
No, ma'am, no comments on the motion. The only thing I would ask, I've been receiving a lot of day before, same day motions. I would just ask the honorable court to advise the state to provide motions within a statutorily required timeline so we could address those motions. But for this one, no, ma'am.
Thank you. The media is actually here, and I know that the media is pooled because that was what the order required. I know that's what the media typically does. Does anyone who is here from any media source want to comment on the motion? You have the right to do that. Anybody want to have a say in what they're asking? Does anybody who is here from the media have any problem with that particular motion? I see all heads saying no. All right, thank you very much. I'm going to grant your motion, Mr. Yamaguchi.
Thank you, Your Honor.
All right, let's talk about the email that I sent you all. Let's talk about the email that I sent you all. And it was the email that I received on Saturday evening directly from one of our jurors. And let me just find it. Expressing her desire to be relieved from her jury duty service. Does the state want to be heard with regard to that motion? And I have her outside. I asked her to report at 9:30. We're running a little bit behind, but.
Your Honor, I think all the issues raised by the juror are issues that came up with many jurors during the course of the voir dire process. I think counsel for the state, counsel for the defense had an opportunity to question the juror about those things, establish that it would not affect her impartiality, and then either side struck her either for cause or using a peremptory strike. So at this point, I don't know that anything raised in the email that was sent to the court would rise to the level of excusing this juror for service. The state doesn't believe any further inquiry is necessarily needed, but certainly if the court wanted inquiry to be made, our request would be that the court handles the inquiry, not counsel for the state or counsel for the defense, since the voir dire portion has been completed.
Thank you. Mr. Cruz.
In regards to the email that she sent in the language, Your Honor, of course, it is not a lawful reason to excuse the juror, but I do believe that the juror is expressing that sitting on the jury panel for the time that she is, that this case may last would cause her a hardship financially. My concern, and of course it's up to the honorable court's discretion. My concern is that we're in the middle of the trial, we get going, and what I've seen from multiple trials is, the juror's all of a sudden sick, we can't move forward with the case. If this is causing a hardship for her, I would ask the honorable court to consider that. I am unopposed to her request, just considering how long this trial may last and to prevent disruptions of the proceedings.
Thank you. All right, let's talk about how long this trial will last. Let's talk about that for a minute. So we have been discussing the case for a long time, and both parties have known that the court set aside 2 weeks for this trial. And it really hasn't been until very recently that there has been discussion about the case lasting 4 to 6 weeks. I do not believe, based on the motions that I've heard and the evidence that both sides have presented, that this is a case that's going to last that long. I do not believe it. And I'm going to do everything in my power to make sure that we move as efficiently as possible. I'm going to tell the jury that we are not going to waste their time. If we need to get here at 7 and do motions or stay till 10 o'clock at night to finish, we're going to have to do that. But I do not believe this case is going to last as long as has been described for the jury. I think it's pretty clear that the potential jurors were quite scared about the length of time that they may have to sit. It could last as long as 6 weeks, but based on my assessment of what I know of the case, I do not believe we're going to get anywhere close to that. I'm prepared to tell the jury that. Again, I'm prepared to tell them that we are going to move as efficiently as possible. I'm not wasting any time. And I will try to explain that to Miss, I think her name is Cameron. All right, I will bring her in here, and I'm going to ask the media not to film this particular juror. Thank you very much. And I'm going to have her come up to the bench. I'll have counsel join me at the bench. Yes, sir.
I would object to that instruction to the jury. And the reason why, Your Honor, is
I'm not giving an instruction to the jury, Mr. Cruz.
But you mentioned that you were going to say that, excuse me, well, to Ms. Cameron. And the reason why is because the state presents their case first. That won't be a limitation on their case. The limitation would simply be on ours.
Mr. Cruz, you're misinterpreting what I'm saying.
Well, please.
You're absolutely misinterpreting it. I'm not giving a limitation on any party. I'm just saying to both parties that I have heard many motions in this case. I have seen and heard a lot of evidence that both counsel have presented, and I do not believe this case is going to take from 4 to 6 weeks. If it does, it does. I am not limiting either party, so you misunderstood me, and I'm not instructing the jury about anything regarding that. I'm simply going to tell them that we are going to progress as efficiently as possible, and we'll do whatever we can not to waste their time. All right, thank you. Could you bring in that juror, just the one juror that I asked to report at 9:30? Thank you. And, hold on just a minute.
Now, ladies
make sure that everyone in here, and I'm really speaking to the audience, of course, has their cell phones put away and that they're on silent or something like that. And I want to make sure that everyone who is here in the audience knows that there is to be no recording, no photographing or anything unless you've been granted permission by the court for Rule 22. Those of you who have know who you are, and I appreciate your cooperation. It's been great. But everybody else who is here who has not been granted a Rule 22 permission, you have to put your cell phones away. I just want to make that very clear. All right. Now, if there's nothing else, counsel, I'm going to bring the jury up. All right. Thank you. You can bring them all up. You all may be seated. Everyone is standing for you, but you all may be seated. Thank you. All right, counsel and everyone else, you may be seated. Thank you. Welcome back, ladies and gentlemen. We are about ready to begin the trial of the State of Georgia versus Edrick Faust, SU 24 CR 0547. I'm going to administer that oath that I told you about on Friday. So I am actually going to ask you all to rise, please, and raise your right hands. And when I'm finished with the oath, if you would please respond by saying I do. If you'll all please rise. Thank you. You shall well and truly try each case submitted to you during the present term, and a true verdict give, according to the law is given you in charge, and the opinion you entertain of the evidence produced to you, to the best of your skill and knowledge, without favor or affection to either party, provided you are not discharged from the consideration of the case submitted. You shall well and truly try the issue formed upon this bill of indictment between the state of Georgia and Edrick Lamont Faust, who is charged with malice murder, felony murder, felony murder, felony murder, felony murder, burglary, aggravated sodomy, rape, aggravated assault, aggravated sodomy, arson in the first degree, and possession of a knife during commission of a felony, and a true verdict give according to the evidence. So help you God, or upon your affirmation, please respond by saying I do.
I do.
Thank you. You all may be seated. And ladies and gentlemen, everybody tends to sit in the same seat when they come back out from the jury room, but you all can sit wherever you choose so that you don't have assigned seats. If anybody is having difficulty hearing, please raise your hand, let us know. If anyone needs a break for any reason, please raise your hand and let us know. Is the state ready with regard to State of Georgia versus Edrick Lamont Faust, SU 24 CR 0547?
State's ready, Judge.
Is the defense ready?
Yes, ma'am.
All right, thank you. Ladies and gentlemen, you are now going to hear opening statements. And opening statements are exactly what they sound like. They are the opening remarks of the attorneys, where it is their opportunity to tell you what they believe the evidence is going to show you. I'm going to caution you now, and I'm going to caution you at the end of the trial, that anything said by the attorneys, whether it's the opening statements or the closing statements or arguments by the attorneys, are not to be considered as evidence. Mr. Yelmanchili, you have the floor. Or Mr. Bolden.
Thank you, Your Honor.
Yes.
We tested this earlier. My screen should be showing.
I don't know. Is that what you're looking for? Very good. You may proceed, sir.
Just going to start my stopwatch. Who killed Tara Baker? Obviously, by now, ladies and gentlemen, you know that's what this case is about. But before we get to know who killed Tara, it's important to know a little bit more about her. Tara Louise Baker was a bright, young, 23-year-old from Lovejoy, Georgia. And when she woke up on the morning of January the 19th, 2001, she had her whole life in front of her. She was a first-year law student here at the University of Georgia, and she had a wonderful circle of family and friends. Ladies and gentlemen, the next day, Saturday, January the 20th, it actually would have been her 24th birthday. And in the early morning hours of January the 19th, 2001, Tara's promising future came to a violent and abrupt end. She was sexually assaulted. She was stabbed. She was strangled. And she was left for dead on her bedroom floor. Her bed was set on fire. A fire, ladies and gentlemen, that smoldered for a considerable amount of time before it finally erupted through the roof of the house that she shared with two friends at 160 Fawn Drive here in Athens, Clark County. On that morning, Tara's life ended. And what started was a 2.5 decade long saga that has hung over the Baker family and hung over this entire Athens community like a specter. Ladies and gentlemen, this trial represents the final chapter in that tragic saga. The chapter where the state will prove to you beyond a reasonable doubt that the defendant, Edrick Faust, is guilty of extinguishing the bright light that was Tara Louise Baker 25 years ago, where the state will show that he is guilty as charged of the crimes in this indictment. So you've heard the indictment a few times by now. Judge Lott read it in its entirety at the beginning of jury selection. The judge also just went briefly over what the charges are again here this morning. I'm not going to spend too much time going through the indictment itself right now. There will be a time and a place for that at the end of the trial. But again, ladies and gentlemen, you know now that the defendant, Mr. Faust, is charged with 12 counts. Count 1, malice murder. Counts 2 through 5, felony murder. Count 6, burglary. Count 7, aggravated sodomy. Count 8, rape. Count 9, aggravated assault. Count 10, aggravated sodomy. Count 11, arson in the first degree. And count 12, possession of a knife during the commission of a felony. All those charges stem from the morning of January the 19th, 2001. And I expect that that's going to become clear over the course of this trial. Ladies and gentlemen, these are obviously heinous crimes. And in order to prove them, and to prove that the defendant is the person who committed them, the state is going to have to present some very grisly evidence. And that's going to come in the form of both testimony and photos. Ladies and gentlemen, some of this trial is going to be difficult. But it's unfortunate, but it's necessary. I just wanted to give you a heads up. On January the 19th of 2001 at 11:22 a.m., Athens 911 started receiving telephone calls in the area of Deer Park regarding a fire at 160 Fawn Drive. Now, if you're not familiar with Deer Park, just to give you a little bit of reference, if we head, make sure I've got my orientation right, down Lexington Road, away from downtown, heading out towards Oglethorpe County. When you get past, Gaines School, Tuxton United Methodist Church is there on the left, right off Lexington. And the road immediately past Tuxton United Methodist Church, before you get to the Walmart, is Cooper Road. So again, heading that direction from downtown, left on Cooper Road, past the church. And then actually Deer Park, which is where Fawn Drive is located, is just on the right. And so when they get this call at 11:22 in the morning, the fire department is immediately en route. The firefighters actually kick in the door, the front door to Tara's house because it was locked. And when they did so, they encountered smoke in the main living room area of the house. And I'm gonna, in just a few minutes, not yet, gonna be able to show you what the inside of that house looked like. So these firefighters kick in the door, and the first thing that they notice, apart from the smoke, is back in the right corner, which is where the kitchen is located. Through the smoke, they can actually see the eyes of the stove. It's one of those old school stoves that has the circular heating element. They can see those glowing red. And so through the smoke, they go over there to the stove. They realize that the knobs that would turn on and off those eyes have actually been removed from the stove itself. And so the firefighters put those knobs back on and turn the stove off. They open the back door to the house to ventilate, to help start getting the smoke out of the room. To this point, I don't think they've completely ascertained exactly where the fire was coming from. The back left bedroom of the house, and there's actually a bathroom door right next to it, it'll make sense in a few minutes, are closed. And so they go over there and they kick those doors in as well. And when they kick open that bedroom door, they are immediately met with flames rushing out over their heads. Firefighters enter and extinguish that fire. And in that moment, ladies and gentlemen, they discover Tara. She's naked. She's in between the mattress and the footboard to her bed. The footboard had been ripped away from the bed frame itself. So she's in that little V-shaped space in between. They notice a computer cord, what appears to be a computer cord, is wrapped around her neck. And so realizing what they've seen, the firefighters back out and turn the scene over to the police. And law enforcement does arrive. And so what we have here, ladies and gentlemen, is a sketch made by Athens Clark County Police as to the interior of 160 Fawn Drive. I won't spend but a couple minutes going over it. The front door here is at the bottom with the arrow pointing up. Again, you see the kitchen in the back right with the stove, which is what the firefighters reported seeing glowing red when they came in the door. And what I want to focus on is what's in the top left of that diagram, what is referred to as bedroom 3. That was Tara's room. And you can see bedroom 3 has a bathroom connected to it, and then there's a door leading both from the bathroom, a door leading to the living room, and one leading into Tara's room. So that's the basic layout of 160 Fawn Drive. You can see there's a back door, which again has the arrow pointing down. And right next to that is a window that is situated right above their dining room table. You're going to see photos that will also help kind of explain the layout of 160 Fawn Drive. So that's the house as a whole. And this is Tara's room as the police encounter it. And again, I've tried to explain, but I think this does a better job showing exactly the orientation of her body inside that bedroom in the back left of 160 Fawn Drive. So again, you can see the footboard having been ripped away from the frame and her body lying in between. So upon arrival, Athens Clarke County Police starts processing the scene. I expect you're going to hear from a number of witnesses that Tara's body, despite having obviously been in a room that was consumed by fire, her hair was actually still intact. I expect you're going to hear that several witnesses actually recall the smell of shampoo still coming from her hair. Again, there was a printer cord wrapped around her neck. I believe the printer itself was there in the room. And there's one thing that the police noticed that firefighters hadn't, was that Tara actually had a stab wound to the right side of her neck. And I think it was on the diagram. The knife was right underneath her body with blood on it. Officers also noticed a clock on the wall in Tara's room. That clock had stopped at 9:32. In processing the scene, officers noted that it appeared as if the doors and windows had been wiped clean. There's a screen to the back, that back window, the one that's right next to the back door, that showed signs of having been tampered with. Now, I expect there's probably going to be some confusion about exactly where that screen was when the firefighters arrived and when law enforcement arrived, but we'll get to that. Ladies and gentlemen, at 160 Fawn Drive, I submit that the evidence is going to show that any physical evidence that could have conceivably been helpful was collected. As an example, I think you're going to hear they even took the drain assembly out of her bathtub. A little bit more about the fire. I expect you're going to hear evidence that the bed, Tara's bed, was the source of that fire. And a little bit more, actually, I expect you're going to hear that there was a blanket that had been in the living room on the back of a recliner. That blanket had been removed from the recliner, taken over to the stove, set on fire, and then thrown on Tara's bed. I expect you're going to hear that there's actually still some remnants of that blanket on the stove itself. In learning about the processing of the scene, I expect you're also going to hear that there were no fingerprints of any evidentiary value that were taken in the house or off of Tara's body. I expect you're going to hear that hairs were collected from her body and from her room. And I also expect you're going to hear that her laptop was missing. The next thing I want to talk a little bit about, ladies and gentlemen, is the canvas of the neighborhood. By canvas, I mean police getting out and knocking on doors and seeing what, if anything, people had seen that morning. That was obviously done in this case to a significant degree. I expect you'll hear one witness recalled seeing a white male running in the area, open area behind Tara's house and near Tara's house around 7:45 that morning. I expect you're going to hear multiple witnesses talk about describing a black male with an orange shirt or sweatshirt at various places in Deer Park around 8 o'clock to 8:15 that morning. I expect you're going to hear one witness who described smelling a faint odor of smoke as he was leaving for work around 8:40, 8:45 that morning. At the time, ladies and gentlemen, there's just not much to go on as it related to that canvas. The next thing I'd like to talk about is the autopsy. Tara's body was taken over to Atlanta to the Georgia Bureau of Investigation's Department of Forensic Sciences the next day, Saturday the 20th, her birthday. And an autopsy was conducted by a medical examiner named Dr. Edrick Faust. And here's where the evidence I submit maybe get kind of difficult. There were photos that were taken at that autopsy. And you're going to see some of those photos when Dr. Faust testifies. It's going to be hard. You're going to see and hear about contusions surrounding Tara's vagina and anus. You're going to hear that stab wound that the officers noted when they got in to her bedroom had actually severed her jugular vein. You're going to hear about the ligature mark that was encircling her neck, and that her hyoid bone, which is a bone in your neck, had been broken. You'll hear about a subarachnoid hemorrhage to her head, which is indicative of blunt force trauma. You're going to hear about defensive wounds, defensive type wounds to her hands. Dr. Faust, after conducting the autopsy of Tara Baker, listed her cause of death as ligature strangulation and a stab wound, with another significant condition being blunt force trauma to the head. He ruled the manner of death, obviously, a homicide. As part of the autopsy, a sexual assault kit was taken based on the way Tara's body was found, based on Dr. Faust's observations. So a sexual assault kit involved oral, vaginal, and rectal swabs of Tara and smears that were created based on those swabs. And I expect over the course of this trial, there's going to be a great deal made about how one of those swabs was mislabeled. I expect the state's going to be able to clear that up as this trial unfolds. As part of the autopsy, head hair and pubic hair was retained, and fingernail and toenail clippings were taken. The next thing of significance that I'd like to talk about is some of the early forensics that were done in connection with this case. You're going to hear from Jennifer Corsi. At the time, back in 2001, Ms. Corsi was a forensic biologist at the GBI Crime Lab. She actually now works at the U.S. Army's Criminal Investigation Laboratory. She made a career out of this type of work. Ms. Corsi is the one who actually did chemical testing on that sexual assault kit, the one that we just talked about. You'll hear that her testing failed to reveal the presence of any seminal fluid, and that she took microscopic examinations of the vaginal smears and observed no spermatozoa or partially intact spermatozoa. And so, ladies and gentlemen, based on the existing technology and the existing protocols in existence back in 2001, there was nothing further that could be done with that sexual assault kit. I expect you'll hear that Ms. Corsi, then Fincher, so if I use both names, please forgive me, did confirm that the blood on Tara's fingernails, the only DNA in that on those fingernails belonged to Tara, that there was blood on the knife, and the DNA from that blood also only belonged to Tara. And there was no blood on the toenails that were taken. Not necessarily Ms. Corsi, but other forensics going on in the early days of the investigation. There were attempts to obtain fingerprints of any sort of evidentiary value, nothing to go on. I mentioned the hairs. Submit to you there was nothing that would help in the investigation at that time. I'm going to shift gears a little bit and talk a little bit more about Tara. In January of 2001, again, she's living at 160 Fawn Drive. She had two roommates, Ashley Peavy, now Ashley Hall, Valerie Lowe, now Valerie Lang. And I say that because, again, I might refer to them as both. Just wanted to get out in front and explain why that might be the case. So the three of them, Tara, Ashley, and Valerie, had moved into 160 Fawn Drive in August of 2000. All three of them were in grad school at UGA, but pursuing different programs. You know, Tara obviously was studying law. I expect you're going to hear evidence about Tara's morning routine. If she had a 9:30 class, which I expect you're going to hear she did that Friday, property law class on the 19th, then she was a pretty early riser. Up around 6:30 in the morning. First thing she'd do is take a shower. Expect you'll hear she'd come out and eat her breakfast. Every morning, same thing, cheese grits. And she'd come out and eat those cheese grits, her hair's still wet. And then she'd go back into her room and sit on the floor in front of her bed to blow dry her hair. And that took a while, ladies and gentlemen, because I expect you're going to hear Tara had a lot of hair. I expect you're also going to hear about how Tara was trying to buckle down in January of 2001. As that new semester at the law school had gotten underway, she was spending less time at home and more time at the law library. But Saturday was her birthday. And on Friday night, she was going to go out and have some fun with some friends. They were going to go to the Winery, which is a bar downtown on Broad Street. I don't know if it's still there, but it was in 2001. But talk about Tara's last hours. Go through what we know about Tara on Thursday, January the 18th. We know that both Ashley and Valerie were leaving for the weekend. They were both leaving that Thursday. Ashley left late that afternoon. She and Tara had been at home together before Ashley left. We know that from approximately 7:30 to approximately 9:30, Tara was at the law library here on North Campus, not too far from the Arch. She's there with a friend named Katie Lonstein. Around 9:30 that night, Katie leaves, goes home. I think there was a discussion about, hey, call me when you get there, make sure you get home safe. And Katie indicated that she would do that, but she forgot. Why is that significant? Because Tara called her. Tara called her at 9:46 that night to make sure Katie had gotten home. And ladies and gentlemen, that is the last time that anyone is known to have spoken to Tara. Friday, again, January the 19th. I think it was kind of a cold, overcast, rainy day, the kind of day that it seems like we've been having a lot of those lately. Again, expect you're going to hear evidence that the neighbor across the street smelled smoke, around 8:45, 8:45 as he was going to work. Point out once again, Tara misses a property class. It started at 9:30 that morning. The clock on the wall stopped at 9:32. And then again, ladies and gentlemen, 11:22 is when the fire is reported at 160 Fawn Drive. I'm going to talk a little bit now about Chris Melton. Some of you have heard his name already in jury selection. Chris Melton was Tara's boyfriend. You're going to hear a lot about the relationship between Tara and Chris leading up to January the 19th of 2001. What I expect that you're going to hear is this was a relatively typical relationship between two very busy people in their early 20s. Tara and Chris met when they both attended college at Georgia College in Milledgeville. It's now Georgia College and State University in the late 90s. Tara and Chris were introduced through mutual acquaintances and hit it off, and they began to date. When Tara graduated from Georgia College, she went back home to the Lovejoy area. And for those of you who don't know, Lovejoy is off of I-75 south of Atlanta. And she got a job at a law firm there. Chris didn't finish school. He also moved back home in with his parents as well. That's in Covington. When Chris moved home, his mom told him he had to get a job. And so he got one. Chris became a plumber. And so at this time, Tara and Chris are in a long distance relationship because Covington, Lovejoy, about an hour and a half apart, maybe a little bit less. Tara moved to Athens, I believe in 1999, when she got a job at a law firm here in town. So at that time, Tara's in Athens, Chris is still in Covington, and so they're still kind of doing the long distance thing, right? Maybe not quite as long, but certainly not in the same town. And they found it hard to find time to get together. And so Chris moved to Athens. He got an apartment with a roommate at a place off of Millage Avenue. And he was commuting back and forth to work. Most of his work was in the Loganville, Gwinnett County area. But I expect what you're going to hear is that Chris and Tara were trying to figure out how to have an adult relationship when they both had a work life and other things going on that they had to manage. As I mentioned before, Tara started law school in August of 2000. I expect you're going to hear that during that fall semester, that first semester, Ashley and Valerie are going to mention to you that Tara was spending a lot of time at Chris's apartment. Now, that doesn't mean Chris wouldn't come over to her house too. He did, maybe just not as often. But when they did, they'd spend the night at each other's house, both at Millage Avenue and at Fawn Drive. This is normal relationship stuff. Moving into the spring semester, January 2001. Now remember, Tara was trying to buckle down. More time in the library. Well, at that time, Chris also had good things going on. I mentioned that he had taken up plumbing. He was working for a company, but around this time, he started maybe thinking about going out and doing work on his own. You know, his business was mainly in the Loganville, Gwinnett area. And so at this time, you know, he's using his truck, not a company one. It's his gas, his time spent commuting. And if he's traveling back and forth from Athens to Loganville every day, he's not making money. And the reason why I point all that out, ladies and gentlemen, because I expect the evidence is going to show that at that time, Chris moved back in with his parents in Covington. So he could spend more time working and less time traveling to and from. Now, ladies and gentlemen, I expect that others might have thought that the relationship between Chris and Tara was starting to fizzle. Again, I think the evidence is going to show that this was just a relationship between two young people whose presence and whose futures were still being figured out, with some highs and some lows, but nothing out of the ordinary. In fact, I expect you're going to hear that Chris had gotten Tara a very sentimental Christmas present just a few weeks prior to her death, and it made her really happy. He was going to come to Athens Saturday to celebrate Tara's birthday with her. Chris saw the potential for a future between them. Others may have made assumptions otherwise. But the bottom line, ladies and gentlemen, is the evidence will show you that there is nothing to suggest their relationship was in a bad place. Let's talk about what Chris was doing on January the 19th of 2001. As I just got done explaining, he spent the night before Thursday night into Friday at his parents' house in Covington. And from 7:15 that morning until long after Tara's body is discovered, his whereabouts are accounted for. At 7:15 or thereabouts, a coworker named Josh McCurdy came over to Chris's house, or Chris's parents' house, to be clear. And Josh was with Chris all day. There's a brief period of time around lunch, 1:30 to 2:30-ish, where they were not together. 1:30, obviously, after the fire at Fawn Drive. But other than that, they were together all day. Made numerous stops throughout the day. You're going to hear a little bit about some of those stops. What I expect the evidence is going to show is that at 9:08 that morning, Chris went into a Wachovia in Loganville. Wachovia, for those of you who don't know, is now Wells Fargo. And at 9:12 that morning, he withdrew $480 from the teller. I expect you're going to hear about some visits that he made to a place called Truck Customs. Remember, Chris is starting, to do his own thing. He's got a truck. He's in the plumbing business. He needs a pipe rack. He needs a ladder rack. So he'd gone to this place called Truck Customs. First stop time, I think maybe around 10 o'clock. Second time later in the afternoon. And it's at that second trip to Truck Customs, ladies and gentlemen, where Chris gets a call from Tara's mother. Something's happened in Athens. You need to come over. Ladies and gentlemen, all those facts were established fairly early in the investigation. Now, you're going to hear about Chris's reaction when he got the call from Tara's mom about something happening in Athens, how Josh actually had to drive him in his own truck to Athens. And even with all of this, ladies and gentlemen, with those facts being established early in the investigation, Chris was always under the microscope as it related to Tara's murder. He was asked to give blood. He was asked to give a sample of his head hair. He was asked to give a sample of his pubic hair. Chris was subjected to repeated interviews by law enforcement. Every time anything's ever been asked of him, his answer's always been the same: whatever you need. The evidence will show that Chris has been fully cooperative for over 25 years. I'm going to try and move a little bit quicker now because I think I'm taking longer than I intended. But there is a lot of other investigation going on in this case, ladies and gentlemen. This is a 20-plus-year-old case. The state is not going to present to you everything that was done over the course of this 23-year investigation. From a period of time, several months after Tara's death in 2001 until 2024, we're going to talk more about that soon, there was a lot of work being done on this case. But there was nothing that would point the police in the direction of Tara's killer. There are tens of thousands of pages of police reports, records. There are hundreds of hours of interviews. It would take months to present all that in court, and we're not going to do it. And in so doing, we're not trying to hide anything. We're being mindful that it is an absolute impossibility to show you every lead that was chased down and every lead that became a dead end. About the dozens of persons of interest who were identified but ultimately ruled out. Hard work, frankly, just didn't result in any relevant evidence. One example, in 2010, the ligature, the printer cord, and the knife were retested for DNA, not just the blood, to see if there was any touch DNA on those items. And once again, only Tara's DNA was found. I expect over the course of this trial, you're going to hear about some missteps and some unanswered questions. Remember that window frame I talked about earlier? Well, the window frame was obviously taken into evidence back in 2001, but now, 25 years later, it's missing. And that's unfortunate. But what is fortunate is that you're still going to hear about the processing of that window frame that was done back in 2001 and how, again, there were no prints recovered. You'll hear that Tara's laptop, the one that I mentioned had been taken from her room, has never been found. And lastly, as far as unanswered questions go, I'd submit to you the evidence can show that no one investigating this case has been able to quite figure out exactly how the defendant got in and out of 160 Fawn Drive. Was it the kitchen window with the frame that showed signs of tampering? Was it the back door? To this day, ladies and gentlemen, there's no definitive answer. And the state's not going to be able to show you the answer to that in this trial either. That fact is not necessary to prove the defendant's guilt. And so again, with all this investigation going on and no leads being developed, the case goes cold. Something happened that changed all of that in 2023. Something called the Coleman-Baker Act was signed into law by Governor Brian Kemp. In case you hadn't figured out, the Baker part of that act is named after Tara. This is a law designed to address cases exactly like this one, where all leads have been exhausted and no likely perpetrator has been identified. What the law does is it directs new eyes to be placed on the file, see if all appropriate forensic testing and analysis was done in the first instance, or if additional testing might produce evidence or information relevant to the investigation. And so at this point, enter into our story agents Liz Bigham and Jeremy Howell with the Georgia Bureau of Investigation. Agent Bigham, Agent Howell are longtime agents with the GBI, and they joined that cold case unit after the law was enacted. In December of 23, they started looking at this case. And one of the first things they did was a dogged re-examination of all the physical evidence in Tara's case, including the sexual assault kit that had been taken at her autopsy. That kit was resubmitted for testing in February of 2024. And so, ladies and gentlemen, a lot's changed about DNA and the way DNA is tested from back in 2001. I expect you're going to hear that the sensitivity of that testing has improved greatly. And so in February of 24, the crime lab was able to find first male DNA and then obtain a DNA profile from item 2I. It's going to get confusing. We can clear all this up later about the names of those items. 2I is labeled oral swab B. It's pretty confusing. And so upon further testing of 2I, what they do is they separate the DNA into what's called fractions. I'm not going to get too much into the details of it now, but the idea is you're trying to separate the female DNA from the male DNA. 2I, the oral swab B, the first fraction is a match to Tara Baker. In the second fraction, there's a partial major profile of male DNA. And that DNA is not Tara Baker and is not Chris Melton. In case I haven't been clear, when I refer to a profile, what I'm, for lack of a better term, talking about is a DNA fingerprint. So when I talk about profiles, that's what I mean. But that profile, that partial major profile from item 2I was eligible to be submitted into something called CODIS, CODIS. That stands for the Combined DNA Index System. CODIS is a national database of known DNA profiles. I think that as of November last year, there are about 26 million known profiles in CODIS. And once that profile from item 2I was uploaded into CODIS, the way it works is it is routinely compared against the 26 million known profiles to see if any leads could be developed. On April 30th, 2024, there was a hit. And it was that DNA, again, matched from item 2I, and that hit was to the defendant, Edrick Faust. Ladies and gentlemen, that is the first time in 23 years and tens of thousands of pages of this law enforcement file that Mr. Faust's name shows up. So what do we know about Mr. Faust? He lived at 350 Cooper Road, and we talked about Cooper Road earlier. You can see it there. It's actually at the top of this picture. The star represents 160 Fawn Drive. I'll get more into that in just a minute. Cooper Road, again, at the very top, going horizontally in the picture. If you were to go left on Cooper Road, that's where you're going to run into Lexington Road, just to give you some orientation. Mr. Faust is living at 350 Cooper Road. 350 Cooper Road, ladies and gentlemen, is literally 585 feet from 160 Fawn Drive. So, next, what happens? Agents Bigham and Howell obtain a warrant to get Mr. Faust's buccal swabs, cheek swabs. And the purpose of that is to get a known sample of his DNA. CODIS, only a lead, you got to confirm it. And again, the first fraction from oral swab B, terrace profile, it's always terrace profile, vaginal, oral A, oral B, we'll clear that up later. Always Tara's DNA in that first fraction. And in that second fraction, you're going to hear about there being two profiles, but the major profile, the partial major profile from item 2I was a match to Edrick Faust. And that match, I might mess up the wording of it, was 1 in 800 quadrillion.
I have objection, Your Honor. And I have a motion. Outside the bridge.
All right, ladies and gentlemen, I'm going to have you go back into the jury room. Don't discuss the case. Thank you. All right, very good. You can bring the jury out now. Thank you very much. All right, you all may be seated. Thank you. Mr. Bolden, you have the floor.
Thank you, Your Honor. As I was saying, 1 in 800 quadrillion. That is, if I got it right, an 8 followed by 17 zeros. That's not all that you're going to hear about as it relates to DNA testing that was conducted in 2024. You're going to hear a great deal about something called true allele. I am not going to go into it too in depth this afternoon, but basically, true allele is this high-tech software that uses something called probabilistic genotyping to decode very small or mixed samples of DNA from a piece of evidence. And again, I'm not going to go into all the nuts and bolts of true allele here because frankly, I just don't think I'd do a very good job. But you are going to hear from Ashley Hinkle. Ms. Hinkle is a forensic biologist at the GBI Crime Lab who is an expert in true allele. She'll give you a good explanation of what it is and how it works. And ultimately, you're going to hear that all 3 swabs from the sexual assault examination of Ms. Baker were analyzed using true allele. Again, that same swab 2I, this is oral swab B. Again, the second fraction, separating male from female DNA. At least 2 individuals, we'll explain more later. Again, the major contributor based on the true allele results was Edrick Faust. The way true allele reports, ladies and gentlemen, is that the wording is significant. It's called a likelihood ratio. What Ms. Hinkle, I expect, is going to tell you that the likelihood of a match between Mr. Faust and the partial major profile in 2I is 30 octillion times more probable than a coincidental match to an unrelated person in the population. 30 octillion. Again, if I counted right, that is a 3 followed by 28 zeros. Good. Next one. So 2J is another swab that was collected at the sexual assault kit from Dr. Falzon way back in 2001. We're going to explain more about what 2J is throughout the trial. First fraction, again, Tara, always Tara. The second fraction of 2J had the profile of at least 3 individuals. There's a match to Chris Melton. Make sure I get it right. 30 octillion times more probable than a coincidental match. And there's also a match to Edrick Faust. Likelihood ratio there.
Your Honor, I would renew my request, my objection.
Your motion is denied.
Yes, ma'am.
You may continue.
The match to Mr. Faust here is 70 billion times more probable than a coincidental match. Then also, ladies and gentlemen, you'll hear about Truleal's analysis of the rectal swabs. Here, the second fraction had at least 3 individuals. There's a match to Chris Melton, a much lower number, 60,000 times more probable than a coincidental match. Going back, ladies and gentlemen, to 2J, the last one that I mentioned, it's a very important fact that I almost overlooked. Why would Chris's DNA be present in 2J? Well, I expect the evidence is going to show you that he and Tara had been intimate the weekend prior to her death. I expect that you'll hear that it's not uncommon for DNA to be found that far in the past, or when sex was known to have happened that far in the past. I expect you're going to hear that current guidelines for collection of evidence in cases like this is 120 hours. So that's 5 days. And again, Chris and Tara had been intimate the weekend before her death. So the rectal swabs, I don't want to spend too much time on it. Obviously, only Chris's DNA is found there. It's a very small amount. That's significant. You'll hear more about that later. Ladies and gentlemen, the evidence is going to be very clear that Chris and Tara were not engaging in anal sex. You're going to hear about a phenomenon known in the forensic community known as drainage. I guess an easier way to think about that is gravity. This is a known fact. Semen, just like any other physical object, is subject to gravity. And the vagina and the anus are in pretty close proximity. And remember how Tara's found in the floor of her bedroom. All right, so I'm nearing the end of our story. Armed with their investigation to this point, Agents Bigham and Howell interviewed the defendant. That took place on May the 9th of 2024, and it happened at the Athens Clark County Police Department. Mr. Faust had been placed under arrest for the murder of Tara. He was read his rights, and he agreed to talk with him. Now, I'm not going to go into everything that was said over the course of that interview. You're going to see and hear the relevant portions of that interview. But just a note, Mr. Faust said that he'd been living at 350 Cooper Road off and on for 40 years, to include the time frame back in 2001. 350 Cooper Road was actually his stepmother's house. During the interview, Mr. Faust denies ever dating anyone in Deer Park, ever knowing anyone in Deer Park, or that anyone from Deer Park ever came over to his house. Now, all that was said in this interview before he was actually told what the charges were for. And you're going to see, frankly, during this interview, the evidence is going to show that this is pretty conversational nature between the defendant and Agents Bigham and Howell. And then at the end, they tell him what the charges were for. Agent Howell actually says, and he's referring to Tara here, "Don't you remember? It's kind of a big deal." Agent Howell offers, "If you can help us understand why your DNA is in that house, help us. I'm here to exonerate just as much as I am to hunt." And you'll hear the defendant's reaction. Ladies and gentlemen, at the beginning of my opening remarks, I talked about how this trial represents the final chapter in a long, sad saga for both the Baker family and for the Athens community. For decades, everyone who loved Tara wanted to know who killed Tara Baker. Ladies and gentlemen, Edrick Faust killed Tara Baker. Edrick Faust sexually assaulted Tara Baker. Edrick Faust set her house on fire. And now, the final chapter begins today. But the last few pages of this story haven't been written. At the end of the trial, we're going to hand you the pen, and you, the jury, will write those last few pages. And when you do, you'll have the evidence to write the correct ending to this horrible saga. Ladies and gentlemen, I didn't say the happy ending. That's not possible. The correct one. You'll have everything you need to know to write the ending that the facts support and that justice demands. An ending that finds, beyond a reasonable doubt, the defendant, Edrick Faust, is guilty as charged. Thank you.
Counsel for the defense, opening statement.
May we use the monitors, please, Your Honor? Yeah. My name is Attorney Ahmad Cruz, and I have the privilege and the honor of standing beside Mr. Edrick Faust during this case. First and foremost, I want to thank you all for your sacrifice and taking time away from your families, your jobs, and your very important matters to sit and listen to the evidence the state presents in this case. We intend to get you all home as quickly as possible. Once you have all the evidence that you need to make a decision and not a moment before. First off, you can see on your screens, I'd like to tell you what happened. You all sat through 5 days of jury service and no one ever explained to you what happened. Then we're going to talk about how this is a crime of opportunity, the evidence that you were here supporting that this is not, let me put it this way. You'll hear evidence supporting that this is a crime of opportunity. Then we'll get into Chris Melton's and Tara Baker's relationship and what the evidence will show there. That is going to be very important in this case to understand what was going on with Miss Baker and Mr. Melton before she passed. Then we're going to talk about then I'd like to talk about with you the initial investigation in this case. This investigation, when it came to Mr. Faust, that isn't the initial investigation, but this investigation, when it came to Mr. Faust, you may decide that this is one of the most thorough investigations in Georgia history. In fact, you will learn that this investigation reached a level of desperation. And at the end of this trial, you are going to have questions that the state is not going to be able to answer. And I believe during the state's opening, they admitted one, which is they cannot present evidence to you, or they cannot answer the question of how Mr. Faust would have gotten into Miss Baker's home. They also can't answer the question of when did Mr. Faust's DNA get in Miss Baker's body? They don't know. They won't be able to answer the question, how would Mr. Faust get away from Miss Baker's home unseen at the time of the morning that they said he committed this crime? The evidence will show that in Deer Park, Black people simply walking were reported. In fact, on January 19th, 2001, the day Miss Baker passed away, there were 3 individuals reported, two, but one person was reported twice. It was a Black male. He had a afro, and he was wearing a bright orange shirt. And the witnesses say, hey, he's just walking normally through the neighborhood. Is he looking around suspicious? No. Is there anything unique about him? No. Actually, when I pulled out my car to get out the driveway, he stopped for me. So the state won't be able to answer if they're reporting individuals walking through the neighborhood. How did Mr. Faust get away unseen in the middle of the morning? And the last question that the state won't be able to answer for you. If Mr. Faust killed Miss Baker, why was the hair that was found on her body, around her body, in her hand, and on the murder weapon of Caucasian origin? You will hear evidence in this case that there is not a shred of evidence that puts Mr. Faust, let alone a Black person, in Miss Baker's home. All of the evidence, including the gift Miss Baker left in her hand for police, it's Caucasian hair. Now, the state, these questions have to be answered with evidence, not speculation, not with sensationalized media coverage, and not with unsupported conclusions. These are questions the state must answer for you with evidence and proof. The state may spend a lot of time talking about Mr. Faust's DNA. That is not at issue in this case. DNA is not at issue in this case. But they may spend a lot of time talking about Mr. Faust's DNA being present among, as they presented to you, the multiple DNA profiles that were found and identified. But you may find yourself asking this question at the end of the state's presentation of evidence. How does Mr. Faust's DNA simply being in Miss Baker's body, along with someone else's DNA profile, establish that he is the person that killed Miss Baker? And this is why you all are here today. This is why we are here today. We're not here to talk about, and the state is going to present this type of evidence. We are not here to talk about how bad of a person Mr. Faust may have been, how horrible of a boyfriend he may have been. That's not evidence in regards to what they must present to you to prove that Mr. Faust is the individual that committed these acts that they've chosen to charge him with in the indictment. We're here to talk about and find out whether the state's evidence proves beyond a reasonable doubt that Mr. Faust committed the crimes that he's charged with. That's it. That is why we are here. And in this trial, the question is not who killed Miss Baker. That is not the question that anyone is asking you to determine. But again, the question is simply, does the state's evidence that they present to you prove that Mr. Faust, proves beyond a reasonable doubt that Mr. Faust is the person responsible for burglarizing Miss Baker's home? He's charged with burglary in the indictment, sexually assaulting Miss Baker, and killing Miss Baker. That's the sole question you have to answer. Not who did it, just does the state's evidence support beyond a reasonable doubt that Mr. Faust is the person that committed this crime? And that's the key issue in this entire case. And you may get distracted by emotion in this case. You may get distracted by your dislike of Mr. Faust's life choices. But you cannot lose focus, and you cannot forget why we are here today. You are here on a murder, a rape, an aggravated sodomy, and a burglary case. You're going to learn that this is not a case of stranger on stranger violence, but rather a case of interpersonal violence. Interpersonal relationship violence. But you cannot be distracted. You can't be distracted. The reason we all chose you is because we thought you were the best jurors to sit on this case. You would not be distracted by emotion, and you would let the law guide you and come to a just decision. The death of a person is a horrible, horrible tragedy, and no one in this courtroom would tell you otherwise. We are not the media. We don't have the opportunity to speculate and draw in viewers. We don't have the opportunity to sensationalize this case of Ms. Baker's life. And that's what we're going to talk about during this trial, is Ms. Baker's life. We're going to show you what Mr. Faust looked like in the year 2000. If you would. This is Mr. Faust in the year 2000. He looks completely different than he looks now. What we put an emphasis on, and what you'll hear in evidence, is this is how Mr. Faust carried himself. He was a very well-dressed, clean-cut individual. He wore jewelry. He drove nice cars. We expect the evidence to we expect the evidence to show that. We're also going to show you a picture of Mr. Faust on February 8th, 2001, which is about 2 or 3 weeks after Ms. Baker's death. This is Mr. Faust about 3 weeks after Ms. Baker's death. Without a haircut, obviously, without his jewelry in, but this is a picture of Mr. Faust. And the evidence will show this is how Mr. Faust looked after Ms. Baker's death. In 2001, the evidence will show that Mr. Faust was a 25-year-old bar-hopping playboy. You will hear for some of Mr. Faust's ex-girlfriends, particularly the state will call Miss Brenda Sweeney. And you will learn in this case that the state, Miss Elizabeth Bigham, she will testify that she's reviewed every single document in this case file. And based on her review of that information, what you will learn is that Mr. Faust did not stay at 350 Cooper Road. Mr. Faust actually stayed in Knollwood Apartments with his girlfriend, Miss Brenda Sweeney at the time. And this is information that the state has had before today and during the entire pendency of this case. So what happened? That's the question that we're here to figure out. What happened with Ms. Baker? This is Ms. Baker shortly before she passed. This is her law school photo that she took while she was a student at the University of Georgia. And these are Chris Melton's hands after Ms. Baker's death. So Ms. Baker was killed on January 19th, 2001. These photos were taken on January 21st, 2001. This is Mr. Melton's left hand. This photo, these are Mr. Melton's right hand. During this trial, you will learn the nature of Ms. Baker's death. It was an overkill. And what we mean by that, it was terrible. That's the best word I could use. It was terrible. It was a horrible death. Ms. Baker was not only unalived, but the person who did this to Ms. Baker, they beat her, they punched her over and over and over again. And you will hear from the medical examiner the injury she had to her face. Her eyes were swollen and blackened. And then this individual, and we don't know the order, but this individual, this sick individual, then took Ms. Baker's printer cord and wrapped it around Ms. Baker's neck and he laid on top of Miss Baker as he pulled the opposite ends of that printer cord, strangling her. That individual, at some point, again, we don't know the order that this took place, but these are the things that took place. This individual at some point walked to Miss Baker's kitchen, pulled out a knife out of her knife block, and then stabbed Miss Baker in her neck. And you'll hear that Miss Baker was stabbed on the right side of her neck. This wasn't enough for this individual. This individual then went into the living room of the home, took Miss Ashley Hall's chenille blanket off of the couch, went and turned on the eye of the stove. They put the blanket on the stove, and when this blanket caught a blaze, what occurred was this person walked back into Miss Baker's room while Miss Baker laid on the floor, still grasping for air. You will hear that there was shooting in her lungs. He places this blanket on the bed, and then this person takes your laptop. You will hear back in 2001, laptops, cell phones now are like laptops. Back in 2001, laptops were like cell phones. They have all your personal information. But this person takes her laptop, he then closes her door, locks it, goes to her bathroom door, and you saw a picture of it in the States opening, closes the bathroom door, locks it, and takes his time to clean up Miss Baker's house. As the state mentioned in their opening, this person wiped down the door. This person wiped down the stove handles. This person wiped down the back door. This person wiped down the window sill. And when firefighters obviously fired a couple of hours later, the fire burst through the roof, you will hear from firefighters that in order to get in this home, they had to kick in the door. And it was deadbolt locked. And the type of doors you'll learn that Miss Baker had, the top lock has a key that you can put in. You have to unlock it to unlock the deadbolt. The bottom lock from the inside, you can just twist it. They have to kick in the front door. It's deadbolt locked. And the back door, there's so much smoke, and the state said this in their opening, there's so much smoke in the house, the firefighter goes to the back door to unlock the door, and the deadbolt is locked on the back door. But what you will hear is that when firefighters found Miss Baker, the individual that did this to her, this was somebody she was comfortable being naked with. The state is not going to present any evidence that clothes were ripped off of her. The state is not going to present any evidence that clothes were found near her. The state's not going to present any evidence that a towel was around her. She was completely nude, no clothing around her body at all. Now, while this individual was strangling Miss Baker, you don't leave the right to finish that or bring your life to take. The evidence we intend to present is that Miss Baker was scratching at this individual's hands while he was trying to strangle him. While he was choking him, Miss Baker was trying to get him off. While he was choking him, Miss Baker was grabbing his hair, trying to get him off of her. And the forensics evidence, and we'll get into the forensics, I won't go there now. But forensics evidence will support that Miss Baker was fighting for her life. Now, I mentioned the back door, that the back door was deadbolt locked. You will hear from a young lady by the name of Miss Kishana Armstrong. She's Miss Baker's niece. Okay, Miss Baker stayed at 160 Fund Drive. Miss Armstrong stayed at 140 Fund Drive. So if you're looking at this map, Miss Baker's home is here where the blue tarp is. Miss Armstrong's home is right here. 2 houses. And what Ms. Armstrong could tell you, and this is the same thing she told law enforcement 20 plus years ago that they ignored, was that, hey, it was 7:45 in the morning. I was going to my car because I had classes. I was getting ready to go to school. And to my surprise, I found it odd that a white guy was running through my backyard with a white t-shirt on and light blue jeans. And Ms. Armstrong is going to tell you, you'll see a photo of it, but Ms. Armstrong is going to tell you, she's going to testify. And what she'll tell you is this person, I can't remember the face because it's been 24 years ago. And you'll learn police never followed up with it. They never showed her a photograph of Chris Melton. And as the state said, Chris Melton was the center of the investigation, right? But they never showed her a photograph of Chris Melton. They never gave her a photo lineup. They said, hey, do you recognize anybody in this photo lineup? So what she'll come in and testify to is, hey, I don't remember the person's face. I can't really remember the person's hair, but I do remember the person has the exact same color hair as Chris Melton. That's what Ms. Armstrong is going to tell you. This is Chris Melton back in 2001. Ms. Armstrong is going to tell you that she can't remember her hairstyle. I can't really remember her hairstyle. But I do vividly remember this person's hair color. And what you'll learn is police never even asked her the hair color. They don't even ask her. When they interviewed her 20 years ago, they don't ask her about the hair color. Only thing they ask her, how tall is the person? What age does he look like he was in? And she'll say he looks like he was in his 20s. He had kind of like a medium athletic type of build. And they're aware that Miss Baker is dating Chris Melton. They never show her a photo of Chris Melton. You will learn in this case that law enforcement ignored Miss Armstrong for 25 years. We had to reach out to Miss Armstrong. Once Mr. Faust was arrested, Miss Armstrong was no longer needed. Crime of opportunity. I told you that I would talk about how this crime is a crime of opportunity. During this trial, one of the most important facts that you all will learn is that Miss Baker did indeed have two roommates. One of her roommates is Dr. Valerie Lowe. I believe you heard about her from the state. Then she went by Mrs. So she can Miss Valerie like she was at school. And also Mrs. Ashley Peavy Hall. At the time of this case in 2001, she went by Miss Hall. You will learn that each girl had a boyfriend, and we were counting Miss Baker and Mr. Melton. So at any given time, you will learn there could be 6 people in the house. And it was very rare, your testimony, very rare that someone would be at the house alone. However, on January 18th, 2001, being great roommates, Dr. Lowe tells Miss Baker, hey, I'm not going to be home. I'm leaving town. I believe she was going somewhere with her boyfriend, so she was going to be out of town. Miss Ashley Peavy Hall tells Miss Baker the exact same thing. And you will hear testimony about Miss Baker's response. What you will know is that Miss Baker was home alone. What you will also hear is that Miss Baker and Chris Melton spoke the day before her death 5 times. There was a 22-minute call. There was a 5-minute call. There was a 19-minute call. And there was 2 other short calls the day before her death between Miss Baker and Chris Melton. And when law enforcement asked Chris Melton the day of the crime, or the day close to the crime, hey, did you know that Miss Baker was going to be by herself? He said, of course not. He said, of course not. I didn't know that. She wouldn't have told me anything like that. But I do remember me telling her that I wouldn't be able to come down to Athens and spend the night with her. A couple of years go by. And police do this as part of their investigation tactics. Police asked him again, hey, do you remember if Miss Baker told you that she was going to be home alone by herself the day before she died? Chris Melton then tells law enforcement, Melton will probably testify that if there are 7 days in a week, 5 of those days, him and Miss Baker would be together. And this is first semester. But you'll hear from Dr. Lowe that on New Year's Day of 2001, she came home and to her surprise, Miss Baker was home alone. And she talked to Miss Baker about it, and she asked her about it. Miss Baker gave a response, I won't get into that. But Dr. Lowe will say there was a change in the relationship from that day up until the time Tara had died. They were not spending as much time together as they used to. But you'll also hear from Miss Baker's best friend. And I say best friend because Chris Melton stated, and that may be his testimony, that Mrs. P.D. Hall was Tara Baker's best friend. She described the relationship to law enforcement as it's pretty much like watching the normal ending of a relationship. But when law enforcement asked Mr. Melton about the relationship, Mr. Melton says, oh, everything was fine. She was my borderline fiance when we were about to get married. It wasn't until 5 months later in June when law enforcement approached Mr. Melton and said, Chris, we heard about a fight that you and Tara had the week before her death. Do you know about that? And for the very first time, he admits that there was trouble in paradise. He says, oh yeah, I know about that. It wasn't a big deal. It was something minor. Now, in the evidence that was provided to us, it wasn't provided to us. You'll learn that we don't have any information on what that fight was about except what Chris Melton said it was about. But it also matches up with Chris Melton's timeline. Chris Melton, when he interviewed with police in 2024, he told law enforcement that he had not seen Tara Baker in 10 days. Okay? That is a very important number. He said that I had not seen Tara Baker in 10 days. That 10 days lines up with their last fight. And Chris Melton said, 5 months later, I remember this fight. That is an important date to remember. Because in 2001, when Chris Melton was asked, or matter of fact, he wasn't asked, Chris Melton was told that there was DNA evidence in this case in 2001. When they told him it was DNA evidence, Chris Melton volunteered. I was just with her 6 days ago. She was at my parents' house, and we had sex 6 days ago. And then he asked, did y'all find semen or anything on her like that? But this is the issue. Law enforcement failed to follow up. They met with Chris Melton's parents, and you would think it's a significant piece of information that you saw a young lady that died at your home the week before she died. The parents never mentioned or confirmed seeing Tara Baker at their home the weekend before. What's verified based on Chris Melton's own words, twice, 2024 and 2001. He started 10 days before she died, and they had a fight the week before, which will line up with that 10 days. I promised you that I would talk to you about Chris and Tara's relationship. So this was a relationship where these individuals met at Georgia Military College. Chris was in school as a pre-med major. So pre-med is pretty much when individuals are going to school to become doctors. Tara was Miss Baker was in school to become a lawyer. So these individuals were equally yoked when they met. Miss Baker graduated school, and of course, as you know, she entered law school. Mr. Melton dropped out of school. And what happened when Mr. Melton dropped out of school? Miss Baker, she moved to Athens to attend law school. And I'm sure Chris Melton know he had an amazing woman. He followed. And he didn't follow and move in with Miss Baker. What he did, he followed and moved into a room of someone else that Miss Baker introduced him to. And you will learn that Mr. Melton, to stay close to Tara, was traveling back and forth every day for work from Athens to Covington, Loganville, Gwinnett County, Georgia, every single day while Miss Baker was attending law school. You will hear that towards the end of 2000, as I mentioned, that Miss Baker was distancing herself from Mr. Melton, and she was developing a friendship with another individual, an individual that was in her profession. Her roommates will also tell you that the relationship with Mr. Melton was coming to an end. Now, this is the biggest thing I want you to focus on during the closing. During the evidence. It's Chris Melton's behavior after Miss Baker died. This is going to be extremely telling evidence. Miss Baker dies on January 19th. On January 25th, Mr. Melton goes to Miss P.D. Hall's home to spend the weekend with her and her boyfriend, the family. On the 25th, he calls a girl by the name of Lisa Tucker and invites her on a lunch. Let me change it. He goes on a lunch. I'll say that. He goes on a lunch. I don't want to misstate anything. We're talking within a week of his borderline fiance dying. Then on this next day, after he set up a lunch with Miss Lisa Tucker, he then calls a woman by the name of Holly Hufford and sets up a lunch with her as well. And Miss P.D. Hall went to this lunch with Chris and Miss Holly Hufford. And she took her boyfriend at the time, Chris Hall. And what she'll tell you, or what the evidence will show, is that during that lunch, Miss P.D. Hall witnessed Mr. Melton flirting with Holly Hufford and even rubbing Miss Holly Hufford's back a week after his girlfriend has just died. And when Miss Ashley P.B. Hall says, all right, me and Chris are leaving, Chris Hall, her boyfriend's Chris Hall. Me and Chris are leaving. Mr. Melton explained to him that he was going to stay and hang out with Miss Hubbard. And this, again, is within a week of his borderline fiance being brutally murdered. You'll learn on January 27th, after hanging out with Miss Hufford, he called her around 10 o'clock that night and told her if she was out on the town to give him a call. Again, this was a week after his girlfriend has just been brutally murdered. Miss Hufford did not give Mr. Melton a call. You'll also learn that there was a candlelight visual for the woman that Mr. Melton claimed he loved. And if you've experienced death, you know death is like a bitch, losing it in instance. There was a candlelight visual held for Miss Baker. And instead of going to that candlelight visual for Miss Baker for his girlfriend, Mr. Melton told law enforcement, because they had to confront him with this information. This is nothing that he told law enforcement. They confronted him with this information. Mr. Melton told law enforcement that, yeah, I knew about the candlelight visual. I knew about it for about 4 days. But, you know, Lauren, she already had these tickets to this country concert at Turner Field. And, you know, she told me that she talked me out of going. She said that, you know, Chris, that isn't somewhere you need to be. So instead of going to his girlfriend's, if they were still together, his girlfriend's candlelight visual, he went to a country concert at Turner Field with two other couples. It was him and Laura Shirley. It was Laura Sherling's mom and dad, and it was also another guy and gal couple. You, the jurors, will have to decide if Chris Melton's actions after Ms. Baker's death were consistent with someone who had suddenly lost their future wife. Next, I'd like to talk to you about law enforcement's failures. And there was a lot of failures in this case. During the trial, you will learn this case is not simply about my client, Mr. Faust. This case is not simply about Mr. Melton, nor is this case simply about Tara Baker. You will learn that this is a case of law enforcement neglect and failure. The evidence will show while this entire community was in dread and fear, law enforcement had enough evidence supporting that the person that killed Ms. Baker was right in front of them. But because of the cameras, because of the media attention, and because of the sensationalism, they have Mr. Faust sitting in that chair. The evidence will show that law enforcement knew, this is information they're aware of, law enforcement knew and ignored, as I mentioned, that all the human hair found on her body that did not belong to Ms. Baker was of Caucasian origin. You will not hear a shred of evidence that there's an African-American man's hair on Ms. African-American's hair on Ms. Baker's body. And the reason we showed you the photo of Mr. Faust with the afro is because he had a lot of hair. The evidence will show that law enforcement conducted a DNA test. A DNA test was done. This isn't the first DNA test. A DNA test was conducted on a pubic hair found on Ms. Baker's butt. Now, in this case, and the state has already told you this, so I'll follow up with it. In this case, it is undisputed that Ms. Baker was sexually assaulted anally. A piece of evidence that law enforcement had was a pubic hair was found on her buttocks. They conducted a mitochondrial DNA test on this hair. And the results of the test was that Mr. Melton could not be excluded as the contributor of the hair. This is information law enforcement had. Law enforcement knew, and this science is now not good science. I do want to be very clear with you. So we're not talking about it because of its scientific purposes. We're talking to you about it because they knew this information and ignored it. There was a hair found on the murder weapon, Ms. Baker's murder weapon. So on the cord that was used to strangle her, the cord block was next to Ms. Baker's head. I'm sure you'll see photographs of how Ms. Baker was found. On this block, they found hairs, human hairs. And one of the hairs, they did a test. It's not good science anymore. I want to make that clear. But at the time in 2001, law enforcement knew that that the scientists had determined that this hair was similar to Chris Melton's hair. Law enforcement ignored it. Law enforcement knew and ignored, and the state has already told you this, there was no evidence of forced entry in Ms. Baker's home. They talked about a window. This is what you will see in the evidence. Can we? Sure. This is the window that the state talked to you about. It's not the best picture, but what you'll see is there's a screen in this window. Because they could not figure out how the person got into the home, they started going around the house and they saw a bent screen. You were here, they saw a bent screen. And because the screen is bent and in the window, they assumed, hey, maybe this person broke in the house by taking the screen down, lifting up the window, lifting up the blinds, climbing into the window, committing this crime. Then, because the doors are locked, they climb back out the window, let the blinds down, close the window, then put the screen back in place. And I'll show you a closer picture of what you'll receive in evidence of that screen. That's a closer image of it. And this is one more image of that screen as well. And it's just showing the shape it was in when law enforcement saw this screen window. That's the outside. Now we're going to show you the inside, and this is what you'll see in evidence as well. This is the inside of that window. Chair in front of the window, blinds down, unruffled, but this is how they're alleging Mr. Faust entered into Ms. Baker's home and exited Ms. Baker's home to commit this crime. The law enforcement ignored that there was no signs of forced entry into her home. They ignored that both the front doors were deadbolt locked and the back doors were deadbolt locked. Law enforcement knew and ignored, and this is very important too, because Mr. Faust is charged with a burglary. Dr. Lowe will tell you that in her room, I think she had a change jar with money, she had jewelry in her room, she had electronics in her room, and nothing was touched. Nobody had even rambled through her room. You would also hear from Miss Ashley P.B. Hall, who will tell you, you may even see images, but you will learn that she had jewelry in her room and she had electronics in her room, and nothing was touched or taken. Nothing was rambled through. Then you will hear about Miss Baker's room. Miss Baker had heirloom jewelry in her room. Heirloom jewelry. She had diamond earrings in her ears. And the only thing that was taken is a personal item, which was her laptop. Police ignored that fact. Law enforcement also ignored, and well, let me say this. So we don't have to prove anything, right? We don't have to present any evidence. The state has to answer the questions when it comes to this case. There are no questions that we have to answer. But something that law enforcement knew and ignored was after Ms. Baker's death, a young lady volunteered. She called in to law enforcement and said, hey, I believe Ms. Baker was out at a Mexican restaurant with me the night before her death. This young lady's name is Jessica Gann. And we're either get it through Ms. Gann or we're get it through the law enforcement officer she told it to. But she said, hey, Ms. Baker was out with me the night before she died. She said, we're at a Mexican grill. And, I don't know if it's her, but I believe it was her. Blind girl, she was talking about law school. I think I heard her. Law enforcement never followed up on this information. Law enforcement never showed Ms. Gann any type of photo of Ms. Baker. Law enforcement never followed up on her to figure out, okay, what more information do you have? They never even confirmed whether or not it was Ms. Baker she saw. They just ignored it. So the state cannot present evidence to you supporting that Ms. Baker, after she left the law library the night before she died, that she did not go out. They don't know. They don't know if Ms. Baker went out. They don't know if Ms. Baker went home. They just don't know. And they don't have any evidence to show one way or the other. Now, they mentioned Chris Melton's alibi. On January 21st, Chris Melton's parents told him, law enforcement, they are after you. They are coming for you, Chris. And that is a quote from Mr. Melton. That his parents told him, Chris, they are coming for you. This was January 19th to 21st. It was in January 2001. Police wait 4 months to go speak to Mr. Melton's parents after they've already told him 4 months prior that they're coming for you. And mind you, Mr. Melton is staying with his parents now. So he's in the house every single day. They asked the parents, hey, can you tell us what your son was doing 4 months ago on January 19, 2001 at 7 o'clock in the morning? Can you give me a rundown? Surprisingly, Chris Melton, you'll learn, is their only son, unless they've had children since then. But he was their only son at the time. They say, oh, he was at home. He was here. I remember seeing him. He was walking around. We were mulling around that morning. And then he left our house, and we know exactly where he went. How would they know that information? How would they know where Mr. Melton was going 4 months prior? But this is law enforcement confirming Mr. Melton's alibi, speaking to his parents 4 months. 4 months after Ms. Baker's death. Law enforcement failed to verify Chris Melton's alibi thoroughly. They just started taking words for, oh, he was here? Okay, perfect. He was with you? Okay, perfect. And this is the important thing in this case. The most important time in this case is 7 a.m. to 9 a.m. Whatever happens after 9 a.m., it doesn't matter because the murder has taken place. So 7 a.m. to 9 a.m. Remember, Ms. Kashana Armstrong at 7:45 says she saw this guy running. 7 a.m. to 9 a.m. is the most important window in this case. Law enforcement also waited 4 months to try and get Mr. Melton's phone records. They waited 4 months after Ms. Baker's death to try to get the phone records for his apartment phone. And that may or may not be important to you all, but to get the records for his apartment phone and his parents' phone call records, resulting in those records being lost forever. So what the state will not be able to present to you in defense of Mr. Melton is that, hey, we have these phone records showing where he was. Those records were lost because law enforcement did not act to get those records. This is the most important thing. So they showed you all a map of Miss Baker's home at Cooper Road, and they showed you where Mr. Faust's home was located. Y'all remember that? Seeing the box? Okay. This is what law enforcement, this is what you want. They did a neighborhood canvas. They had a roadblock, all this great stuff. Things you want here. One, they did not talk to the residents on the other side of your apartment. They could have simply went to 350 Cooper Road and knocked on the door. And they would have had all the information they needed about Mr. Faust because, as they mentioned, 350 Cooper Road was his stepmother's home. So she could have gave them all the information they needed. Two, law enforcement was aware, because you would hear Ms. Bingham say that, hey, I've looked at every document in this case. They were aware that Mr. Faust or his grandmother, if they notated it, now, I don't know how good their notes were, but those were not two individuals that were notated as individuals that they spoke to around the time of Ms. Baker's death. But this is a fear of theirs, because if they're saying that Mr. Faust stayed a block away, they're basing that on him saying, hey, I stayed at this address for a year. But again, they didn't go and interview those folks. They interviewed people in Deer Park, which was in the neighborhood that Ms. Baker stayed in. Chris Melton, another important fact. After Ms. Baker's death, Chris Melton comes to the police department with his hands covered in plumber's. You will hear from law enforcement that there was a shirt that Miss Ashley P.B. Hall, she's an amazing friend. She did everything she could to try to figure out what's going on with Ms. Baker. When Chris Melton came to her house, there was a shirt that she washed, and it was a substance. She called police and said, hey, we believe there's an issue with the shirt. And what law enforcement determined was the substance on the shirt was the exact same substance Chris Melton showed up to the police department with his hands covered in the day of her death. Now, you may hear the audio was brand new. I'm going to try to play it for you all. But you may hear law enforcement. I'm going to play it. So I have to play it a couple of times. But you'll hear law enforcement ask him, and this is a quote, do you want to watch them things? And Chris Melton says, no, this is neat right here. They never searched Chris Melton's apartment. They never searched Chris Melton's car for blood. There's a gentleman you'll hear about by the name of Lindsey Baker. He begged, you'll hear, he begged law enforcement, search his car. Did you search his car? Did you search his car? But what you will learn is, and the state already told you this, when Chris Melton came to Athens, he didn't bring his truck back. He rode in Josh's truck. And law enforcement never searched his car for blood. They didn't care. You won't hear evidence presented by the state that they searched Mr. Melton's car. You won't hear evidence by the state that they searched Mr. Melton's apartment. You won't hear evidence from the state that they searched Mr. Baker's parents' home. In regards to the claim that Mr. Melton made that he saw Miss Baker 6 days before her death, law enforcement never attempted to confirm that. They just took his word for it. Parents didn't confirm it. No one confirmed it. They just simply, well, Chris said it, so it must mean it's true. Let's talk about the forensics. I've already talked to you about the hair. There's no, and I'm gonna talk about this twice. When law enforcement met with, and the state told you this, when law enforcement met with Mr. Faust in the interview, what they told Mr. Faust was that your DNA was found in a house in Deer Park. You will hear no evidence that Mr. Faust's DNA was found in any place other than Miss Baker's body. His DNA was not in the house, unless you're saying in the house because it's in Miss Baker's body. There's no DNA of Mr. Faust ever being present in that house. And you will hear he is adamant. I have never been to. I don't know anybody over there. He's going to say that. What law enforcement did not do. Matter of fact, before I get into that, there are no handprints belonging to Mr. Faust. There are no fingerprints that the state will present to you belonging to Mr. Faust. There is nothing inside of the house that the state will be able to present to you to connect Mr. Faust with Miss Baker's house. The state wants you to believe that Mr. Faust is smart enough to enter Miss Baker's home, fight with Miss Baker, kill Miss Baker without leaving a trace of evidence behind, sexually assault her, right? Because they're charging him with aggravated sodomy based on the allegation that he sexually assaulted Miss Baker anally, but sexually assaulted her without leaving any identifiable DNA behind, then escaped Deer Park just unseen. But he is dumb enough to leave his DNA in her body and commit the charged crimes at the busiest time of the morning. And I don't think the state ever told you what time they are alleging that Mr. Faust committed this crime. Their window is between 8 a.m. and probably around 8:45. And you don't leave your common sense at home. You know what's going on at 8 in the morning and 8:45 outside your neighborhoods. But you have to decide as the jurors, does that make sense? That's the question you have to answer. The DNA. I think this is the most important part of this case that I would like to talk about. We talked about the DNA test conducted on the pubic hair found on Miss Baker's butt. But I would like to talk about the sexual assault kit that the state talks to you about. So the sexual assault kit, as the state explained to you, came back with multiple DNA profiles. Mr. Faust was one of the identifiable profiles. Mr. Melton was one of the identifiable profiles. Mr. Faust's DNA. If I understand the DNA correctly, and I may not, the testimony would be much clearer than me, was found in her vagina and her mouth. Chris Melton will tell you that Miss Baker engaged in vaginal and oral sex. That is a very important fact in this case. However, as you know from the charges read in the indictment, Mr. Faust is charged with aggravated sodomy for anal sexual assault. Chris Melton told law enforcement when they asked him, do you all engage in anal sex? No, never. She doesn't do anything like that. You know, we just have normal sex. Well, lo and behold, when they get the DNA results back, the only identifiable profile in Miss Baker's anus is Chris Melton's profile. Now, something the state mentioned, they told you in opening that gravity could make the DNA go into that area. Well, what the state says isn't evidence, but what Dr. Falzone says will be evidence. He is the medical examiner. He's the person that did the autopsy. And what he's going to tell you is that it is clear that Miss Baker was sexually assaulted anally based on the injuries well, let me use the right language. He's going to say it's consistent. That's the proper language. That her injuries to her anus are consistent with sexual assault anally. And the only identifiable DNA profile is Chris Melton. The state will not present any evidence to you supporting that Mr. Faust ever engaged in anal sex with Ms. Baker. It is important that you focus on the evidence that is presented. He is charged with aggravated sodomy, and his DNA is not even identified in her anus. There's no evidence supporting that Mr. Faust had anal sex with Ms. Baker anytime or anywhere. The state will not be able to present evidence supporting that Mr. Faust and Ms. Baker engaged in that act. Now I would like to talk to you about what I call directing the investigation. You will learn that once law enforcement became aware of Mr. Melton's DNA in Ms. Baker's body, they learned that information that Chris Melton had previously told them was false. Okay? You heard the state tell you that DNA typically in certain places only lasts about 5 days. I left out a place. Mr. Melton's DNA was also found in her vagina as well. So his DNA was found in her vagina, anus. Mr. Faust's DNA was found in vagina and mouth. Okay? But you will learn that this DNA of Chris Melton, as the state said, only lasts about 5 days. When law enforcement interviewed Chris Melton, they asked him when was the last time you saw her. He said 10 days, which I said was in line with their fight that he was approached about in June of 2001, the week before her death. Law enforcement says, well, look, and I want to make sure I say this correctly. Instead of interrogating Chris Melton and confronting him and saying, hey, you've been dishonest with us, something's not right here, we've seen the picture of your hands, what law enforcement tells Mr. Melton is they sit down and meet with him. And you're going to hear from the lead detective in this case, Elizabeth Bigham, that she asked Chris, and this is a quote, so was there ever a time in those 10 days, leading up into her death, that y'all just had a quick booty call or met up real fast or anything like that? Chris Melton responded, no. She knew what the DNA evidence was telling her. Ms. Bigham then tells Chris, I need you to be 150% honest with me. And I know that what I'm about to ask you, and I emphasize this language, is not what has been said for 23 years. And that may hinder you from wanting to be honest with me. But you've got to be honest with me. She then tells Chris Melton, look, your DNA would only last in her body 2 to 3 days. And that she needs to, and you will hear this, she needs to separate Chris Melton's DNA from bad guy's DNA. She says this. I need to be able to explain it. I need to be able to explain it. Jeremy Howell tells Chris Melton, and you'll hear Jeremy Howell testify, that the timeline needs to be correct. Everything needs to make sense. And if we know that this window is here and you're over here, I can't explain this gap. You need to be here. But Chris Melton, and you have to decide if he sticks to his story because he knows he's lied before, continuously denies being with Miss Baker the week of her death. They asked Mr. Melton, well, were you with her the night before? You had a booty call with her at 12 o'clock? He says, no. They said, well, how about 2 days before? No. Well, how about 3 days, Mr. Melton? Were you with her 3 days before? No. And eventually they get Mr. Melton for the first time to say in this interview, For 23 years, he changes his story to, you know what? Well, we maybe did it on Sunday. We might have did it on Sunday. And then Elizabeth Bigham tells Chris Melton in this interview, not an interrogation, in an interview, I think we just have to be able to explain it. I think we just have to be able to explain it. And that is our job, is to explain it. So we can then go after the one that we think did this. She laughs. I mean, you know, and evidence will show Mr. Faust is the individual that she was referring to. My client. When Chris continues to refuse to put himself and Miss Baker together, Miss Bigham, she says, if you're like, you know what? I effing lied about it 23 years ago because I was a scared, terrified kid. And you're right. I had a booty call with her that night. I left at midnight and I don't know what happened after that. It'll be, thank you. Have a nice day. We'll let you know what happens. Like, that's it. We just want to be able to explain it and make it make sense so we can focus on this, you know? So they can focus on this. You'll learn the lead investigator in this case, Elizabeth Bigham, told Chris Melton it was okay if he changed his story or changed his timeline of when he was with Miss Baker. And if he admitted to lying to police for 23 years so that she could explain away his DNA and put the focus on Mr. Faust and the responsibility for Miss Baker's murder on Mr. Faust, everything would be okay. She would explain it away. When Mr. Melton would not help Miss Bigham explain away his DNA, despite the 23 years of conflicting statements from Mr. Melton, and evidence, and you have to decide, but evidence pointing away from Mr. Faust's involvement in this case, the allure of being a hero, the allure of being on TV, being the officer to solve the 23-year-old Tara Baker case became too strong. And we ended up in the courtroom before 12 jurors to decide Mr. Faust's fate. The allure of being on TV became more powerful than following the evidence. And on May 9th, 2024, while Mr. Faust had just finished working, he's at Walmart buying a Simply Lemonade. Police cars swoop in on him and put him in handcuffs and arrest him. Solely because, and this is very important, and follow the state's timeline, solely because his DNA was present in Miss Baker's life. At the time of Mr. Faust's arrest, which you will learn, it's not, and this is, we told you, this is not a DNA case. We didn't come here to fight with DNA. You will learn Chris Melton's DNA is present, unidentified DNA is present, Mr. Faust's DNA is present. And based on his DNA being identified, he was arrested and charged with burglary based on DNA alone. He was arrested and charged with aggravated sodomy in the anus, even though his DNA isn't present. He was charged with 4 counts of felony murder. He was charged with malice murder. And every other count in this indictment solely based on his DNA being present, along with Chris Melton's DNA. Let's discuss the state's evidence against Mr. Faust, and I thank you for your patience. Do you all need a break? Let's discuss the state's evidence against Mr. Faust. To meet its burden of proof to establish beyond a reasonable doubt that Mr. Faust killed Ms. Baker, the state is going to rely on, they're going to present evidence of Mr. Faust's DNA being present. Okay, that isn't anything we're fighting with. As I told you, Mr. Faust's DNA profile was not the only DNA profile present, but these are the questions you have to answer, or the state has to answer. Mr. Faust's DNA profile being present does not tell you why this crime occurred or how this crime occurred. And you have to ask for that evidence. It does not tell you when the contact happened. And we don't know. It's been 24 years, 25 years. They've charged him with rape. They have to present the evidence that it was rape. The only thing that we could possibly say that you're here in the testimony in this case is that maybe when she was out at the Mexican restaurant, we don't know because they never followed up on it. They came into contact. We don't know. But that's a question the state has to answer. If you're saying it's rape, explain to us why his DNA is there. If you're saying it's rape, prove it. It does not tell us how the contact between Miss Baker and Mr. Faust took place.
Jack, if we can approach.
May first. Ladies and gentlemen, we're going to have you go into the jury room for a few moments. Please don't discuss the case. We'll be with you shortly. Do you have a motion? Mr. Elementary.
Yes, Judge, because I think this relates to our ruling as to 412 evidence, which I just think Mr. Cruz violated in a manner that borders on placing him in contempt, quite frankly. Mr. Cruz just intimated about the possibility of prior consensual contact that resulted in Mr. Faust's DNA being present in Miss Baker's body outside of the complained of contact, which would be previous sexual contact that requires 412 notice, Your Honor. So I think Mr. Cruz has quite intentionally actually violated the court's order, which court has made clear to him after multiple hearings on the issue. And so I'd like the court to instruct Mr. Cruz that that's, again, I guess for the third time now, that that's a wholly inappropriate suggestion to raise in any manner before the jury without having given notice, which he has repeatedly failed to do during the deadline set by the court, or from the point at which the court reiterated the fact that he had failed to procedurally give notice prior to today's date, which would be, well late of the time period in which he would have to do it. It would be 10 days late if he gave it today, but he has not. I would say further to the court that Mr. Cruz has represented to the court that he has no evidence other than what's in the state's file. Now, I guess he's making reference to this random tip that was received that Ms. Baker may or may not have been in a Mexican restaurant, which again doesn't say anything about her alleged contact with Mr. Faust. So there is no evidence supporting this, which is a finding the court would have to make, even if Mr. Cruz had provided proper notice, which he has not done. And now in opening statements after a week of jury selections has intentionally violated the court's order. So I'm asking the court to instruct Mr. Cruz not to engage in any further statements regarding that type of allegation, as the court has already instructed him, and to refrain from engaging in any questioning after opening statements, as is prohibited by Rule 412. So that's the state's objection that Mr. Cruz has intentionally violated the rape shield law, and the instructions of the state is asking the court to give Mr. Cruz again for the third time.
In just a moment, sir. Yes, of course. Ms. Setterfield, are you able to read back the question prior to the objection? Are you able to do that? If you would you mind reading that to the court? Thank you. Of course. Unable to find it. If you can't, that's fine. I'll go ahead and ask the state for something. I'll let Mr. Cruz respond. If you can't find it, that's fine. I am going to go back on the record when you're ready. You good? Thank you for trying. Okay, thank you. Mr. Yalamanchili, please tell the court exactly what you feel, the words that you feel Mr. Cruz deliberately said to violate the order that the court gave.
Yes, Your Honor. So Mr. Cruz initially said the state can't prove when it is that Mr. Faust's DNA entered Miss Baker's body. Mr. Cruz then said the police didn't follow up on this tip about the Mexican restaurant. Mr. Cruz then said it's the state's burden to prove that, and then said something to the effect of it could have gotten there when they had contact at that Mexican restaurant the night before the incident, essentially. Now that's paraphrasing, but Mr. Cruz stated that there was a separate time when Mr. Faust could have had contact with Miss Baker in a manner in which DNA would have been found in her mouth and in her vagina that is a match to Mr. Faust, which they are not contesting, Your Honor. So I think that is pretty clearly a violation of 24-4-412 when no prior notice has been made and no showing of competent evidence showing that would pass 403 examination has been presented to the court as required by 412. So that's the actions that I think that Mr. Cruz has taken in order to intentionally violate the court's previous instructions.
All right, thank you. Mr. Cruz.
So part of the state's case, Your Honor, is that Mr. Faust and Ms. Baker doesn't know each other at all. Only I was telling them that the only time, they could have had contact with each other at this restaurant. The court explicitly told me, or explained to me, ordered me, that I could not make an argument about consent. So I'm not making an argument about consent, but a big part of their case is just no way possible that these two people ran into each other. I'm just addressing that fact. Nothing in regards to the honorable court's order regarding 412 or in regards to argument of consent. Now, I am arguing, as the court has heard, that it's the state's burden to prove that appropriate occurred. And that's as far as I understand that I can lawfully go, considering the honorable court's order to be not to arguments.
Mr. Cruz, what would be the purpose of even mentioning the possibility of prior contact if it wasn't to violate the court's order?
Because the state's position is simply that these two would have never run into each other. We're disputing that.
All right, thank you. Yes, sir.
And Your Honor, since it is my motion, that is a complete and total misrepresentation of what just happened. Mr. Cruz was talking about the DNA and the fact that the state's contention is that the DNA came into Ms. Baker's body when his client was raping, sodomizing, and then murdering Ms. Baker. And then said, alternatively, that could have happened if they had run into each other at this Mexican restaurant the night before in the context of where the DNA came from. So the idea that this is just an attack on the idea that Ms. Baker and Mr. Faust could have randomly run into each other in some other social setting and that it has nothing to do with intimating that there was some kind of prior consensual sexual contact, something that Mr. Cruz seems to want to create the impression of with, as he says it himself, no evidence existing to support, is a violation of 412. And I don't see how it could be possibly interpreted as anything other than an intentional act on Mr. Cruz's part after repeated instructions from the court that he hasn't followed the proper procedural rules in order to introduce such evidence, and his own statements that would support a finding by the court, even if he had given notice, that there isn't any evidence, much less sufficient evidence under 403 to allow that allegation into the trial of this case.
Thank you. Yes, sir. And Mr. Yelmichley does get the last word. It's his motion, but go ahead.
I think the prosecutor is taking my statement, deal and gaps, which is breaching. There's evidence in the case. If one of their positions is that, hey, these people would have never came into contact with each other, we're allowed to rebut the evidence by saying, hey, they had contact with each other. I am not speaking of sexual contact. I am speaking of proximity. The state's position is just simply judge or judge don't like it. I'll put it this way. For the state to get up and say, hey, this attorney should be held in contempt because he made statements about the DNA and saying that, hey, they could have had contact with each other. And I didn't say they had sex at the Mexican restaurant. All thing I'm doing is saying, hey, there's a chance that these two were around each other. I understand the other court's rules, but to get up, object, and say, hey, this attorney should be held in contempt because he intentionally violated the court's order, that is not this. I have not said one time in this open, consistent with the court's order, consistent with my understanding of 412, that that Mr. Faust and Ms. Baker have had sex. What I've said is the state may be charging them with this offense, so they have to present evidence to support their allegations. And I've stated it multiple different ways, but that is exactly what the position is now.
Yes, sir. Anything else?
Your Honor, Mr. Cruz just said that it was about the DNA in his response. There is no other way to interpret DNA that is taken out of an oral sample and a vaginal sample that is male DNA other than claiming some sexual act. So I think not only is Mr. Cruz intentionally violating the court's previous orders, he's also being disingenuous in his representation of what just occurred in the courtroom, which the court saw for itself.
All right, thank you. That's all. All right, with regard to this particular moment, Mr. Cruz, we have had discussions about this issue. And I am finding that your comments were deliberate, that you are deliberately trying to circumvent 412. I'm not going to find you in contempt because this moment is very similar to an argument you made about the state's comments about a word that you did not agree was appropriate. Attorneys' comments, attorneys' arguments, openings and closings are not to be considered as evidence. But I am offering this to you, Mr. Cruz, as a warning that it is imperative that you follow the court's order. I've made several rulings with regard to this case. You are not allowed to talk about any issues of consent. You are not allowed to circumvent 412 without a proper motion. You have not filed a proper motion with regard to 412. If you do, the court will hear it. The state is correct. Even if we do hear a 412 motion, you have to have evidence supporting your motion. It can't just be something that you throw out there and assume that is something that could be properly admitted. But until a motion has been filed by the defense regarding 412, my order stands, and you are not allowed to go down that road. Am I clear about that, Mr. Cruz?
Yes, ma'am.
All right, thank you. You may bring the jury back in. Thank you. All right, you all may be seated. Thank you. Mr. Cruz?
The state's evidence includes, we mentioned the DNA, but what they also intend to introduce, and this is the question you have to ask yourself with anything they introduce, how does this support that Mr. Faust is responsible for death, burglary, rape, and escape? They intend to bring in a long-term girlfriend of Mr. Faust by the name of Miss Brenda Sweeney. Okay? Now, the thing is, Miss Sweeney and Mr. Faust were in a long-term relationship. They are not strangers. Okay? The state won't present any evidence of strangers coming in saying Mr. Faust broke in their house and did these terrible things to him. But what Miss Sweeney will testify to, you may get three different things because I believe we've gotten two. Okay? Police go to Miss Sweeney's house when Mr. Faust is first arrested. The news is broken. Right? She's getting phone calls. You'll see this if they present it. She's getting phone calls from people saying, hey, did you know, I don't know what I'm assuming. Pretty much she ends up saying that I just got a phone call that Edrick has been arrested. So what happens is law enforcement goes to her house, and the way they find her, based on what the officer says, is police reports. Mr. Faust and Miss Sweeney had a tumultuous relationship. They fought a lot. Okay, their police report of Miss Sweeney calling the police on Mr. Faust and saying he beat her up, and she gets arrested because there's witnesses saying no, it's the other way around. She was jumping on him. You're going to hear testimony from Miss Sweeney where she says, hey, Edrick hit me, and I beat him so bad I threw him into a DJ booth one time. Edrick took my car without permission. I went to his grandmother's house, and I beat him so bad he was trying to get me off of him, so he was scratching me, and other people had to come take me off of him. And she's going to give you multiple stories like that. But during this interview, it gets to a point where you'll see that this interview stops. And she says, hey, the worst thing I can say that Mr. Faust has done to me, he's hit me, and when the relationship is over and I'm with somebody else, he just stops. Won't leave me alone. Police don't take that as true. When they didn't get this scandalous story from Miss Sweeney about how terrible of a person Mr. Faust is, and it's terrible to fight with your significant other, what they say is, a young lady has been killed, and we want to get justice for this young lady. And we know, he's a terrible guy, and he's done terrible things to you. And just like we want to get justice for this young lady, we also want to get justice for you too. And she says, wait, guys, I don't know anything about a cold case. I don't know anything about a girl dying. All right, are you saying Edrick did it? Yes, I believe he did it. And Brenda, you were involved. You were with him at the time. And you'll see her, she misinterprets and she said, what? How am I involved? And he says, well, Brenda, you were with them, so forth and so on. We've seen police reports with you too. And then she pauses for a second and she says, Edrick used to force himself on me. And the officer says, oh, tell me more about that. Tell me more about it. And he says, did he punch you? She says, yeah, he punched me. Was he violent? Yeah, he was violent. When he would do this to you, was it vaginally, orally, anally? She said, or you hear it, she says, I don't know, for me, that, right? And they continue talking to Ms. Sweeney. And it gets to a point, and they may present it, they may not present it, but I want you to know this is evidence that may come in this case. It gets to a point that Ms. Sweeney is under so much pressure. And forgive me, I've forgotten the piece. Ms. Sweeney tells law enforcement that she's had multiple strokes, by the way. So she's physically suffering, and she also says it affects her memory. But it gets to a point where they get Ms. Sweeney so worked up, she says, y'all, God just gave me something. She said, I'm very biblical. She said this one time, Edrick went to this house, and there was this girl, and I don't know what he did, but he set the house on fire. And they say, well, did he hurt the girl? She says, I don't know. Says, was anything taken? She says, yeah, he probably took a TV. He probably took it to his stepmother's house. The officer asked, well, how do you know this? Did he tell you? She says, he must have told me. I knew too much. And police at that moment, they don't take it like, oh my goodness, she may not be in the best space to talk, right? They continue talking to her, tells them all types of fantastical stories. But what ends up occurring is, once I found out about Ms. Sweeney's interview, and you'll hear this too, that's why I say it's two sides. I speak to Ms. Sweeney. She comes to the court in front of the investigators that interviewed her, in front of the prosecutors, in front of Mr. Faust, in front of myself. And she says, I felt like they led me into those answers. She says, the only thing that I can remember from my relationship with Mr. Faust is that there was one time that we had unconsensual sex, and it was not violent. The state will introduce Ms. Sweeney not as evidence supporting that Mr. Faust committed these crimes against Ms. Baker, but to get you emotionally riled up. And that's why we chose you as jurors, because we believe that you will focus on the evidence. They are also going to bring in an individual by the name of Mr. Cedric Jeffries. Mr. Jeffries is serving a 105-month federal sentence. You will learn throughout this case, multiple people, since 2001, I know at least one officer has testified that there's been people from prison call with tips, like, hey, I have this information, can I get a deal or something? Now, what you'll learn in this case, Mr. Jeffries is going to testify that I don't have a deal. I don't have a deal. But what you will have to admit is that after he testifies in this case, he doesn't have a deal now, because it'll be terrible for him to have a deal now. Because of course, we're talking about his deal. What happens after this case, after he testifies and says Mr. Faust told him in 2003 that he committed this crime, I'm going to get into the details for you. Federal prosecutors are going to meet with him. They're going to review the transcript. And if they determine that Mr. Jeffries assisted the state in this case, he is going to receive an interview. Okay? And you have to consider that information in determining his credibility. But this is what he says. He speaks with, he sees the news. The news breaks of Mr. Faust's arrest. He's in jail. He says this, so you'll hear this. You admit it or we'll play a recording of it. He's sitting there watching the TV. He sees Mr. Faust get arrested. Okay? He doesn't call police. He doesn't say, hey, correctional officer, come here. I know something about a crime. He calls his lawyer. You'll hear that he reaches out to his lawyer. And of course, we don't know what the conversation is with his lawyer, but he ends up meeting with the lead investigator in this case, Miss Elizabeth Bigham. When he meets with Miss Bigham, she says, hey, tell me what you know about this case. He says, well, when I was 14 years old, Mr. Faust came to my house and he was saying, oh my goodness, I'm about to get into it with police because they know that I killed this girl in Deer Park. Okay? That is what he's going to testify to. So police asked him, why did you wait 20-something years to say that? And Mr. Jeffries says the most important thing and the reason why he's testifying in his trial. Mr. Jeffries tells him, jail helps me remember things. But you will hear from Mr. Jeffries. That is the state's evidence. Not a single shred of evidence will place Mr. Faust in Miss Baker's home. And the state has told you themselves, they've admitted it. We don't know how he got into the house. The evidence will show that Chris Melton admitted that Miss Baker had a key to his house. You have to decide if it's reasonable that Miss Baker.
I'm going to sustain that.
Yes, ma'am. But the state will rely on Cedric Jeffries, who, when he walks in this courtroom, he is serving a federal sentence right now, 104 months. And this isn't the first case Mr. Jeffries has testified on. Now, he may admit it, he may not admit it. But Mr. Jeffries at this time has testified on 2 other cases. He is a witness that gets in on cases and comes and testifies for the state. Something that's important, you're going to hear the interview of Mr. Jeffries, or he may admit it, so we may not get into the interview. But you're going to hear that Mr. Jeffries, one of the things he says is that I've never heard of this case before. Okay, and the state brought it to your attention that Mr. Faust stated that, in his interview, he made statements about Ms. Baker, and we're going to get into those statements. But before I get into those statements, I want to talk to you about sketches you'll see. The state is going to present sketches to you, okay? And what these sketches are of African-American men walking through Deer Park neighborhood, right? Police does a canvass after they found out about Ms. Baker's death. And during this canvass, they're talking to neighbors saying, hey, what did you see? The person that stays directly across the street, and Your Honor, may we switch back to the here. So, thank you, Your Honor. So what you'll see, as I mentioned, the blue tarp, and I think you all have a ticket there, but the house with the blue tarp is Tara Baker's house. The house across the street, I believe that is Mr. Matthew Owens, Mr. Jay Anderson. I may be mistaken, but I think Matthew Owens definitely stays there, Mr. Jay Anderson, and another individual. And when police come and talk to them, what they're going to tell you is that we see a guy in a bright orange shirt. And as you know, in UGA country, you don't wear orange if you're trying to be here. But we see a guy in a bright orange shirt. He's either wearing khakis or jeans, and he was walking in front of, down the street in front of Miss Baker's house. And the officer asks, can you describe him? He says, yeah, he has like small afro hair, black male, orange shirt, jeans. They said, well, how is he walking? He said, he's just walking regular, just walking. But he says, I leave to go away. I walk away from the window for a second. He said it's maybe 5 or 10 seconds he walks away from the window. And he says, when I come back, that person is gone. I don't see him anymore. He said, there's no way they could have made it to the end of the street because he says, I can see both sides of the street. He said the person had to cut through the houses. And then you will hear from Miss Tiffany Riker. And that individual, I think it's Jay Anderson, but the evidence will show the proper name. He doesn't do a sketch, just to be clear. But you will hear from Miss Tiffany Riker, who stays right here, this house here, she's going to say when she's coming out of her house to get in her car, she also sees a black guy, and she gives the same description. Wearing an orange shirt, blue jeans, khakis. He's walking down the street, and that's the gentleman I said. She backed up. She said, "You can stop. I need to get out of my car." Now, what you'll learn in this case is on the other side of your park, there's another photo you'll see during this trial. There's a Walmart. It's the Walmart on Lexington Road. So people travel from this neighborhood up here at the top through your park, and around here, I think somewhere around here, you can cut through and go to the Walmart on Lexington Road. Okay? And Chris Melton will tell us that African-American foot traffic was coming. Tiffany Riker would tell us that she didn't think anything of it because African-American foot traffic is coming. She thought the guy was walking to Walmart. But when police get this information, despite Ms. Kashona Armstrong saying we saw a gentleman running through my backyard, police say, okay, let's do a sketch of this person. So you're going to see a sketch of a guy who may not even know his pictures involved in this case. But they're going to show those sketches. But they're also going to show a sketch from a young lady. She was the wife of a tow truck driver. Okay? And the state may, they may change it because I'm about to say it, but the state may try to make this one person. Okay? But it's two different people. She says, hey, I see a guy. I was out with my husband. We were picking up a car. I saw a guy walking down the street. She says this guy has a heavy set face. He's kind of heavier looking. I can't really tell his body because of the jacket he has on. She says it's a bright jacket, but she says it's long sleeve, which is different from the individual that Ms. Riker and the individuals that stay across the street from Ms. Baker. Different from the individual they saw. They say, well, how was he acting? She says, well, he was just walking down the street. She said, I actually watched him in my mirror the entire time he walked, and he was just walking. They said, well, did he have on a hat? No hat, no hood, just a jacket, just walking down the street. The state is going to present those pictures to you as Mr. Faust. They're going to say, hey, it's a black guy in the neighborhood. This is Mr. Faust. But again, the only evidence they can present to you is that this gentleman was just walking. One, heavier set in the face. Another, wearing a short sleeve orange shirt. One wearing an orange jacket. All right? But those are the sketches they are going to present to you. One of the sketches, and it's up to you to decide, does not fit the description given at all. And you will hear evidence, you will see those sketches, you will hear the information given by those witnesses about what the person looks like. But the photo that I showed you, Mr. Faust with the hair, they're going to say, hey, this is Mr. Faust with his hair, and these are the sketches. Ask questions about the sketches. Look at the sketches. Listen to the information that the state gives you about the sketches. And just to make sure I'm clear, the person that was reported walking in front of Ms. Baker's house, our position would be this is the same person that Ms. Riker saw coming down this way, just for clarity. Lastly, you are going to hear Mr. Faust's interview. You're going to hear what Mr. Faust himself said about this case. You will learn, contrary to what the state has told you, that Mr. Faust was told when he was arrested, we're arresting you for murder and aggravated sodomy. They hadn't asked him anything. That's what you're here for. Murder and aggravated sodomy. Mr. Faust is confused. He talks to him. He chooses to talk to him way his rights because, of course, he's trying to figure out what the heck is going on. While they're talking to Mr. Faust, they didn't tell him whose murder. You will hear Elizabeth Bigham and Jeremy Howell ask Mr. Faust, did you hear about a cold case from 23 years ago? And that's how they ask him. Did you hear about a cold case from 23 years ago? Mr. Faust tells him, I vaguely remember, and this is a paraphrase, not a quote, but I vaguely remember it. I think I saw something in the paper about it. You will learn Jeremy Howell nor Elizabeth Bigham show Mr. Faust a photo of Ms. Baker. Jeremy Howell nor Elizabeth Bigham tell Mr. Faust Ms. Baker's name. They don't say, the Tara Baker case. They just say, hey, you heard about the cold case from 23 years ago. They don't even give Mr. Faust the opportunity to explain the DNA because what they tell him, and this is very important stuff, they tell him, why is your DNA found in that house? Mr. Foster said, house? I've never been to a house in Deer Park. My DNA in the house? Your DNA is in the house. And just as much as I'm here to exonerate, I am here to hunt. But the truth is, as I've told you, the evidence will show there is not a shred of evidence putting Mr. Faust in the house. They didn't have that evidence. They misled Mr. Faust. And of course, hearing he's charged with murder and aggravated sodomy, he's probably freaking out. And he says, I don't know anything about the house. I don't know that woman. But again, they never gave him an opportunity to confirm who they were talking about. No name, no photo, just the cold case from 23 years ago in Deer Park that your DNA was found in the house. What you're learning in this case, one person lied to police over and over and over and over and over again. One person simply said, I've never been to a house in the park, wherever you're talking about, I don't know. And the person that's in that chair is Mr. Faust. Now, Miss Baker, as we all know, is a very beautiful woman. They showed us a photo, or the photo that Mr. Faust would have been aware of. It's a glamour shot. The photo that you all saw was not a photo that was shown to Mr. Faust. I do predict that the state, they may change this. I predict that the state is going to attempt to play for you an audio version of Mr. Faust's interview. Because the video version will show that Mr. Faust was given no information other than that he was charged with murder and aggravated sodomy for a cold case that occurred 23 years ago. On the video, you will see no pictures shown to him, as I mentioned. The state's evidence may get you emotionally riled up, but those are not answers. I think this is significant for everybody to know. So in 2001, Mr. Melton is told, as I told you before, that Ms. Baker was sexually assaulted. And in there, I may not say the sexual assault, but he knew. They told him in 2001, and that's when he came back with, I saw her 6 days before she passed away. When he was meeting with Elizabeth Bigham and Jeremy Howell, they told him, hey, we found another person's DNA in her body. And Mr. Melton's response was telling. Mr. Melton himself said, sounds like she was with someone else. This is evidence in the case.
Ladies and gentlemen, I'm going to ask you to go into the jury room for one more moment. Please don't discuss the case. Walden, you have an objection?
I do, Your Honor. Mr. Yalamanchili and I had talked in anticipation of us getting to this point over the weekend. That since I had made opening statement,
You pull that microphone towards you. Thank you.
that I would object since I had made the opening statement, but since Mr. Yalamanchili had made the 412 arguments in the past that he would handle.
All right. Thank you. Go ahead, sir.
Your Honor, as the court's aware, as the state's aware, if Mr. Cruz wasn't aware before we started all the pretrial motions in this case, he ought to be aware now. Making reference, whether it's a statement made by some other witness, whether it's elicited direct examination, cross examination, or any other method to a relationship between Ms. Baker and anyone else that was not noticed by the defense as a 412 act is prohibited by 24-4-4-12. I'm not sure how much clearer the statutory language could be, not sure how much clearer the court could possibly have been in its instructions, but whether it's Mr. Cruz making reference to a statement that some witness made during an interview with law enforcement, or whether it's Mr. Cruz eliciting the testimony on direct examination or cross-examination, it is all prohibited by the rule, which Mr. Cruz has violated now for the second time in his opening statement. It does not matter. It does not matter one bit whether or not Chris Melton said that in an interview to law enforcement for the analysis of whether or not it is admissible and the methods that must be adhered to if the defense intends to admit it in any way, shape, or form, Judge. And so this is the second time before we've called the first witness to the witness stand that Mr. Cruz has violated 412, and what seems at this point to be an intentional pattern to try to work his way around the laws and rules of the state of Georgia as it relates to admissible evidence in cases involving allegations of rape and aggravated sodomy, Your Honor. So again, at this point, I don't know what the remedy is that the court wants to enact, but obviously telling Mr. Cruz not to do it isn't effective because he's not listening and he's not following the court's orders.
Thank you. Cruz. Any response?
Absolutely. I'm actually blown away and in shock that the state is taking this statement to be a 412 argument. Our theory of this case is that Chris Melton committed this crime. Chris Melton's statement, when he's confronted with DNA that he already knew was present, that she was with someone else, it has nothing to do with us trying to get around 412. That statement is for the sole purpose of showing his consciousness of guilt. He knew this information in 2001. He's told the exact same information in 2024. And his response isn't, oh, my girlfriend, I can't believe this happened, you guys better find her. His response is just simply to say, oh, well, let's leave her. It means she was with somebody else. There's no evidence that I intend to present that Chris Melton knows about Ms. Baker's sexual history. There's nothing I can intimate that Ms. Baker knows, that Mr. Melton knows about Ms. Baker's sexual history. The purpose of that statement has nothing to do with her character, under 24-4-12, her sexual character. The purpose of that statement is to show Chris Melton's response. When he's presented with some evidence, he gives a response that's inconsistent with the person that is innocent. So this isn't a 412. I understand the state may not like what I present, but that does not mean I have to preview every single statement I have to them so they can prepare their case. This is open statement. I respect the court. I do anything for this court. I told the court that multiple times. This is not a 412 argument. This is Chris Melton, who knows nothing about Ms. Baker's sexual history, being confronted with a piece of evidence and making a statement that shows consciousness of guilt in our court. This has nothing to do with sex.
All right, thank you. As this court has stated multiple times, this is the second time today, multiple times during hearings, that there is a process that must be adhered to in order to get the appropriate permission from the court to introduce statements, evidence that another party objects to. In this particular case, it is a 412 motion. We have talked about this over and over again. What I have said over and over again is that the defense has failed to file a motion under 412. The state did. The defense has failed to file a motion, and I've said many times that if the defense files a 412 motion, even though it's not timely, the court will consider it. There has been no motion filed. Mr. Cruz, you've been made aware many times that you are not to bring in this kind of statement. I mean, I realize I have said several times today that opening and closing arguments of the attorneys and arguments are not evidence, and I'm going to say it again when the jury comes out. But you've been told many times that in order to, I'm talking now, Mr. Cruz, thank you. You have been told many times that in order to present statements like that, ask for the admissibility of evidence like that, you have to file the proper motion. And the court may consider it even though it's not timely. As I just stated 10 minutes ago, I do find your statements to the jury to be avenues to circumvent 412. And it is not appropriate. I'm finding you in contempt of court. You have had the opportunity to explain yourself, and I'm fining you $1,000. And you are to present that $1,000 tomorrow morning by 9 a.m. Put it into the registry of the court. And that is my sanction for continuing to not abide by this court's orders. I don't know how many times we're going to have this, but it really can't happen again. $1,000 tomorrow morning by 9 o'clock. You may bring the jury up. Thank you. All right, you all may be seated. Thank you. Ladies and gentlemen, I want to remind you that any statements made by the attorneys, whether it is in opening statements or closing statements or during arguments, any statements by the attorneys are not to be considered as evidence. Mr. Cruz?
Thank you, Your Honor. At the end of this case, when you go back home, you're sitting around the dinner table and someone says to you, "Why did you find Mr. Faust not guilty?" You're going to say, "Well, I was fed a wealth of information. All this information came and it boiled down to one thing. The state couldn't prove that Edrick Faust was the person that killed Tara Baker. The state could not prove or present evidence that Mr. Faust was in Miss Baker's home. All of the hair found on and around Miss Baker's body was Caucasian hair. Mr. Faust is an African-American man. And that's why we voted not guilty. The prosecution in a murder case is required to prove their case beyond and to the exclusion of every reasonable doubt. Not a forced doubt or a speculative doubt, but a reasonable doubt. They have to present a case from you from A to Z. If A is Mr. Faust's DNA and Z is law enforcement's investigation, they never answer the question at G, at H, at I, at J, K. They don't answer the questions about Chris Melvin. They don't answer the questions about the hair, even the hair found in her hand. If he did it, why would she have somebody else's hair in her hand? Why would she have non-African-American hair in her hand? If Mr. Faust did it, how did he get in and out of the house unseen? Why didn't anybody see a black male running through the neighborhood? If he did it, why would he take so much time cleaning up her apartment? He doesn't know who stays there. There are 3 bedrooms. If he's a stranger, why would he take that time to clean her apartment? This was a crime opportunity. You all swore to uphold the law, to hold the state to its burden. There is evidence here of reasonable doubt that Mr. Faust did not kill Miss Baker. And it is not just sprinkled through this case. Reasonable doubt lives in this case. When you all have heard the evidence in this case, we're going to ask you to render a verdict of not guilty. In this nightmare for Mr. Faust, I am asking you individually and as a body to find Mr. Faust not guilty. Thank you.
All right, thank you, counsel, for both parties. Ladies and gentlemen, we started a bit late today. It is certainly late. I am going to give you a lunch break, even though it is certainly late. I'm going to ask that you return here at 4 o'clock. We're going to try to get into a little bit of the case. I promised Dr. Waller that we would be gone by 5. I've kind of promised all of you that 5 o'clock is kind of our limit. There may be days where we go a little bit longer. There may be days where we go shorter. But I did promise Dr. Waller 5 o'clock today because I know he has an emergency at his house. So we're going to do that. But we're going to get into a little bit of the case at 4 o'clock. When you leave here today, please don't discuss the case, of course, with anyone. Do any independent research. Go to any of the locations you may have heard. Have a nice late lunch. We'll see you right back here at 4 o'clock. Thank you. Council will see you at 4 o'clock.
Your Honor, and after the jury leaves, I wanted to raise a matter before the Honorable Court.
Sure. Come on up. Hang on just a minute. I want to make sure that can't have a private conversation. Back on the record. State of Georgia versus Edrick Faust, SU 24 Sierra 0547. Is the state ready to proceed?
You are, Your Honor.
Is the defense ready?
Yes, ma'am.
All right, thank you. Statement call its first witness.
David Freeman.
Could you get David Freeman, please?
Thank you, Your Honor. Sir, I'm going to ask you to raise your right hand, please. Do you swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you can have a seat. Sir, I'm going to ask you to state your name and spell it for our court reporter, please.
David, D-A-V-I-D, Freeman, F-R-E-E-M-A-N.
Sir, I'm going to ask you, back in 2001, how were you employed?
I was a Firefighter, Athens, Clark County.
Okay. Can you tell the jury, please, just a little bit about your firefighting career with the Athens Clark County Fire Department?
I was generally assigned firefighting or driving the truck. I did both. When I say firefighting, I mean actually pulling the hose off and, fighting fire.
How long did you do that, sir?
26 years.
Was there a primary station that you worked out of in those 26 years?
I worked in all of them at one time or another. I worked at all. We had 6, then we had 7, then we had, I think they got 8 now, but I worked at all of them at one time or another.
Do you recall where you were working in January of 2001? Which station?
Station 5.
Which one is that?
Whit Davis at Whit Davis Road.
Mr. Freeman, do you recall being dispatched with other Athens Clark County firefighters to a call at 160 Fawn Drive?
Yes, sir, I do.
Is that address in Athens Clark County?
Yes, sir, it is.
Do you recall approximately what time of day that call came out?
Generally, we clean up the station in the morning, check the truck, do household stuff. And it was before lunch. I can't tell you exactly what time.
Okay. Mr. Freeman, if you could please describe what you observed as you approached 160 Fawn Drive.
The call came in, I believe, as a structure fire. Me and another firefighter were on the back of the truck, which means we actually have the nozzle. We pull up to the front of the house or front of the apartment, and you could see the left side of the apartment. It had broken through. You could see flames. So as a firefighter, you're taught to go in the front and push the fire outside. So I had the nozzle. We went to the front door. I was putting my mask on, and I reached up and tried the door, and it was locked. And I believe the lieutenant on the truck is who actually kicked the door in. When he kicked the door in, I mean, it was almost like a training fire. You could see smoke had come down about head high, and we're taught to crawl. But that day, the smoke wasn't all the way down, so I could see a glow in the right side of the back of the room, which...
I'm going to stop you right there. So just to clarify a little bit, did you go in the front door of the house?
Yes, sir, we did.
And as you enter the front door, where in the house are you situated, if that makes sense?
When I go in the front door?
Yes, sir. Like just kind of generally
the best I can remember, because when we pulled up in the truck, you could see the fire in the left back of the house, and you could see the flames shooting through. So when I had in my mind that when we went in, I was going to go to the left. Well, when we kicked the door in, you could see in the right back of the room, you could see red glowing.
And what did you do when you saw that red glowing?
We actually went to that area, which turned out to be the kitchen, which turned out to be all the eyes on the stove are on.
When you say eyes, what exactly do you mean?
The old coral type electric stoves.
Okay.
They were all on and glowing red.
Did you notice anything about the knobs to the stove?
Did not have knobs on the stove.
Where were the knobs?
I can't. They were either on the counter. I don't think they were on the stove, but I think they were on the counter. They were taken off.
Okay. Did you yourself turn the stove off?
I believe I did. Yes, sir. I had to. I don't know if they were in the right place, but I put the knobs back on there and turned the stove off, and then. Or you go ahead.
Okay. What'd you do after you turned the stove off?
Lieutenant was over he was walking across the room back towards what now we know is the bedroom. But he told me, he said, open the back door to let some of the smoke out. So I had on my gloves. So I reached up to open the door and it was locked. So it was pretty warm in there. So I took my glove off and I opened the door. I believe it had a deadbolt and then a regular lock. So I opened the door, and at that point, the lieutenant said, come over here. So I had the nozzle.
Okay. You had the nozzle. He said, come over here. Where did you go?
I went from the stove kitchen area across what was the living room to what we now know was her bedroom, and that door was closed also.
What happened next?
We tried to open the door and it was locked. So the other firefighter that was with me, I think Doug actually kicked that door too. And, you know, I said, when he kicks the door, it's going to roll out, because I knew it was what we call rolling. It was.
When you say it's going to roll out, what are your...
The fire is going to roll out, because when we rolled up, we could see it burning through the roof. So I knew it was pretty intense. So when he kicked the door, I opened the nozzle, what we call Z'd it. I Z'd it down, knocked the fire down. And then they said, I hit it one more time just to kind of cool it down. And I had put my hand, we were just sitting there kind of watching it, make sure it didn't flare back up or flame up or whatever. And I always kept a big rubber band on my fire helmet, and I had a light stuck, up there in it. And I had my hand down on the floor, just kind of sitting there watching to see if it, it was smoke had banked all the way down in this room. And then I turned the light. When I turned my head, I looked down and I saw her at the foot of the bed. And
can you describe in detail what you saw?
There was a nude lady laying there. Almost looked like, you could tell she'd been in extreme heat. And she was also like a mummy, like she didn't look real. Her hair looked like her hair was intact, but it was.
So I know you said that she was on the floor. Do you recall how she was positioned?
She was positioned with her feet towards the door. Best I remember, we go in the door, the bed was to the left, and then she was at the foot of the bed, and then looked like the flames or the fire was on the bed.
Do you recall how her body was oriented, up, down, otherwise?
She was face up.
Upon discovering the body, what did you do next, sir?
Like I said, we were trained just to make sure it doesn't flame back up or anything. And so Steve and I were still in the room, on the floor. And the lieutenant, which was Doug, he was standing at the door behind us. And he said, y'all don't touch anything, just make sure it doesn't flame back up and back out. So that's basically what we did. We got it cooled down, and then we backed out.
And after backing out, did you, and when you say Doug, is that Doug Whitehead?
Yes, sir. He was the lieutenant on the seat that day. He was their supervisor, you might say.
And you mentioned Steve. Is that Steve?
Steve, yes, sir. He was a firefighter also. He and I were on the back of the truck. We had a driver of the truck. We had Doug was a supervisor, lieutenant, and then we had two firefighters, Steve Shellnut and myself, were on the back of the truck.
And after y'all backed out of the room, did you turn the scene over to the police?
Yeah, we called, I guess they called the chief and the assistant chief anyway. The shift commander was already there. So I guess they notified police, and, you know, it just kind of become chaos at that as everybody started showing up, and they wouldn't let us go anywhere. We had to stay there.
At any point, did you take notice of a screen to the back window in the house?
Yes, sir. When we got it cooled down, and I guess I was in shock. I just went to the back door because I had two small daughters. I went to the back door kind of trying to collect my thoughts and whatever. And there was a window to the left side of the door, and the screen, I can't say if it was laying in the yard or if it was leaned up against the house, but the screen had been tampered with. You could tell where it, like if you take a screwdriver and try to pop it out, you can tell where it had been bent. It had been tampered with.
Hang on just a moment, Your Honor. Mr. Freeman, those are all the questions I have for you.
Cross-examination, Mr. Cruz.
Yes, ma'am. May I move the podium, please?
Of course.
Good afternoon, Firefighter Freeman. How are you today?
I'm great. How are you?
I'm doing well. Is it okay if I ask you a couple of questions?
Yes, sir.
You mentioned the back door to the home. I just want to make sure I'm clear on this point. When you opened the door, did you have to unlock the deadbolt and the bottom portion of the door?
With no glove on. Yes, sir.
Would it be fair to say that based on your examination of the home, the doors were locked and there was no evidence of forced entry?
That would be correct. No forced entry to the doors. Now, like I said, the screen on the window, it looked like it had been tampered with, but no, there was no forced entry to the doors. No, sir.
Sure. Do you recall completing a interview with firefighter report from January 19th, 2001?
The report that I had to write?
Yes, sir.
Yes, sir.
Would you agree, and if you don't know, you say you don't know and I can show you. Would you agree that you were asked a question 29 in that report, were the doors locked when the first units arrived? Do you remember that question?
I really don't even remember the report you were referring to. I had to write a handwritten statement of what happened that day. Usually the supervisors make out the fire report.
Yes, sir. I am going to show you what I am marking as Defense Exhibit 1. Yes, sir. Thank you. Is it okay if I approach you?
Yes, sir.
Thank you.
Okay. Yes, sir. Were the doors locked when the first unit arrived? Yes, they were. Was any force of entry? I put no.
Yes, sir. You mentioned the window. I know that it's been 25 years since you responded to the scene. Do you recall what that window looked like at the time that you saw it?
It was a, could have been like a white, seemed like it was a white aluminum frame or vinyl window. It was 2 panes, top and bottom. Like I said, it was to the left of the back door.
Would you recognize that window if you saw it again?
Possibly.
I'd like to show you what's being marked as Defense Exhibit 2 and Defense Exhibit 3. Thank you for your patience.
Yes, sir.
And to make sure I have this correct, this window was to the, if I'm facing the back door, it would be to the right. Is that correct?
Left.
If I'm facing, well, let me.
If you're coming in the front door,
Okay, it's to the left. Is that right?
the window is to the left of the door that's on the right.
Excellent. I'm going to show you what's been marked as Defense Exhibit 2 and 3. Your Honor, may I approach?
Yes, sir.
Do you recognize that image?
Yes, sir.
Okay. Is that a fair and accurate depiction of the window as you viewed it on the day you responded to 160 Fun Drive?
Is this the way I found it? Is that what you're asking? I mean, is this
correct? Well, do you recognize?
I can't honestly say. I remember, as you can look at this and tell, it looks like it's been tampered with or whatever, but I can't honestly say that the screen was outside, was not on the window. I mean, over 26 years, I had numerous calls, and I can't 100% say that screen was off. I'm pretty sure it was, but I can't sit here and say, I know it was tampered with because I remember seeing this.
Yes, sir. Did you make any notations in the report I provided you? I believe that was Defense Exhibit 1, if I'm not mistaken, about the window screen.
No, sir.
Okay. Would you have any reason to say that those images have been altered in any way?
No, sir.
Okay. I'd like to show you Defense Exhibit 4. May I approach, Your Honor?
Yes, sir.
Do you recognize Defense Exhibit 4?
Yes, sir.
Okay. You recognize Defense Exhibit 4 as the screen at 160 Fine Drive, well, the screen in the window at 160 Fine Drive. Is that correct?
Yes, sir.
Okay. Is that a fair and accurate? Defense Exhibit 2 through 4, are those fair and accurate descriptions of?
Yes. That's looking at this is where I got the idea that it had been tampered with.
Yes, sir. Your Honor, I would move to admit Defense Exhibit 2 through 4 into evidence.
Any objection? They are admitted.
May I approach, Your Honor?
Yes, sir.
May I publish any to the jury?
May.
I want to thank you so much for your heroism. Those are my questions.
Any redirect by the state? May this witness be excused. Any objection?
No, ma'am.
You are free to go, sir. You may call your next witness.
Doug Whitehead.
Could you get Doug Whitehead, please?
Doug Whitehead. Sir, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court should be the truth, the whole truth, and nothing but the truth, so help you God? Help you God.
I do.
Okay. Can you state your name, please, and spell it for our court reporter?
Doug Whitehead, DOUGWHITEHEAD.
Good afternoon, Mr. Whitehead. If you could please, sir, tell the jury what it is that you did for a living.
I was a firefighter, sergeant in Athens, Clark County Fire Department.
How long did you work for the Athens, Clark County?
Almost 35 years.
When did you start and when did you stop?
Started January 1st, 1977 and stopped sometime in January of 2011.
Over the course of your career with Athens, Clark County Fire Department, did you work in a number of different stations around town?
Oh, yes.
Specifically in January of 2001, do you recall where you were stationed back then?
Station 5 on Whit Davis Road.
Mr. Whitehead, on January the 19th of 2001, do you remember being dispatched to a house fire at 160 Fawn Drive?
Yes, I do.
Is that in Athens, Clark County?
It is.
Just real quick, to get from Station 5 to Fawn Drive, how would you get there?
Well, we turn left out of the fire station, go to the intersection at Lexington Road, turn left. Believe it's the next road to the right is Cooper Road, and Fawn Drive would be off of that.
So when you turn onto Lexington from Whit Davis, are you turning left as
turn left at the red light towards Athens?
Do you remember about what time of day that call came out?
11-ish, I believe.
Describe, if you can, sir, what you personally observed when you arrived at 160 Fawn Drive.
Smoke coming from the rear of the apartment.
And so what did you do next?
I told the guys on the back to pull an 1 3/4 attack line, and we proceeded to the front door of the building.
What did you observe when you got to the front door?
It was locked.
What happened next?
Kicked it in.
What did you observe once that front door had gotten kicked in?
Smoke in that room. In the right rear corner of that room, to the best of my knowledge or remembrance, it is like one big room, kitchen and living room kind of combined, and in the right corner was a red glow.
And did you and the other firefighters go to investigate the source of that red glow?
We did.
What was it?
It was an electric stove with all 4 eyes on the top on high, and the knobs pulled off and placed on the countertop.
What did you do upon observing the stove being turned on with the eyes or with the knobs removed?
I didn't personally do it myself, but the knobs were put back on the stove and it was turned off.
Did you then turn your attention towards locating the source of the fire?
Yes.
Describe exactly what you did next, sir.
From the stove, we would have kind of turned left, and there was a hallway short hallway, a door at the end of that hallway, a door to the left, a door in front, and a door to the right. All three of those doors were locked. So we were pretty sure that the fire was in the room to the right, and it was locked, and we kicked that door in.
And what happened when you kicked the door in?
We found the fire, source of the fire, and we also found Miss Baker.
We'll get to that in a minute, but I want to talk about encountering the fire and what you and other
The fire had broken through the roof, which means that it burned through the sheetrock, up into the attic, through the insulation, through the plywood and the asphalt shingles on the top. So you could actually see daylight through that hole.
Good time to ask. Do you remember what the weather was like that day? If you don't, that's it.
I don't really remember. Okay. It seems maybe cloudy, overcast, and maybe cold, but I couldn't tell you for sure.
And so, what do you specifically recall about the discovery of the body in the bedroom?
I remember seeing Tara or Miss Baker at the foot of the bed. And what I remember is like her hair was wet and a comb had been run through her hair.
How was she positioned, if you remember?
I believe she was laying on her back.
Mr. Whitehead, do you recall, in fighting the fire in the bedroom, what would be the result, or what was the result, if you remember, of actually having to extinguish the fire to the structure of the bedroom?
From what I remember, the fire was primarily up overhead, not that much fire. So we basically would just hit it, and just a couple of turns of the nozzle, it was extinguished.
And after doing that, were you able to view a potential source or origin of the fire?
Yes.
What was that?
An Afghan, what I consider an Afghan, like was crocheted. I'm not sure if that's crocheted, knitted, was placed onto that stove that was, all four eyes were open, on high, ignited, carried to the bedroom and thrown on the bed, and remnants of that Afghan were on the stovetop in places where it dripped on the floor around to the bedroom.
And so what was the primary area of the fire in the bedroom, if that makes sense?
The bed, yeah.
You mentioned that you found the deceased, Miss Baker, at the foot of the bed, lying on her back. Do you remember anything else about her condition when you first saw her?
Yes. I know some type of an electrical cord. Not really sure where that came from, but around her neck.
Once you and the other firefighters had gotten the fire under control, what did you do at that point?
We backed out to preserve evidence. Once we realized there was Miss Baker was in the room, we backed out to try to preserve as much evidence as we could after making sure the fire was extinguished.
Mr. Whitehead, do you recall anything about the back window, the kitchen window to the house?
I think that the screen was taken out of the window and propped against the back of the house, but I cannot tell you that for 100%.
When you say you think that, is that your best recollection?
Yes, yes.
Overruled.
That's the last question I have.
All right.
Mr. Whitehead, I don't have any further questions for you, defense man.
All right.
Mr. Cruz.
Yes, ma'am. Good afternoon,
Good afternoon, sir.
Mr. Whitehead. My name is Attorney Ahmad Cruz, represent Mr. Faust. Is it okay if I ask you a couple of questions?
Absolutely.
In regards to the screen, would it have been the fire department's practice to find a screen outside the house and put it back in the window?
Would not have been our practice, no.
Okay, is that a practice that you're aware of with any agency that you've worked with?
Other than the fire department, I wouldn't be
sure
about their practices.
Would it be fair to say that the front door was deadbolt locked when you found it?
Yes.
And I believe you said this on direct. There was heavy smoke and flames coming out of the corner of the house. Is that right?
That's right.
Were those was the bedroom door locked? Do you recall?
Yes.
Okay. Was the bathroom door connected to that bedroom lock?
Yes. And so was the door to the left.
You gained entry into that room by kicking those doors in. Is that correct?
That's right.
Okay. And just to make sure I'm clear, that's the front door you had to kick in, the bedroom door you had to kick in, and the bathroom door that you had to
That's correct.
Do you recall completing a firefighter, Athens Clark County Fire Department interview with firefighter report?
No, but I'm sure I did.
Yes, sir. Would you have any reason to disagree that you placed in your report that there was no evidence of forced entry?
I'm sorry, could you repeat that?
Sure. Would you have any reason to disagree with the statement that in your report you put that there was no evidence of forced entry?
Before our arrival?
Correct.
Yes.
Those are all of my questions for you. Thank you.
Any redirect, Mr. Bolden? May this witness be excused.
No objection. Stay here.
Any objection, Mr. Cruz?
Objection, Your Honor.
You're free to go, sir.
Free to leave?
You are, sir.
Thank you.
You may call your next. You may. All right. Thank you. All right, ladies and gentlemen, we've just discussed amongst ourselves kind of best timing, and I'm going to let you all go a little bit early today. I know Dr. Waller has to get to a broken pipe, and we've talked about that. So I'm going to release you today and ask you to return back here tomorrow morning at 9 o'clock, where we are going to resume the trial of this case. My instructions that I've given you, of course, continue to apply. Please don't talk about the case, anything you may have heard in court today with anybody. Don't do any research. Please don't go on the internet and do any independent research or analysis or anything like that about this case. Does anybody have any questions for the court about that? Very good. I appreciate your patience today. We got, started a little bit late and we took a late lunch. I will try to do a normal lunch every day between 12 and 12:30, just so you're aware. We have some snacks for you all in the jury room and drinks. If there's anything that you need while you're waiting for us in the jury room, you need to let the court know. We'll be happy to try to get it for you. Other than that, I'm going to release all of you. See you tomorrow morning at 9 o'clock. Thank you.
Thanks.
Good morning. Y'all ready?
Yes, Judge. Just before we bring the jury out,
Okay.
I think this will speed up our process this morning.
All right.
Just a couple of things. Our first witness this morning is going to be the medical examiner. And so part of his presentation, I intend to elicit testimony about his opinion as to how some of the injuries to Ms. Baker may have been inflicted. And in so doing, I have what is very clearly not a real knife. So I just didn't want the court to freak out that I was, so just putting that out there. Second of all, we also would tend to introduce the autopsy report. I have 2 copies of it. The reason I bring this up is that it does list 2 names as suspects on that report, neither of which are either Mr. Melton or Mr. Faust. Since this trial has very clearly zeroed in on those 2 individuals, I prepared a redacted version because I think otherwise we get into issues that might confuse or mislead the jury. And so it would be the state's preference to tender the redacted version. But I would,
All right. Mr. Cruz, any comment on the state's proposal?
In regards to the fake knife, no. I think the most appropriate thing is wait till they attempt to introduce. If I have any objections, I'll make the objection at that time, Your Honor.
All right. Thank you. All right. I'll allow you to introduce the redacted portion since there's been no objection. All right. Anything else from the state before we bring the jury in?
No, I reserved my objection. I didn't say I didn't have any objection. Once they attempt to introduce, if I have an objection, I'll make the objection at that time.
You're certainly entitled to do that. But for now, in terms of allowing the redacted version in, you haven't made an objection, so I'm going to allow it in. If you want to object when it comes in, you certainly have the right to do that. All right. Thank you. Anything from the defense before we bring the jury in?
No, ma'am.
All right. Thank you. You may bring the jury in. All right, thank you, everyone. You may be seated. All right, ladies and gentlemen, good morning. Thank you for being here on time. As instructed, we're ready to begin again with regard to the state of Georgia versus Edrick Faust, SU 24 CR 0547. Is the state ready to proceed?
Your Honor.
Is the defense ready to proceed?
Yes, ma'am.
All right, thank you. Mr. Bolden, you may call your next witness.
Dr. Andrew Falzon.
Could you get Andrew Falzon, please?
Sir, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? You can have a seat. Sir, if you could state and spell your name for the record, please.
Sure. My name is Andrew. Last name is Falzon. Falzon.
And sir, where are you currently employed?
I am currently employed as a consultant pathologist with Mater Dei Hospital in Malta, Europe.
And what are your role, or what do you do as a consultant forensic pathologist there?
I oversee a pathology lab, one of the satellite labs on a separate island, and I also provide forensic services to the hospital.
Can you tell the jury a little bit about your prior employment before working at the hospital in Malta?
So I started as a associate medical examiner with the state of Georgia, with the GBI in Decatur, Georgia. That was from 1999 to 2001. After that, I was the assistant medical examiner for Middlesex County, New Jersey. And then when my chief retired, I became the chief medical examiner for the county. And I then took over the chief state medical examiner position for the state of New Jersey.
Throughout your career, has it been part of your job to conduct autopsies when requested by law enforcement or otherwise?
Yes.
Approximately, if you know, over the course of your career, how many autopsies have you performed?
Over 3,500 postmortem examinations.
Can you speak a little bit to your professional experience?
I graduated as a doctor of medicine and surgery from the University of Malta. I did a rotating internship there. I then started a master's degree program at the University of Mississippi Medical Center, and I graduated with a master's degree in anatomy in '92. I then enrolled in a pathology, anatomic and clinical pathology residency program at the University of Mississippi. And following that, I did a one-year fellowship in forensic pathology at the University of Alabama, Birmingham.
Have you also had an occasion to teach in the area of pathology and forensic pathology?
Yes, it did.
Can you speak just briefly to that, sir?
I usually, whichever locality I'm working at, I teach forensic pathology to various classes, usually undergrad classes.
Do you serve on any boards, sir?
As the chief state med examiner, I served on the domestic violence fatality near fatality review board, and also the child fatality review board, both the state board and the suicide subcommittee. I still serve on the suicide subcommittee of the child fatality review board.
Again, briefly, do you have trainings and certifications in the area of forensic pathology?
Once I completed my training in pathology, I took the American Board of Pathology certifying exams. I am board certified in anatomic, clinical, and forensic pathology.
Have you spoken at conferences related to the area of forensic pathology?
I've presented at mainly at the National Association of Medical Examiners meeting, you know, on any research that myself or the office was conducting.
And have you previously testified in court before as an expert in the area of forensic pathology?
Yes, I have.
Do you know how many times?
Over 100 times, mainly in the state of New Jersey, but also in the state of Georgia.
Your Honor, at this time, the state would tender Dr. Falzon as an expert in the area of forensic pathology.
All right, any objection by the defense, or would you like to voir dire the witness?
No objection, Your Honor.
All right, thank you. This witness is declared an expert in the area of forensic pathology. You may continue.
Thank you, Your Honor. Dr. Falzon, I'd like to turn your attention back to January the 20th of 2001. Just to be clear, where were you working at that time, sir?
At that time, I was working with the Georgia Bureau of Investigation in Decatur, Georgia.
And on that date, did you have the occasion to perform an autopsy on the body of Tara Baker?
Yes, I did.
Can you describe briefly the condition in which the body was received?
The body was received enclosed in a black body bag, and the body, to my recollection, was that she was unclad. She didn't have any clothes on her, and it was extremely charred.
You take steps to ensure that the person you are performing the autopsy on matches the, I guess, submission from law enforcement, I guess?
Yes, I do.
Okay. At the time, do you recall, or would you have noted receiving any historical or case information related to the request for the autopsy?
Typically we would receive that. I haven't seen any copies of those recently, so I don't recall exactly.
Can you tell us briefly what an autopsy consists of?
An autopsy is a post-mortem examination, typically performed to establish the cause and manner of death. We would start by reviewing the history surrounding the case. Then we'd move on to the examination of the body. Certain cases, we would do x-rays prior to actually starting the examination. Then you describe the clothing, remove the clothing, collect any trace evidence if indicated, and then you start the external examination, the examination of the body from head to toe, front and back. Once that is documented and you look for any injuries, document those, take the necessary photographs. Then you move on to an internal examination whereby we do an incision across the chest and abdomen, remove the organs of the chest and the abdomen. We'll make an incision across the top of the scalp, remove the skull cap, examine the brain, and then finally we'd examine the neck organs. During the course of the autopsy, we'll also collect specimens for toxicology and DNA as indicated.
You also take photographs while the autopsy is being conducted?
Correct.
And is it common practice to reduce the findings of your autopsy in the form of a written report?
Yes.
Okay.
Dr. Falzon, I'm going to hand you what's been marked as State's Exhibit 1. Do you recognize that, sir?
Yes, I do.
What is State's Exhibit 1?
It is a copy of the autopsy report drafted and signed by myself.
And is that the autopsy related to the case involving Tara Baker?
Correct.
I'd move to tender State's 1 at this time, Your Honor.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
Dr. Falzon, I'm going to go through your report kind of sequentially as it's outlined in State's Exhibit 1. Let's talk a little bit about the receipt of the body. I think I kind of just touched on this earlier, but if you could speak to what your report reflects as to how the body was received.
Correct. The body bag was, there were tags affixed to the body bag zipper that had the case information relevant to this case.
Can you speak generally to, you mentioned an external examination. We're going to try and take it in order. What was the first thing that you did with Ms. Baker as it relates to that external examination?
Photographs would have been taken, and then overall assessment of the body, the charring, the degree of rigor mortis, and the stiffening of the muscles that happened post-mortem, any lividity, the settling of blood in the dependent areas, general observations.
Let's talk a little bit about the injuries that you noted to Ms. Baker's body, starting with those on the head and neck, sir. Can you describe those in general?
The injuries on the head and neck were mainly in the form of blunt force injuries. When we describe injuries, there's three main categories: blunt force injuries that are caused by a blunt instrument, whether that be a fist, a piece of wood, a hammer. Those are all blunt force injuries. There's sharp force injuries that are caused by objects with a cutting edge, could be a knife, could be a shard of glass. And then there's gunshot wounds. In the case of Miss Baker, she had multiple blunt force injuries, mainly in the form of bruises around the eyes, the right and left sides of the head, and on the neck. She also had, on the neck, she also had a stab wound on the right lower front of the neck, and she had a ligature mark that surrounded the neck.
Specifically as it relates to the stab wound, can you describe in a little bit more detail what you observed?
The stab wound, like I said, was on the right lower front. When I describe a stab wound, typically I will, imagine the face of a clock overlying the wound. And in this case, the wound was oriented between the 10 o'clock and the 4 o'clock on the lower front of the neck.
You also mentioned a ligature mark encircling Miss Baker's neck. Can you speak a little bit more to that, please?
Yes. The ligature mark completely encircled the neck. It had one mark on the back of the neck and two marks on the front, which indicated that the ligature had been wrapped around the neck, crossed over in the front, and the ligature held on the sides.
Did you note any other injuries to Miss Baker's neck?
She had some blunt force injuries to the neck. Not sure if there was something specific here, if I may look at the report. She had contusions, bruises below on the left ear, below the left ear, and behind the left ear.
Moving, and we'll come back to that momentarily, Dr. Falzon. Did your external examination of Ms. Baker also include injuries to her torso?
It did, yes.
And again, I'm going to ask you to briefly summarize the extent of those injuries that you observed.
The injuries to the torso were mainly in the genital and anal area.
Can you go into a little bit more detail about those injuries, sir?
Again, they were in the form of blunt force injuries, bruising on the right side of her vulva down to the posterior aspect of the vulva, and she also had a bruise that completely encircled the anal region.
And lastly, Dr. Falzon, did you note any injuries to Ms. Baker's extremities?
Yes, I did.
And what were those?
Those were mainly in the form of sharp force injuries, injuries caused by a cutting instrument, and they were limited to the back of her hand, which could be classified as defensive type injuries, the injuries that a person would sustain trying to ward off an attack.
Did part of your internal examination of Ms. Baker include examination of the organs of the neck?
Yes, I did.
And particularly what, if anything, did you observe in that part of the internal examination of Ms. Baker?
As part of the examination of the neck structures, we look at the bones and the cartilages that make up the neck. One of the bones that we have in the neck is called the hyoid bone. It's a C-shaped bone that sits above the larynx. With cases of strangulation, we often see fractures in the hyoid bone. In the case of Ms. Baker, there were fractures on both the right and left sides of the hyoid bone.
And based on your training and experience, sir, what, if any, significance did you attribute to your observation as it related to Ms. Baker's broken hyoid bone?
That was part of the strangulation process.
Dr. Falzon, you mentioned that as part of the autopsy, you do take photographs.
Correct.
Bear with me just a second, Dr. Falzon.
May?
Dr. Falzon, I'm going to show you what's been labeled exhibits 2 through 7. We're going to finish labeling them. The rest of the photos here in just a moment. But if you could take a look at, again, states 2 through 7. Do you recognize those, sir?
I do.
Are those states exhibits 2 through 7 fair and accurate representations of the autopsy that you described of Ms. Baker back on January 20th, 2001?
Yes, they are.
Move to tender states 2 through 7.
Any objection, Mr. Cruz?
No, ma'am.
They are admitted.
And again, I realize this is a little cumbersome.
You may.
This, Dr. Falzon, is states 8 through 14. Same question. Take your time. Take your time. See if you recognize those. then one last group.
You may.
This is states 15 through 22. Last time. States, I believe, 8 through 22, are those also all true and accurate depictions of your observations of Miss Baker's body as you observed her at the autopsy on January 20th, 2001?
They are.
The Tender states 8 through, let me just start back, 22 through 22.
All right. Well, 2 through 7 have been admitted, so we're now on 8 through 22.
8 through 22.
All right. Mr. Cruz, any objection?
No, ma'am.
They are admitted. And how are you planning on doing that? Just handing them to them? Okay, so that's what I'm asking. So we've had a prior ruling, thank you. So just for any red and black persons who may be here under Rule 22 with a photo opportunity that the court granted, the Rule 22 has been amended to prohibit the media from taking any photographs or videos, of course, of these particular photos that the state is going to introduce to the jury. So if you can turn, thank you for doing that. I saw you turn your camera off. If anyone is here from the red and black pursuant to Rule 22, if you would please not photograph. Go ahead, Mr. Bolden.
Your Honor, and I think the court may have to switch. So, Dr. Falzon, you should have a monitor down there to your right. Okay. Dr. Falzon, we're going to start with State's Exhibit 2. What is State's Exhibit 2, sir?
It's a photograph of the body of Miss Baker as received, and it depicts the face, the torso from the chest down to the hip area, and the upper extremities.
State's Exhibit 3, same question.
This would depict the lower aspect of Ms. Baker from the upper chest, including the lower extremities, and you can see the charring of the body in this photograph.
State's Exhibit 4. What do we see here, sir?
This is a photograph of the face of Miss Baker, showing a degree of charring and also the blunt force injuries that I alluded to prior, notably the bruising around the eyes.
State's Exhibit 5. Is that just a slightly different angle of her face?
Correct. It's a slightly closer up view of the face.
Same question as it relates to State's Exhibit 6.
Again, closer up view, focusing mainly on the right eye.
State's Exhibit 7.
This depicts the left side of the face, and there's again charring, and you can see there's a braided laceration, kind of like a U-shaped, inverted U-shaped lesion on the left side of the chin.
State's Exhibit 8.
Okay. This is a photograph depicting the left side of the face, neck, and the left shoulder, and you can see the ligature mark on the posterior aspect of the neck.
State's Exhibit 9, is that just kind of a closer up photograph of what you just described?
Correct, and you can see the single linear mark that extends over the posterior neck, and you can also see the bruising behind the left ear.
This is State's Exhibit 10. What do we see here, Dr. Falzon?
It's a photograph of the neck aspect. You could see the ligature mark on the top, which is an electric cord, and you can see the plug aspect, the prongs on the left-hand side of the photograph.
And Dr. Falzon, I think you can actually, if it would be helpful, you can, the screen in front of you, you can touch and circle things. Just to clarify what you just described as it relates to the ligature. And I think Your Honor might have to, Mr. Dickey explained that there's a, within, yes. All right. So you've made some drawings on.
The U-shaped, I need to erase that. Okay. But so I'm marking here the cord, and that's the prong aspect and the plug attached to the cord there.
In this photograph, is the stab wound that you previously described also identifiable in this photograph? Right. Thank you, sir. State's Exhibit 11. What do we see here, sir?
Again, you see the cord here. Difficult to see because it's.
And the circle at the end, is that the?
That's the end of the
plug to the
plug. Yeah.
It's Exhibit 12. What are we seeing here, Dr. Falzon?
It's the front of the neck. Again, there was extensive charring, and there was a lot of smeared, dried blood on the skin. But you could see the stab wound, and the stab wound had what we refer to as the blunt edge and the sharp edge. When you have a knife, obviously you have a cutting edge of the knife, and the back, the non-cutting part of the blade, and they both leave kind of distinct characteristics. But this would be the blunt end there at the back. So you see the blunt end on the, I guess, on the right-hand side of the body, with the sharp edge more directed towards the middle of the body.
We'll come back to that later, Dr. Falzon, but I'm going to move on for now. This is State's Exhibit 13. Is that just a slightly different angle of the stab wound that you just described?
Correct.
State's Exhibit 14, particularly on Ms. Baker's left shoulder, Did you reach any conclusions about that area where there's no charring, sir? If that question makes sense.
Right. It looks like an area of what we'd call sparing. There's no soot and charring on that area, and most likely that was where the plug was resting, kind of like protecting the skin from the soot deposition.
State's Exhibit 15. That just a slightly different picture of different angle of
Correct. Closer up view.
what we just described. Okay. Okay. These are where it gets even tougher. State's Exhibit 16, Dr. Falzon. What is this photograph?
That's a photograph depicting Ms. Baker's genital area. You can see the bruising. The above, this would be kind of like an area of charring, heat damage. So this is not part of the injury she sustained while she was alive, but you can also see the bruising around the introitus, the entryway to the vagina.
And we're going to follow up on that with State's Exhibit 17. Again, I apologize. State's Exhibit 17, what is this a photograph of, Dr. Falzon?
This is a slightly different angle of the anal-vaginal area. You could see a bruising that completely surrounds the anus, which would be this area here. And then you see the bruising on the right-hand side and the posterior aspect of the introitus, the entrance into the vagina.
State's Exhibit 18, is that just a slightly different angle of the last photograph, sir?
Correct.
We're almost done. State's Exhibit 19, shifting gears. What are we looking at here, sir?
This is a photograph of the back of Miss Baker's left hand.
State's Exhibit 20, is that just a slightly different viewpoint of that left hand?
Correct, and it's showing what we refer to as an incised wound. With sharp force injuries, you can have stab wounds where the knife is actually penetrates, the blade penetrates into the body, or you can have an incised wound where the cutting edge is dragged along the surface of the skin. This here is an incised wound that we see, that area there.
State's Exhibit 21. Again, are we just kind of looking at that same left hand, sir?
Correct, and you can also see there's another incised wound, another cut in the web space between the fourth and fifth finger. So that would be that area there.
And then finally, State's Exhibit 22, is that just a picture of the ligature that you previously described after it had been removed from Ms. Baker's body?
Correct.
Dr. Falzon, I want to first talk about the injuries that you've described and the photos that we've seen in Ms. Baker's genital area. And you've described those and we've seen the photographs. Based on your training and experience coupled with your observations of that area of Ms. Baker's body, what, if any, significance can you attribute to the causation of those injuries?
Those would be caused by sexual intercourse with force used.
As it relates, and then I realize I'm jumping around a little bit, as it relates to your observations with regards to the ligature and Miss Baker's, the fact that her hyoid bone had been broken. And again, based on your training and experience, what, if any, significance do you attribute to the causation of those injuries?
So the injuries on the neck that we saw from the cord and the fractures of the hyoid bone would be the result of strangulation, ligature strangulation.
And then Dr. Falzon, as it relates to your observations of the stab wound that you've previously described on Miss Baker's neck and the wounds, which I believe you previously referred to as defensive type wounds to her left hand, do you have, and again, based on your training and experience, do you have an opinion as to the mechanism by which those injuries may have occurred?
Those would be sharp force injuries inflicted by a knife. Just to expand on the stab wound, because we described the injury on the skin, but once the internal examination is performed, there was actually injury to the internal jugular vein on the right side, which is the main vein that drains blood from the right side of the brain, which would explain the amount of hemorrhage, the blood on Miss Baker's skin. And that would have been caused by a knife.
Okay. And did you, were you able to form an opinion as to how that stab wound may have been inflicted?
Given the orientation, the location, and the orientation of the wound, as part of the assessment of the stab wound, I also try to ascertain the direction in which the stab wound was penetrated into the body. So in case of the stab wound that we saw on Miss Baker's right neck, the knife entered through the skin and it went from front to back, downwards and to the left. In my experience, that has often been due to somebody being stabbed with the perpetrator standing behind the victim and forcing the knife into the body cavity like that.
And again, referring to your observations as to the incised wounds on Ms. Baker's left hand, what, if anything, do those wounds tell you about what you just referenced?
Those would indicate that Ms. Baker would have been in the process of trying to protect herself from the stabbing while it was being performed.
Would it be helpful to the jury to kind of demonstrate what you've just described, sir?
Yes.
Well, Your Honor, is it okay if I ask Dr. Falzon to step down into the welcome?
It's fine.
Dr. Falzon, I'm going to hand you what is very clearly a rubber knife. And I'm going to be Ms. Baker. And so what you just described on the stand, sir, if you could kind of describe or show exactly what you described.
So the entry wound would have been somewhere here. So with holding the knife like this, the blunt end would be at the 10 o'clock position and the short end would be at the 4 o'clock position.
And again, as it relates to the injuries to the hand, how would that, in your estimation, have occurred?
So if she was trying to hold on, that would explain the cut on the space between the fourth and the fifth finger. Again, the direction would be front to back, downwards, and to the left.
Dr. Falzon, based on everything that we've talked about, well, actually, I want to back up just a little bit. Did your autopsy of Miss Baker reveal anything as it related to her larynx?
She did, yes, I did examine the larynx, the voice box, where the vocal cords sit, and she did have a slight amount of soot present below the vocal cords.
Did you also, as part of this autopsy, request or refer Ms. Baker's blood be tested for the presence of carboxyhemoglobin?
Yes, I did.
And are you familiar with the results of that report?
Yes, I am.
And what was that?
I believe it was between 6 and 14%. I may have to jog my memory. I gave you back the report, but
now let's talk a little bit about carboxyhemoglobin.
okay.
What is that, sir?
Hemoglobin is a molecule that transports oxygen. It picks up oxygen in the lungs, takes it and deposits it in the periphery of the body, and it picks up carbon dioxide and releases that back in the lungs during respiration. Now, when as part of the fire, carbon monoxide is formed. So carbon dioxide is carbon with 2 oxygens. Carbon monoxide is carbon with 1 oxygen. Carbon monoxide tends to attach somewhat more strongly to the hemoglobin molecule, and it actually prevents hemoglobin from transporting oxygen. So when somebody is exposed to a fire, we test the blood for carboxyhemoglobin, which is essentially hemoglobin attached to a carbon monoxide molecule.
And so based on your observations of soot being deposited below Ms. Baker's voice box and the results of the carboxyhemoglobin test that you just described and testified to, is that significant in any way to you, in your opinion, doctor?
The level of carboxyhemoglobin was not high enough to be considered a cause of death. Typically, we expect carboxyhemoglobin to be more than 50%. People who smoke tend to have, elevated carboxyhemoglobin levels. But in the case of Ms. Baker, the presence of the soot below the vocal cords and the slightly elevated carboxyhemoglobin level would indicate that she was still alive when the fire was set.
Thank you, Dr. Falzon. So again, just to summarize everything that you've testified to thus far, were you able to form an opinion as to the cause of death of Ms. Baker?
Yes, I did.
What was that opinion?
So she died of a ligature strangulation and a stab wound of the neck. I also described the bruising on the head, the blunt force trauma of the head. As part of the internal examination, I did examine the brain, and there was some subarachnoid hemorrhage on the surface of the brain. So the other contributory factor would be blunt force trauma of the head.
Did you rule the manner of death, Ms. Baker's death, a homicide?
Yes, it did.
Overruled.
Dr. Falzon, you mentioned that part of a autopsy may include taking an X-ray or radiograph if there is evidence of a stab wound. Did I understand that correctly?
Correct.
Why do you do that?
When somebody is stabbed, the
Yes, sir.
Relevance. It's undisputed that Ms. Baker was stabbed.
All right, Mr. Bolden, do you care to respond to the objection?
Trying to allow Dr. Falzon to testify to everything that was done as part of Ms. Baker's autopsy.
I'm going to overrule the objection. You may continue.
That's for the same courtesy during our examination.
I'm sorry, Mr. Cruz. What do you mean by that?
We just asked for the same courtesy that the honorable state has received.
When there's an objection made, I will rule on it. Mr. Bolden, you may continue.
Do you also obtain a sample of Ms. Baker's blood?
Yes, I do.
What is the purpose of that?
That would be performed to collect the specimens to submit for testing for toxicology.
And is a blood spot filter card also submitted?
Yes.
And
All right. I'm going to sustain that objection, Mr. Bolden, if you'll rephrase.
okay, I will rephrase it, Your Honor. What other physical evidence is, I guess, obtained or submitted as part of an autopsy?
To establish a reference point for DNA testing, a blood spot filter card is prepared whereby we take a filter paper card and we put drops of the victim's blood that is air dried and then submitted for analysis.
Was a sexual assault kit obtained in this case?
Yes, it was.
Can you explain briefly what we mean by sexual assault kit?
A sexual assault kit has various components to it which help in collecting evidence in cases where sexual assault is suspected. It would have swabs to collect DNA. It would have slides whereby we smear the swabs and prepare smears to look at under a microscope. It would have nail clippers to clip nails and envelopes, put those nail clippings in. And it would also have envelopes for head samples of head hair, pubic hair, and pubic hair combings.
And I apologize if you mentioned this already, but when you're talking about swabs, from where on Miss Baker's body were those swabs obtained?
Swabs are taken from the mouth, oral swabs, from the vagina, and from the anus.
And again, I apologize if I just misheard. You mentioned smears as well. How are those smears created?
The smears are created from the swabs. So we put a Q-tip with a cotton tipped end, and that would be inserted in the cavity, the oral cavity, the vagina, the anus. Once fluid is absorbed onto the cotton tip, while it is still wet, we would take the glass slide and smear the tip of the Q-tip on that slide to prepare the smear.
Your Honor, we have a motion.
All right. Ladies and gentlemen, I'm going to ask that you go into the jury room. Don't discuss the case. This is a good time for a bathroom break. We will be with you shortly. Y'all may be seated. Thank you. Mr. Cruz, your motion, sir?
Well, I want to do the simple thing first. We have an objection to the known pubic hair of a victim. Exhibit 31 is empty. So that's empty.
Your objection is to Exhibit 31.
Correct, but I do have a motion.
No, but I want to hear your objection, and then you can make your other motion. Go ahead.
I believe the purpose of showing this to Dr. Faust is for the purpose of identifying ever here tonight. So we object to the state simply giving Dr. Faust back.
Okay.
All the other items from the ones that were observed from the inside, they had items. That we don't object to those. But we do have a motion.
All right, well, let Mr. Bolden respond to your objection on Exhibit 31. Go ahead, sir.
Well, Your Honor, I mean, I can show Dr. Falzon, we can open it. I mean, I guess the objection is the fact that it's empty, and somehow that makes it inadmissible. I don't know that that's the case. I don't know that I know how to respond to that particular objection.
I can make it clear. It's confusing. The pubic hair is relevant for his testimony. An empty bag that just says pubic hair is irrelevant in this case. That's what we're objecting to, the ground that we are objecting on.
All right, Mr. Bolden, do you care to respond to the objection about relevancy?
Again, I think the fact that Dr. Falzon has testified that pubic hairs were taken, why don't we let him look at it? Because Mr. Cruz's assertion that it's empty, I honestly had not opened the bag, so let's allow him to do it. We can do that momentarily. I'd like to hear the motion. Sure.
All right, that's fine. We'll hold off on Exhibit 31's objection. Go ahead, sir.
We're moving to suppress the oral swabs due to chain of custody. In this case, it has been stated that oral swabs, vaginal swabs, and anal swabs were taken. We have the chain of custody report. The chain of custody report says that only 2 oral swabs were taken. I assumed that was pretty much an error on the chain of on the custodian, because Ms. Bigham, 2024, conducted a test on these swabs, and it was determined. They went to a company in California to do this test, and that's something we'll address on cross-examination instead of using the company here in Georgia. But that company came back and said, you know what? We did this presumptive test. These are actually vaginal swabs. However, now that I'm seeing the original packaging that Dr. Falzon put these items in, and please correct me if I'm mistaken, a vaginal swab wasn't taken. Ma'am? Madam I'd like to show the report, State Exhibit 28. State Exhibit 29.
I don't know that I need to see the exhibits at this moment. I want to hear your objection about, you're asking the court to suppress certain things. Tell me that.
To suppress the, I'm asking for 2 things.
Okay.
I'm asking on the court to suppress, I believe it's oral swab B. Let me confirm which swab it is, Your Honor. Course indulgence. So one of these are labeled as item 2I. Or give me a second to identify item 2I. So for purposes of the record, oral swabbing B is labeled as item 2I, as in igloo. Oral swabbing A is labeled as item 2J, as in joy. So, Your Honor, on November 4th, 2024, and mind you, this wasn't a discovery, by the way. But on November 4th, 2024, Pure Gold Forensics.
Okay, hang on just a minute, Mr. Cruz. Let me ask you this question. Are you making a motion to suppress?
I am. But this is based on knowledge I just learned just now going over these exhibits. So this isn't a motion that was untimely because I knew about it 10 days from around. I just learned this.
All right, let me stop you right there just for a moment. Is there any response to the motion to suppress as opposed to a motion in limine or an objection based on something else? Go ahead.
Yes, I would object to this being characterized as a motion to suppress. Mr. Cruz, we've had hearings going back for months. We've discussed making any physical evidence available to him to inspect, and we would have done so at any time. He never asked. He asked in court, but never followed up with that. This evidence we would have gladly shared with Mr. Cruz at any point had he actually asked, but he did not. I don't think what he's asking for this morning, well, again, I don't know a motion to suppress at this point. I don't know what legal grounds he's asking that it be suppressed. He mentioned chain of custody. I think that argument is more of a weight versus admissibility issue. It's very hard to respond when I don't understand exactly what is being asked.
All right, thank you. Mr. Cruz, let me ask you this question. With regard to this motion you're making now, is it, as you stated earlier, about the issue of the chain of custody?
Correct.
All right. I'm making a ruling right now that that is not a motion to suppress issue. You are entitled to cross-examine this witness or any witnesses with regard to the chain of custody, and I'm not going to allow it.
Judge.
If you have an objection to something else about the admission of this evidence, I will hear it.
Judge, motion to suppress, motion in limine, the phrasing is irrelevant.
No, it is not, Mr. Cruz.
Well, forgive me, the state, when the chain of custody issue is raised, the state has the burden to show that that this evidence is the same evidence that was collected and that it wasn't tampered with. The issue we have is that both of these items from Dr. Falzone, Dr. Falzone, both of these items were collected by him and labeled by him. There's going to be testimony in this trial 24 years later that, actually, one of these is a vaginal swab. Dr. Falzone, as you've heard from his testimony, is very careful. He's very diligent. It sounds like he takes his time and does his work the right way. So we're moving for the state to either show a chain of custody for these items, meet their burden to show a chain of custody for these items, and that they were not tampered with, or we ask the honorable court to exclude any mention that oral swabbing B is a vaginal swab, because from what I'm seeing for the first time today in court, it is not.
All right, Mr. Cruz, I'm going to overrule your objection and I'm going to deny your motion. And I'm going to make the statement that the complaint that you're making in the form of an objection and the request to make a motion is certainly appropriately addressed by cross-examination. You have every right to cross-examine any witness with regard to chain of custody, with regard to the issues of tampering, anything that is relevant to the evidence that's being offered. You have every right to cross-examine with regard to those issues. And so that's the reason I'm denying your objection. And if there are any other objections to the admission of that evidence, I want to hear it now. I want to address one more thing before we bring the jury back. Any other objections to the admission of that? I mean, I haven't ruled that admissible yet. We haven't made an, there hasn't been a proffer, but if you have something that you'd like to object to now that you know about, so you can do that.
We will stand by our chain of custody
All right.
Motion.
All right, thank you. I do want to make a comment, Mr. Cruz, and this is really for all parties, but it's related to the comment that you made a little bit earlier. You did not make an objection, but you stated something to the effect of, we're asking the court to extend us the same courtesy. My comment to all parties, but particularly to you with regard to that comment, is this. That comment about the court's behavior is not appropriate in the manner in which you said it. The court makes rulings of law, not courtesies. The court extended, Mr. Cruz, you a courtesy this morning when you were 20 minutes late. I knew why you were late and I extended you that courtesy. That's a courtesy. But in terms of this trial and in terms of making comments in front of the jury, the only appropriate comments to be made are not comments. They are objections. They are proper examination questions, cross-examination questions, things of that nature. And the court will respond to proper objections. Any comment on the courtesies of the court or fairness or things of that nature that are not in the form of objections need to be made outside the presence of the jury. And that's my statement.
Yes,
thank you. Anything else before we bring the jury back in?
Your Honor, if we could have just maybe a minute for us to take a restroom break.
All right, why don't we be off the record until 11:15? That's about 12 minutes. All right, we'll be in recess until then. Thank you. Cruz? All right, thank you. You may bring the jury in. All right.
Judge, did you issue a ruling on our objection to the empty pubic care package, or no?
Hang on one second. I thought that I had said it. I was overruling your objection. Maybe I didn't make that clear. I'm sorry, Mr. Cruz. I'm overruling the objection. All right. If you have any other objections to the introduction of evidence, you may make them. I haven't ruled them admissible at this point. The state hasn't proffered them in that way. So if you have any other objections, you certainly can offer them.
Yes, ma'am. But on that ground,
Yes, sir. Yes, sir. All right. Thank you. You may bring the jury. Please be seated. Mr. Bolden?
Thank you, Your Honor. Excuse me, Dr. Falzon. I think we were talking about the collection of the sexual assault kit. Is that right?
Correct.
Okay. I am going to, if I may approach the witness, Your Honor. I think, Dr. Falzon, this is State's Exhibits 23 through 33. Dr. Falzon, let's start with State's Exhibit 23.
Yes.
What is that, sir?
It's a clear plastic box with a label marked with the case information, and it's marked fingernails left hand.
And would that be the fingernail clippings that you took from Ms. Baker's body on January the 20th, 2001?
Correct.
Move to tender State's 23, Your Honor.
Any objection?
No, ma'am.
It is admitted.
State's Exhibit 24, Doctor, what is that?
It's a clear plastic bag sealed with evidence tape. There's two clear plastic boxes, each one with a label with the case information. One is marked toenails right and the other one toenails left.
Again, same question as before. Are those related to the autopsy that you've been describing this morning?
Correct.
How do you know that, sir?
Each one has a label on them with the decedent's name, Clark County, the age, race, and sex, and the unique case identifying number assigned to this case.
Any objection?
No, ma'am. I won't have any objections to any of those outside of the objection I already put on the record.
All right, thank you. Number 24 is admitted, and you may proceed, Mr. Bolden.
State's 25, Dr. Falzon, what is that?
25, it's a white paper envelope sealed with evidence tape, and the the label with the case information, and this one is marked oral swabbings B.
And again, same question. Is that related to the autopsy that you performed on Ms. Baker on January 20th, 2001?
It is.
Move to tender states 25, Your Honor.
All right, and based on Mr. Cruz's assertion, is that right, sir, that there's no objection?
Outside of my prior objection.
All right, then it is admitted. Thank you. And that's number 26?
25.
25. All right, 25. Thank you. Go ahead.
States Exhibit 26. What is that, Doctor?
Same white envelope with evidence tape and the unique case identification information. And this one is marked oral swabbings A.
Move to tender states 20. Now I've forgotten. 26, Your Honor.
26. Mr. Cruz, any objection, sir? All right, it is admitted.
States Exhibit 27, Dr. Falzon. What is that?
White envelope, red evidence tape, label with the unique case information, and this one is marked rectal swabbings.
Tender states 27.
Mr. Cruz, any objection, sir? It is admitted.
States 28. What is that, Dr. Falzon?
State Exhibit 28 is a brown cardboard folder, has a label marked with the unique case identification information, and this one is labeled anorectal swab.
Move to tender state 28.
Any objection, sir?
No, ma'am.
It is admitted.
States 29, Dr. Falzon. What is that?
29, again, is a cardboard folder with the unique identification label, and this is marked auto swab.
Move to tender states 29.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
That was 29, yes.
29, is that right, Dr.
Yeah,
Falzon? Okay, good. States 30, what is that?
30 is a white cardboard box, again, marked with the label with the unique case information. And this one is marked vaginal smear.
Move to tender states 30.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
States 31. What is that, doctor?
A clear plastic envelope with the label with the case information, and this one is marked known pubic hair of victim.
Move to tender states 31.
Any objection, Mr. Cruz?
Yes, ma'am. The same objection I put on the record.
All right, and thank you. Any further comment by the state? All right, I'm going to overrule your objection. Your objection is noted. It is admitted over objection.
States 33. Dr. Falzon, what is that?
33 is a clear plastic envelope marked with the case information, and this is the combings, pubic combings of victim.
Move to tender states 33, Your Honor.
Mr. Cruz, any objection?
No, ma'am.
It is admitted.
Is that everything that I handed you?
Did we do 32?
Oh, 32? Did I skip that? I apologize. States 32. I got ahead of myself. What is states 32?
Clear plastic bag marked with case information, and this is marked known head hair of victim.
Move to tender states 32, Your Honor.
Any objection, Mr. Cruz?
No, ma'am.
It is admitted.
I'm going to not go through all of those pieces of evidence, Dr. Falzon, but I want to start. This is states 30. There's the sticker. I think I can zoom in. States 30. Again, what is that, sir?
This is a cardboard folder and marked with the case information, and this would contain the glass slides with the smears of the vaginal, taken by the vaginal swab.
How would or was States Exhibit 30 created?
The first we do the swab. So like I mentioned, you have the Q-tip swab, that we insert into the orifice, in this case the vagina, to collect the fluids on the swab. Once that is removed, we take the glass slide and we rub the cotton tip across the glass slide to transfer cells from the Q-tip onto the smear, onto the slide, and thus creating a smear.
Thank you, sir. Then this is state 28. Again, I'm just going to show you the back. That has the sticker, then I'm going to flip it over. What is states 28?
That again would be the anorectal swab. Actually, this would be a glass slide, so that would be the smear.
And would that have been created in the same manner that you just described for the vaginal swab, smears?
Correct. So the swab would be inserted into the anorectal orifice, collect the fluid from that area, and then transfer it onto the smear, onto the glass slides.
Same question for states 29. I'm just showing the sticker there. What is states 29, just to be clear?
That would be the oral swab. Again, this would be the smear made from the oral swab.
So let's talk a little bit about the swabs. I'm going to start with states 25, which has been admitted into evidence. States 25, what is that?
It's marked oral swabbings B.
And then just for clarification, states 26, what are we looking at there?
This is marked oral swabbings A.
Dr. Falzon, I realize it's been a long time since this. I guess let me ask the question this way. Would you have collected two different sets of oral swabs back in 2001?
No.
What, if anything, can you attribute to the fact that two of those are labeled oral swabs and there is not one labeled vaginal swabs?
The swabs are collected during the course of the autopsy. As indicated in the report, I collected oral, anal, and vaginal swabs. Once the swabs are collected, as soon as they are removed, we take the swab tip and create the smear. So the swab is prepared, the smear is prepared, the smear is packaged. Because the swab is moist, if it is packaged right away, because of the moisture, mold grows on the tips of the cotton tips of the swabs. So the swabs have to be air dried prior to packaging. Every autopsy, the doctor has an assistant to help with the case. So the the swabs would be placed in a small cabinet marked with the name, and it would be marked oral, anal, and vaginal. And the technician would package those swabs once they have air dried and package and label those.
Was that common policy and procedure at the crime lab back in 2001?
It was.
Bear with me, Dr. Falzon. I did want to go back and ask a few more questions about the fact that Miss Baker had a broken hyoid bone, and you've described what that bone is. Can you talk just a little bit more about the hyoid bone in general in a young person like Miss Baker?
The hyoid bone, like I said, is a C-shaped bone that sits just above the voice box. Initially, the bone is a little bit pliable. Young people have softer bones. As we grow older, that bone starts to get more calcified and become more brittle. So in younger people, you're less likely to see fractures of the hyoid bone as opposed to older people. But again, in this case, there were fractures both on the right and the left-hand side of the hyoid bone.
And based on that observation and your knowledge of that part of the human anatomy, do you have an opinion as to the amount of force that would have been necessary to break that bone?
It was a significant amount of force.
And to follow up on that a little bit more, Dr. Falzon, you've described the ligature previously and the ligature marks on Miss Baker. Now, with the hyoid bone as well, do you have an opinion as to, and again, taking into account all of your observations from Miss Baker's autopsy, do you have an opinion as to the manner in which that strangulation with the ligature occurred?
Like I said earlier, the ligature encircled the entire neck. So it passed from behind, looped in the front, and then the ends of the ligature held on each side.
And anything about the existence of those defensive wounds on Miss Baker's left hand that we previously described, is that significant in any way as to your findings related to the ligature?
I wouldn't say to the ligature. It's more in relationship to the
stabbing. I understand. Dr. Falzon, those are all the questions I have for now. Mr. Cruz will have some questions, sir.
Mr. Cruz, cross-examination.
Thank you, May I move the podium, please?
You may, absolutely.
Thank you. Good morning, Dr. Falzon.
Morning.
My name is Attorney Ahmad Cruz. I have the privilege and honor of representing Mr. Edrick Faust. Do you recall you and I speaking previously? Okay. Would you agree with the statement that Ms. Baker had a height of approximately 69 inches and weighed 113 pounds?
Correct.
Is it fair to state that Ms. Baker's earlobes were each pierced with a stud type earring with a clear stone in each earlobe.
Correct.
Is it fair to say that Ms. Baker had blunt force trauma to the head?
Correct.
And you previously admitted that you took photographs of Ms. Baker's condition. Is that fair?
Correct.
I'd like to show you what would be marked as Defense Exhibit 5. May I approach?
Your Honor, I would ask that Mr. Cruz show me the exhibit before.
That's correct.
May I approach you?
Okay.
Is that photograph a fair and accurate depiction of Ms. Baker as you saw her?
Yes, it is.
Does that photograph, does that photograph appear to be altered in any way?
Not to my recollection. I can't say that I think it's an altered, no.
That's fair. Are those injuries consistent with the injuries that you witnessed on Ms. Baker?
They are.
Your Honor, I would move to admit Defense Exhibit 5 into evidence. May I approach Dr. Falzon? Dr. Falzon, you stated in your autopsy report that contusions also surround the anal region. Is that correct?
Correct.
And you identified the contusion as a 4.5 by 7 centimeter contusion that surrounds the anus. Is that accurate?
Correct.
I'd like to show you what would be marked as Defense Exhibit 6. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 6. May I approach the witness, Your Honor? Let the record reflect that I've provided Dr. Falzon with Defense Exhibit 6. Dr. Falzon, do you recognize those photographs?
Yes, you do.
Okay. Is it fair to describe that there are 2 photographs of Ms. Baker's anus and 1 photograph of Ms. Baker's upper body, chest to head?
Correct.
Would you agree that the contusions that surround the anus support that Ms. Baker was sexually assaulted anally?
Yes.
May I approach? Okay. Oh, here. Your Honor, I move to admit Defense Exhibit 6 into evidence. And I would like to publish Exhibit 6. And just to make sure we're clear, these are photos of her anus and her upper body. Is that right?
Correct.
The state spoke with you about the packaging on state's exhibit. May I see those exhibits? Are those exhibits still? On State's Exhibit 25 and State's Exhibit 26, and may I approach the witness, Your Honor? Just to refresh you on what those are. And you recognize these from direct examination, correct?
Correct.
You stated that the way that these are packaged, and please stop me at any time if I say it wrong, I just want to confirm that I heard you correctly, that you get a vaginal swab, you then make a smear out of it, but because mold may get on the swab if you leave it out, mold may get on the swab because it's wet, you leave it out to air dry, and then a technician would package it up later. Is that correct? Did I understand it correctly?
That's correct.
Okay. The question I have for you, does no one check the technician when he labels or she labels the items to ensure accuracy? I'd like to show you what has been marked as Defense Exhibit 9. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 9.
No objection, Your Honor.
May I approach you?
Go ahead. It's fine.
No, I won't be startled.
So I handed you the state's exhibit and I handed you Defense Exhibit 9. Would you agree that Defense Exhibit 9 is a close-up of the window depicted in State's Exhibit, I believe 27, if I'm not mistaken? I may have that number wrong. 47, please forgive me.
Yes, sir. You're correct.
And do you recognize that photo?
Yes, sir. It's the photograph showing the window adjacent to the rear entrance or exit, however you want to look at, to the apartment.
Yes, sir. Has that, to your knowledge, or would you have any reason to disagree that that photo has not been altered in any way?
I would agree.
Your Honor, I would move to admit Defense Exhibit 9 into evidence.
Any objection?
No objection, Judge.
Admitted.
Yes, ma'am. And I would ask for permission to publish Defense Exhibit 9 and State's Exhibit 47 to the jury. Thank you. I'd like to show you what is being marked as Defense Exhibit 10. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 10.
Absolutely.
Lieutenant Leadall, do you recognize Defense Exhibit 10?
I do.
Okay, and you recognize Defense Exhibit 10 as the back door that's depicted in State's Exhibit 47, is that correct?
Yes, sir, it is.
And it's just a closer up view of said door, is that right?
That's correct.
Would you have any reason to disagree that that photo has not been altered in any way?
Doesn't appear to be altered that I'm aware of.
Yes, sir. Is it a fair and accurate depiction of the back door as you remember it to be?
Yes, sir.
Your Honor, I would move to admit Defense Exhibit 10 into evidence and publish same to the jury.
No objection, Judge.
Court's indulgence, Your Honor. I'd like to show you what's been marked as State's Exhibit 71. Now, in regards to State's Exhibit 71, I believe we saw a prior photo of material from the ceiling that was on top of Ms. Baker and on top of that item there. Is that correct?
Yes, sir.
Okay. And just to make the record clear, the item that I'm speaking of is the power transformer. Where the power transformer is located, once that debris was moved, is that the place that you found the power transformer located?
Yes.
Okay. Your Honor, I would ask for permission to publish State's Exhibit 27 to members of the jury.
That was already admitted, correct?
It was.
Granted.
Thank you. And we've already established that on January 19th, 2001, you went to Ms. Baker's home and you had opportunity to view her body, correct? Do you agree?
Yes, sir.
In regards to the evidence located on and around Ms. Baker's body, there were hairs collected from Ms. Baker's left hand. Is that correct?
Yes, sir.
There were hairs collected from Ms. Baker's body. Is that right?
That's correct.
There was also a hair collected from Ms. Baker's buttocks. Is that right?
That's correct.
And I'm going to get you another pair of gloves.
No, I'm good.
Give me 1 second. Court's indulgence. All right, I'd like to show you what's been previously admitted as State's Exhibit 89, which contains a envelope enclosed, documented as item number 8, hair from buttocks. Do you recognize that?
Yes.
Okay. I'm going to hand you a pair of scissors. I would like for you to open item number 8. That was within State's Exhibit 89. And I provided you a paper towel for the hair.
Okay. There is no hair in it.
Can you repeat that?
There is no hair inside it.
Thank you.
I'm gonna place this back in the envelope where I cut it open.
I'd like to show you what's previously been admitted as State's Exhibit 88. Inside State 88, there's an there's an envelope marked number 9, hair from torso area of victim. Are you okay with opening this for me, sir?
Yes, sir. There's no hair inside here.
Can you repeat that for the jury, please?
There's no hair inside here.
Gunner, can I take a break for a second? Bathroom break if it's okay.
Yes, you can. Ladies and gentlemen, I'm going to ask you to go into the jury room for a couple of moments. Please don't discuss the case. Then go ahead, Ms. Cruz. Sure. Shirley, we have a box for you. Please be seated. Mr. Cruz, you have the floor.
Thank you, Your Honor. Lieutenant Liao, did you collect hairs and put them in those envelopes?
Yes,
Okay, so at one point in time, there would have been hair in those envelopes. Is that correct?
that's correct.
Thank you, sir. All right. I'd like to show you what's been previously admitted as State's Exhibit 90, which is hair from left hand of victim. And inside State's Exhibit 90 is a white envelope marked number 10 with a description of hair from left hand of victim. May I approach? Can you open this for me? Lieutenant Liedall is looking at that exhibit. I would like to mark empty envelope number 8, which is the envelope that was supposed to contain the hair from Ms. Baker's buttocks, as defense exhibit 11. Which I'll separate from State's, I think 27. Sorry, which I separated from State's 89.
Are you asking it to be readmitted, or are you just putting a defense number on the already admitted exhibit? You want it on the envelope?
Correct.
Okay, and it's number 11. All right. So, any objection, Mr. Yeoman-Chili?
I don't have an objection. I think the original larger envelope and its contents have already been admitted. However, I don't have any objection to
All right.
labeling the interior envelope.
I will admit it in that manner.
Yes, ma'am. Also, the envelope that was in State's Exhibit 88, which is the empty envelope containing, well, that would have contained hair from the torso of the victim. I am admitting this as defense exhibit 16, Your Honor.
All right, Mr. Yeoman-Chili, any response?
Just the same response, Your Honor.
All right, I will admit it. Okay, it has been, the whole package has been admitted as State's exhibit, but I will admit it as defense 16 in this manner without objection.
Lieutenant Liedall, can you tell me the number of hairs that were in State's Exhibit 90?
From this, none. There was 0 in here.
There are no hairs in State's Exhibit 90?
That's correct.
Did you put hairs in the envelope when you sealed it up?
Yes.
Your Honor, I would like to mark as defense exhibit 17, the empty envelope that would have contained the hair from the left hand of Miss Tara Baker.
Any objection, Mr. Yeoman-Chili?
No objection, Judge.
All right, I will admit it in the same manner as before without objection.
In regards to your observation of Miss Baker's home, is it fair to say that you determined that Miss Baker's front door was deadbolt locked before it was opened by firefighters?
It appears that way, yes.
You would agree that there were multiple bedrooms in Miss Baker's home, correct?
That's correct.
And they belonged to Miss Baker's roommates, Miss Ashley, at the time, Miss Ashley Peavy, now Mrs. Ashley Peavy Hall, and at the time, Miss Valerie Lowe, now Dr. Valerie, at the time, Miss Valerie Lang, now Dr. Valerie Lowe. Is that correct?
That's correct.
Based on your observations, none of the drawers in Miss Lang's room appeared to be disturbed.
That's correct.
Based on your observations, none of the drawers in Miss Peavy's room appeared to be disturbed.
That's correct.
Would you agree that Miss Lang and Miss Peavy had jury boxes, computers, and other accessories in plain view within the home?
That's correct. There was.
And of course, I'm sure we agree on this, none of those items were taken from the home.
That's correct.
You also had the opportunity to walk through the living room and the common area of the homes. Is that correct?
I did, yes.
Would you agree with the statement that nothing was stolen, that nothing appeared to be stolen from the living room or common area of the home?
I can't say that with any certainty since I don't live there and don't know what is actually there, but there were items still present.
Do you recall writing a report dated January 21st, 2001?
I do.
You have a copy of that report up there with you?
I do, yes.
Can you turn to page 3 of 11?
Okay.
Can you read the 4th sentence? And the first sentence ends in burglaries. So the first sentence you'll see is commonly removed in burglaries. Can you read the 3rd sentence from that period?
Some items have been moved after the fire, indicated from markings on the floor.
Read the sentence before that one.
The living room and common area of the residence contained furniture and a television/VCR.
And can you read the next sentence?
Nothing appeared to be disturbed prior to the fire.
Thank you. So it's fair to say that nothing appeared to be disturbed in the living room and common area.
That's correct.
Now, you also then had opportunity, and I believe I provided you with an exhibit, the state provided you with an exhibit as well, but we can agree that you had an opportunity to examine the window in the kitchen area, right?
Yes, sir, I did.
Now, you would agree that the blinds were down on both the window on the door as well as the window in the dining area?
Yes, sir, they were.
Thank you. And I believe you discussed this with the state, but during your examination of the home, you learned that several items had white marks. Is that right?
The door area, the front door near the peephole, and other areas, white marks probably from just general cleaning throughout the course of that door being there. I can't say when the white marks occurred, but there were marks there that were picked up when I put fingerprint powder to those surfaces.
So is it fair to say that we don't know if the white marks happened after Miss Baker's murder, nor do we know if the white marks happened before Miss Baker's murder?
That would be correct, yes.
And those white marks were present on the stove. Would you agree with that?
I don't recall if there was any on the stove.
Sure. Can you turn to page 9 of 11 of your January 21st, 2001 report, please? And if you will go to the second paragraph, in the 4th sentence from the bottom, that starts with in processing the front door. Can you read that, please?
In processing the front door, stove, and window sill, markings similar to one wipes the surface with a rag were found. The markings on the front of the door were consistent with a person looking out the peephole and placing left hand on the door. The white mark where the left hand would have been as well as along the door edge. White marks were also found on the window sill in the dining area.
Thank you. Now, when Miss Baker was found, you would agree that she was completely naked.
That's correct.
There were no clothes around her that were notated in your report. Is that right?
That's correct.
And a towel was not found near her body.
That's correct.
Your Honor, I don't have any more questions for Lieutenant Leadall. Thank you so much for your service. Those are my questions.
Any redirect, Mr. Yellowman-Chili?
Briefly, Judge, Lieutenant Leadall, as it relates to the hairs you collected, did you package those hairs?
I did.
Did you send them to the GBI?
Yes, sir, I did.
Okay. And that would have been for some kind of analysis or testing possibilities. Is that right?
That's correct.
Do you have any idea what the GBI did with them once they received them?
I do not.
Does not have any other questions for Lieutenant Leadall? Thank you.
Any recross, Mr. Cruz?
No, ma'am, but I do have a motion.
All right. Do you, all right.
Or we could approach, if you don't want to send the jury out, we could approach it.
All right. Okay, that's fine. I mean, I may do that anyway, but you come on up, that's fine. Yes, sir. All right, ladies and gentlemen, I'm going to send you into the jury room for just a few moments. Don't discuss the case. Be with you shortly. Thank you. You all may be seated. Thank you. All right, Mr. Cruz, your motion. Go ahead, sir.
I would just like to renew my motion in regards to, and I'll say motion to limine, to admission of testimony that the oral swab B is a vaginal swab. The additional information that I'm providing to the court is consistent with our prior argument that regarding the collection of that swabbing and the markings of that swabbing, and what Dr. Falzone testified to in regards to the procedure, as well as the supervision of making sure items are properly marked and properly identified. As the court saw, we just had, I believe it's 3 envelopes. One was supposed to contain, and was marked to contain, hair from Ms. Baker's hand. And we heard testimony from the Honorable Lieutenant Leadall that he collected it, he put it in the envelope. It is now missing. We also had a hair that was identified that was on Ms. Baker's butt that the Honorable Lieutenant Leadall stated that he put in the envelope. It is now missing. And we also heard about the hair, you also heard testimony about the hair that was on Ms. Baker's chest that the Honorable Lieutenant Leadall secured, packaged up. It is now missing. I would ask the Honorable Court to consider that in regards to our argument regarding the oral swabs. And 23 years later, the state is going to attempt to introduce testimony that these oral swabbings are now vaginal swabs. Thank you for hearing me out, Your Honor.
Thank you. Mr. Golden, Mr. Yellowman-Chili, any response?
Yes, Your Honor. I think Mr. Cruz is confusing the admissibility of the evidence versus the, I guess, the significance of it. It's hard to really understand. I would point out that we had the motion, motion in limine, whatever he characterized it as, when Dr. Falzone was on the stand. But then when I actually moved to tender the exhibit, there was no objection. So there's no contemporaneous objection to the admission of the evidence. I think, again,
Mr. Cruz, it's your motion. I'll let you respond when he's finished.
Yes, ma'am.
Respectfully to Mr. Cruz, I think he's misunderstanding the fact that there will be additional testimony about not only the items that Lieutenant Leadall just entered into evidence, but also those that Dr. Falzone entered. You know, you can't have one witness testify about everything as it relates to the piece of evidence. That's why you tender it and then have them testify. So I don't know what the grounds are that he's asking to move to exclude the exhibit relative to oral swabs A, but they're admitted into evidence, Your Honor.
All right, thank you. And thank you.
If I may, Your Honor, as I mentioned when I learned about the swabbings today, this is a motion that I brought up as this issue came to my attention. If the Honorable Court is willing, if we come in tomorrow, provide the Honorable Court with cases, and just to clear up Mr. Bowden's, if I misstated anything. So when it comes to chain of custody, the state has to establish an appropriate chain of custody before evidence is admitted. If not, if there's an issue with the chain of custody, and I provide the Honorable the Honorable Court with a case or cases regarding this issue, that evidence is to be excluded. We have a chain of custody log. And one of the biggest issues with the chain of custody log is the same way those items were packaged here today. They're the same way on the chain of custody log. And I said, well, maybe because it was improperly marked, they just put it in this way. But actually seeing the packages ourselves, and I should have opened it. I didn't even think about opening it to see if something's actually in the box. I would just ask the Honorable Court to allow us to have a hearing. I'll present the case law pursuant to chain of custody. I'll be able to present the chain of custody report to the Honorable Court. And the Honorable Court has already heard the testimony from Lieutenant Liedall about what he collected and what's missing. And I think it would be appropriate, if the Honorable Court finds that it is appropriate, to allow us to present that issue to you in regards to suppression of any future testimony that is now attempting to relabel swabs that have been documented as oral for 23 years to now say they are vaginal swabs.
Thank you.
Thank you, Your Honor.
All right, so I'm going to deny your motions, Mr. Cruz, and this is the reason for them. You are asking the court to kind of venture into the purview of the jury. There has, first of all, I agree with the state that the evidence you are complaining about with the doctor expert we had this morning was admitted into evidence. The issues that you're referring to right now with regard to any evidence that has been admitted with this witness goes to the weight of that evidence. And the argument you're making about about chain of custody is an argument that you are entitled to make to the jury if you choose to do that. But what you're arguing is the weight of the evidence. And so I'm going to deny your motion, Mr. Cruz.
Yes, ma'am.
All right, thank you.
One question for you, Your Honor.
Yes.
May I follow up with a couple of questions for Lieutenant Liedall, separate from our motion, but once the jury comes back out?
So hang on just a second. I'm trying to remember where we were before I sent the jury out. Did you finish your redirect?
Yes, Your Honor.
Okay.
I asked a single question, or
Okay.
single question, but 3 questions, I think.
Right, and I have not yet asked you if you had any recross. Is that correct?
He indicated he did not have recross and thanked Lieutenant Liedall for his service.
Okay, that's correct. All right, I'm going to deny your motion, Mr. Cruz. Can you bring the jury out, please? I do remember that now. Musical chairs. All right, you all may be seated. Thank you. All right, may Detective or Lieutenant Liedall be excused?
We'd ask that he is, Judge.
Any objection from the defense?
I have him under subpoena. I would just ask that he's subject to recall. I spoke to Lieutenant Liedall. He explained to me his schedule.
Okay.
The Honorable Court will allow, if we have the opportunity to call Lieutenant Liedall back, we would just ask if he would prefer that we allow him to do it via WebEx.
I can add to that, Your Honor.
Okay.
I have no objection to returning back. I would just need enough notice because I live 30 minutes away.
Sure.
And I'm also possibly testifying sometime next week in DeKalb County in a state court case, and I don't know the exact date. So other than that, I'm free and able to come at any time.
Thank you, sir. So the answer to your question, Mr. Cruz, is yes and yes. So Lieutenant Liddell, you are still on call. You're still under subpoena, and I'll let you work it out with your witness. If you need to ask the court for permission for a video testimony, I've already told you that you can do that. And so I'll leave that to you to just let the court know whether that's necessary. Other than that, you are free to go, sir.
Thank you, Your Honor.
Okay, Your Honor, may I step out to obtain
Yes.
information?
Yes.
Thank you.
All right, Mr. Yalman-Chile, Mr. Bolden, you may call your next witness. You may. All right. Do you have any problems with that? Is that very much? Ladies and gentlemen, we are going to call a next witness, but I'm going to break today at 5 o'clock. So we're going to get through as much as we can with this next witness, and then I'm going to send you home. So I just wanted you to kind of know the plan. All right, Mr. Yalman-Chile, you may call your next witness.
State calls Brian Grove.
Could you get Brian Grove, please?
Sir, if you would, please raise your right hand and take an oath. Do you swear or affirm the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you could, please have a seat and state and spell your name for the record.
Brian Grove, Grove.
And Mr. Grove, where are you currently employed?
I'm a fire protection engineer with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF.
And how long have you been working for the ATF?
About 26 years.
All right. And if you give me just a moment, my computer's not exactly cooperating with me.
And
And if you could, please describe your work experience with the ATF.
I'm a fire protection engineer, so my job is to help ATF certified fire investigators with the science part of their investigations.
What's the, well, you already talked about the role of a fire protection engineer at ATF. What is the field of fire dynamics?
So fire dynamics is the science of fire, kind of the physics of fire, how fires start, how they spread, how buildings interact with fire, how people interact with fire, anything really dealing with the physics or the science of fire.
And how does your expertise assist fire investigators?
So fire investigators are asked to figure out where a fire started, and then if they can do that, how a fire started. So we get involved with those processes, as well as timeline and some other things.
And so if we could, starting with your undergraduate degree, do you mind going through your educational background?
Sure. I have an undergrad degree, Bachelor's of Science in Fire Protection Engineering from the University of Maryland, as well as a Master of Science, also in the same field from the University of Maryland.
And besides those degrees, do you have any licenses or certifications?
I do.
And what are those?
I'm a registered professional engineer in the state of California.
And what's required to obtain that designation as a registered professional engineer?
So typically you need a 4-year degree from an accredited university, as well as 2 years of work experience under another registered professional engineer. And then you also have to sit for an 8-hour exam that all engineers would take, and then another 8-hour exam that's specific to your discipline.
Have you ever been a part of any kind of presentations or written any publications?
Yes.
Okay. And approximately how many presentations and publications have you been a part of?
Publications, probably about 10. Presentations, hundreds.
Have you done any teaching in the field?
Yes.
All right. And what topics have you taught on, and approximately how many times have you taught?
So we teach state and local fire investigators, as well as our fire investigators. Those are generally who we teach. Also attorneys sometimes, just on the sort of the science of fire.
And how many cases approximately have you worked involving fire dynamics?
I've been with ATF for about 26 years, say 20 cases a year, so over 500.
And have you previously testified as an expert witness?
I have.
And in what field have you been qualified as an expert previously?
As a fire protection engineer.
And approximately how many times have you testified as an expert as a fire protection engineer?
Over 20.
Okay. Judge, at this point, I don't know if Mr. Cruz would like to voir dire the witness at all.
All right, Mr. Cruz, if you'd like to, you may go ahead.
No questions.
All right, thank you. Mr. Elmichley, go ahead.
Judge, I would move to admit Mr. Grove as an expert in fire protection engineering.
Mr. Cruz, any objection?
No, ma'am.
All right, thank you. This witness is an expert in the area of fire protection engineering.
And Your Honor, would you like me to continue or?
We have 15 minutes. I'm going to ask you to actually continue. I think it's, we talked about stopping now, but it's only 4:45, so we have 15 minutes.
Okay,
Thank
and
you,
I
sir.
have
Thank
some
you.
more questions
All
before
right.
we reach that point.
Yes, sir.
How did you get involved in this case?
Special Agent Will Purdue reached out to me and told me about the case.
All right. And what was requested of you when you were contacted about the case?
He gave me a brief overview of his knowledge of the case, sent me some photos of the scene, a couple of reports, a diagram, and then we talked about ways that maybe we could help with the timeline of the fire, as well as there was an issue of some burn material around the stove and whether or not it'd be possible to ignite textile materials on a stove.
Okay. What is the fire triangle?
So the fire triangle is a way for fire investigators or scientists to organize their thoughts in terms of what do you need to have a flame or fire. And there's 3 things, 3 legs of a triangle. One would be fuel in its vapor or gas phase. So this would be solid, but we're talking about like a gas phase. Another would be an oxidizer, which is typically oxygen and air. So we need air to have fire. And then lastly would be heat. Initially that heat might come from a lighter, and then at some point a fire supplies its own heat and you have a self-sustaining reaction.
Okay. What is a fuel limited fire?
So a fuel limited fire would be a fire that's limited only by the amount of fuel that can be vaporized. So if you think of a campfire outside, that's a fuel limited fire.
Okay. And what is a ventilation limited fire?
So a ventilation limited fire, at some point, if you take that campfire, let's say a couch, maybe you burn the couch outside, it's a fuel limited fire. You bring that couch inside and it gets large enough and it's burned for long enough time that it consumes the oxygen in the room, and then ventilation becomes the dominant factor in the size of the fire.
Well, and that kind of dovetails perfectly with my next question. What is a ventilation limited fire?
So a ventilation limited fire, the size of the fire is dictated by how much fresh air you can get to the fire. All fires start out fuel limited in a room, and then at some point they typically transition, and they'll go out unless you open a door or a window fails or something like that to allow fresh air into the space.
Okay. And if you could, would you describe the term heat release rate?
So heat release rate is a term that we use.
I'm sorry, your objection is to foundation?
Yes.
And can you elaborate on that objection?
Prior to his questions, the witness did not make any testimony about any term that
All right, thank you. Any response, Mr. Yellowman-Chili?
I'm not sure exactly how to respond to that, Your Honor. I'm not sure that Mr. Grove could have just, without my having asked a question, started explaining these topics, but it's certainly a foundation based on his knowledge, training, and experience has been laid for him to describe these topics, since he's an expert that's taught extensively in the field of fire dynamics and engineering.
I'm going to overrule the objection. You may continue.
Okay. Could you please describe the term heat release rate?
Heat release rate is the power of a fire, the intensity of a fire. Really, we're looking at size. So if you think of like a 60-watt light bulb or a 100-watt light bulb, that's the power of that light bulb. We're interested in the same units for fire, but rather than dealing in watts, we're dealing in thousands of watts, kilowatts, or megawatts, millions of watts.
Okay. Is part of your preparation for testimony after your work on this case, did you create a PowerPoint in order to facilitate a discussion of the
Overruled. You may continue.
Did you create a PowerPoint in order to facilitate your testimony as a demonstrative aid?
I did.
Okay. All right.
Your Honor, before admission of the PowerPoint, can I have opportunity to review same?
Yes.
Or publication, forgive me, before it's
Okay.
published to the jury.
Well, can I see both counsel at the bench real quick? Thank you. All right, thank you. All right, ladies and gentlemen, we have decided this is actually a good stopping point, even though I was trying to make use of every single minute before 5 o'clock. I'm going to release you all to go home and come back tomorrow morning at 9 o'clock as scheduled. I want to tell you a few things. Obviously, the same instructions apply. I'm going to continue repeating those. It's important. Please don't discuss the case, of course, with anyone. Please don't do any research or go to any of the locations that you may have heard about. Don't go on the internet, of course, and do any independent research or study about anything you may have heard in court. I do want to talk a little bit about comings and goings of the courthouse. We haven't really talked about that. I really appreciate everybody wearing your juror badge. So certainly it is very important that when you get out of your car to come into the courthouse, that you're wearing that. It's very important that everyone in the courthouse knows that you are a juror in a case and that no one can talk to you about the case. So it's very important to keep wearing those. Thank you very much. When you come in the morning for your 9 o'clock hour, please come directly to this courtroom, and we're going to have you go into the jury room. As there are snacks in there and drinks, and Mr. Terrell makes great coffee, and so there'll be coffee in there for you. But please come straight to the courtroom. Every day that you leave, you're going to be escorted on the elevator by a deputy. And so as soon as I release all of you, if you'll go out into the hallway, there will be a deputy there waiting to escort you to the elevator. Deputy will ride down with you, and then you can go to your cars. And that's kind of the process we're going to use. Does anybody have any questions or anything they need to tell the court before we go? Very good. Thank you for your service today. I'm going to release all of you. See you tomorrow morning at 9 o'clock. Thank you. Everybody going? Everyone may be seated. Thank you. Just going to wait for that door to shut. Thank you very much. All right, counsel, we've discussed at the bench. You're sharing whatever demonstrative aid that you have. I appreciate your willingness to go ahead and do that with Mr. Cruz. So you all may take whatever time you need to do that. Is there anything else we need to take up before tomorrow?
Yes, ma'am.
Go ahead.
We have a little bit of time after court. Since these exhibits are admitted into evidence, can me and Attorney Hill and the state, if they would like, open them to see if what they're labeled as is actually inside of those packages?
Tell me exactly what you're referring to, Mr. Cruz.
So may I, Your Honor?
Sure.
The items here, the state exhibits, this is here, but the smaller items,
Judge, I'm sorry to interrupt, but is it okay if Mr. Grove leaves?
Yes, sorry, sure. We will see you tomorrow. You're still under subpoena. Thank you, sir.
Thank you.
All right, go ahead, Mr. Cruz. I'm sorry. Oh, okay. No, that's fine. I mean, that's absolutely.
So these items here, I'm just asking if we could just take time, since court is concluded today, just to open them up and see what's in them. Typically, we do it at closing. Typically, during closing, whatever exhibits are admitted, we'll open them. But in case I have any motions, Your Honor, is it okay if I spend time looking at these exhibits today, just opening them and making sure what they're labeled as and what they're identified as is actually in the package?
Mr. Yellen, do you care to respond to that request?
Yes, I think it would be inappropriate to open anything that's been admitted into evidence without the jury present here as part of the proceedings or with the witness at the time that the evidence is tendered.
I mean, I think that's the law, Mr. Cruz. I don't, you can't do that outside the presence of the jury. I don't know. I guess one of the things I wanted to ask you, Mr. Yellowman Chili, these have been admitted into evidence, but are you, well, I'll just say it this way also. One of the reasons for the law to be the way it is the state is entitled, since they have the burden and they've admitted those items, to open, if they choose, those items with another witness. I have no idea whether the state is, planning on doing that or not, but that's one of the reasons for the rule. So I would say no to your question. All right. Anything else, Mr. Cruz?
No, ma'am. I
Okay.
just look at the
All right. Mr. Yamachili, Mr. Bolden, anything else we need to take up before I release everybody?
No, Your Honor.
All right, very good. I will see you all tomorrow morning at 9 o'clock. And Mr. Cruz, Ms. Welch is going to come on up and I'll have her speak with you about a place for you to store all your items.
Thank you.
All right, thank you. Court is adjourned.
Hey, Mr. Cruz. So obviously when Harris sent to the GBI, they put it
True crime just got darker. Catch the full episode on the link above. Subscribe to At Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m.